to Knoxville, don't be late. Baker's Live, it's gonna be great. June 5th and 6th, mark your date at Dollywood, we'll celebrate. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. Rides fun and meet and greet. Baker and pals, the crew's so sweet. Get ready for laughs, cheers, and thrills. Knoxville's the place, it's giving chills. Meet Baker and more cool friends. Live show magic that never ends. Come to Dollywood, feel the vibe. With great people there, it's gonna be a ride. June 5th and 6th, don't miss the fun. Meet Baker and friends, it's second to none. Baker and friends, it's second to
Hey everyone, and welcome to OnlyFan, where me and Valhalla will take you through the pain that is another Karen Reed hearing where Bev will lose her mind again, maybe?
Probably. Let's be honest.
Most likely.
What's up, everybody? How's the day going?
Hey, Dr. Bull Butter.
I've learned two things this week.
Oh.
One of which is Bev overreacted to
yes.
the false information. The other is that she has no idea what metadata is.
No, and she denied them the metadata, even though she in a previous motion have said they should have all the metadata.
And they should.
I'm thinking Bev doesn't understand her own trial. Hanky Panky haven't watched a second of it, even though he at the last meeting he claimed, I read the transcript. I never read the transcripts.
That dude, he just projects dishonesty, in my opinion. That guy is as slimy as they come.
Yeah, he's a typical slimy defense lawyer. He's the one we're always sitting here when we see someone with a little funny. He's kind of like the guy from the bike rider who shot a lawyer. What's his name?
I don't remember that. Chris Cuomo.
Oh, he was.
How dare you?
He was the guy who stole the closing arguments from the OJ trial.
I have no idea.
Mo covered the trial Saturday, and he was the one whose paralegal got to be a witness where Judge Borowski just lost his mind. He was wonderful. But I love that Bev rules against her own rulings. It's just wonderful. It's the only way it can be is a Bevinism. Did I rule that? And she doesn't care. She really doesn't care. Big Dog says, starting off early, helping this swear jar in advance. Big Dog, you're going right in the jar.
Big Dog's awesome. Do you think it's she doesn't know or can't remember? Or do you think she's intentionally trying to make things complicated?
I have said it because everyone flipped out and
myself included. I thought when she wigged out last week, I thought there had to have been something bigger than what she was talking about. And then after she filed her decision or whatever, I was like, oh no, she's just an idiot. Zach, hashtag hash browns are better than hash marks. Agreed. Thanks, buddy.
Well, I have my Christmas shirt on, so I don't want to ruin my hairdo. But I said it. I think I said it to Jemima. Said I don't get why she doesn't have like a cheat sheet. She must have a paralegal who can give her. Okay, today we are ruling on these motions. Go back, check. Do we have anything pertaining to them before?
Well, that's the killer about this thing, right? It's like she doesn't decide anything in court. She always waits and then makes her decisions after the fact. So you'd think she'd be a little more on top of things.
Yeah, it was clear, and she stated it when she came back. Said the new information I just got from the Commonwealth, and then he went up there and said, "Whoops, I might just have lied in open court." And then
turns out it wasn't the feds; it was actually the defense team that gave me the information that you're mad at the defense team for hiding right now.
Yeah. My guess is she emotionally ruled on those motions. She was still peed and just denied everything. Yes.
Yeah. Yeah, I liked your video last week, like an hour after court got done, where you pulled up in voir dire, Dr. Wolf saying exactly what Hank was accusing them of trying to hide. Like, you're an idiot, Hank. You're dishonest.
Yeah,
is what it is.
But again, she is the one leading this trial, and she doesn't even understand that she have sat through the voir dire. She sat through the testimony. She even said what they could talk about and couldn't talk about, and then she claimed that Janetti never told him her. And she said, "Well, we couldn't talk to them about it because you shackled our hands and feet." That's such a stupid thing. Yeah, and the way she always lets the state filibuster. Yeah, it's and him last week. Oh, you're just doing this for the camera. You're doing this for the press. Who's the guy who stood up there and slammed the table?
Literally.
Yeah. It's so stupid.
I can't believe she hasn't with the Mark Bettero thing. That still kills me too.
Well, there wasn't a sufficient affidavit. There's never affidavits attached to anything Hank files, and it's never denied on basis that he didn't. Did you see that they're going to put in a a guy who looks at the weather, meteorologist, and is going to tell you, yeah, the ground was hard. He has no medical. He can't testify if the ground could make those injuries, because she has a ruling saying you need to be a medical
There's no way
doctor.
you could pinpoint the exact hardness of 34 Fairview's front lawn at that time. Like, you can get a guesstimate, but there's no way it could be completely accurate or even testable.
You are unmuted.
No.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves starting with the Commonwealth?
Good morning, Your Honor. Laura McLaughlin for the Commonwealth.
Good morning, Ms. McLaughlin.
Let's see how this
Good
plays
morning,
out.
Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Ms. Giannetti. Good morning, Ms. Reed. All right, so last week, upon hearing of a previously undisclosed relationship, perhaps, between defense counsel and the ARCA witnesses, I took a recess here. We suspended. I had heard about email communication, detailed communication, memorializing a conversation regarding an engagement letter and a promise of retainer on March 20th and 22nd of last year, roughly 2 months before the ARCA witnesses testified.
But after they filed their
There's another
findings,
email that was 2 days before the trial and after the voir dire, 2 days before the trial with a list of cases. The Sunday before the witness testified, there's a proposed script of questions and answers and suggestions. And after the trial, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ARCA
She's still
witnesses were
shaky.
expecting to get paid.
Yeah.
So the Commonwealth, so I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each other, to look at transcripts, to consult with people, and that it made sense to give you some time to do all of that, because what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So it made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to
it
do that,
wasn't.
I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Ms. Giannetti, where I raised my skepticism about defense counsel in a murder case calling not 1, but potentially 3 witnesses that you never talked to. I looked back at the June 18th voir dire hearing, the June 24th trial testimony of the ARCA witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that, but what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last
Citing
June,
something that we didn't hear.
outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying pursuant to Rule 14, and you know, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So we will mark that as an exhibit. And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense counsel.
Your Honor, thank you for the opportunity to be heard. I am going to be responding on behalf of defense counsel
Okay.
to all of your concerns. I have
I like him.
a notebook that I've given, albeit just now, to Mr. Brennan. It's got exhibits, but it's everything that everybody's already had. It's similar to what you're doing, transcripts, documents, probative issues. And if, with your Honor's permission, I'd like to provide you with the notebook so that you can follow.
That'd be great.
This is Alessi, the latest addition. He is more the technical guy, and he is the only guy on the defense team that she smiles when he says good morning to her.
And should I hand it to someone here to have it handed you, bring it up?
A court officer will take it for you.
Okay,
I appreciate that, Mr. Alessi.
you're welcome.
Thank you.
Here's another notebook to follow along. And with that, Your Honor, I'm going to go to the podium and make my presentation.
Is she going to cut him off again?
I'm sure.
You know what, actually, I'm going to take 5 minutes to just quickly go through this.
That would be excellent. Thank you, Your Honor.
Back to OnlyFans.
Mr. McDermott? Mr. McDermott, first of all, good morning.
Turn off the audio. So
Thank you.
she got mad that they lied to her at sidebar, even though there's nothing suggesting that they lied to her at sidebar.
Right.
Because-
she cited something that nobody's ever heard before except for her and the lawyers, apparently.
Yeah, because it was a sidebar, and all of her sidebars are kept under wraps. But her reason to suspend the meeting was because Brennan hadn't gotten the evidence from the defense, even though he then changed it and said, I got it from the defense. And then she had to reflect over her memory, and it was pretty good. Then she should have said, oops, I'm sorry, because as we all know, Yannetti disclosed that they had reached out to them. There was a court order. They couldn't talk to them. And the proposed script, he also talked about. He said, we talked about the CV and the findings. He said that at the voir dire and in open court. Lally questioned them about the same things that she now claims they didn't disclose.
Yeah, it sounds to me like she's trying to cover her butt. She realized that she freaked out on national streaming, whatever you want to call it, television, whatever, and is trying to save face a little bit. That's how it's coming across to me.
We don't know what actually was said and in what context it was said.
So
But
it
it
sounded
seems
to me like the sidebar thing. It sounded to me like the state, the Commonwealth, had given her false information, and she was mad at Yannetti for not clarifying things. Apparently, she used the word disabuse.
Hey, Hellfish.
Hey, Hellfish.
No, because she still threatened the defense. I don't know what may flow from this. It
Shouldn't be anything. Nothing should come out of this. This is all BS. There's nothing different. She didn't catch them in this conspiracy. Like,
no, and again, what she really should be doing is saying, well, and I rewatched the transcript of the last hearing, and I understand that Hank changed his testimony from before I took my break until after, so I might have been a little rash suspending the meeting, but she didn't do that because he will face no trouble.
She should have absolutely given the defense to at least say something last hearing, right? She just canceled it and was like, you got to be here next week, blah, blah, blah. She should have given them the chance to respond right then, and at least it likely would have been clarified, and then they could have recessed and nobody would have been freaking out for the last week.
I know.
She should also yell at Hank a little bit here, but we all know that's not going to happen.
Yeah. Yeah, and she sounded flustered or angry or whatever. But still, she clearly overreacted.
Clearly.
Especially, and I can't wait for Alessi to go through the timeline. I believe it's a great choice not to have either Jackson or Yannetti talk to her now, because she just hates them. They won't get anything done if they talk to her.
No, Alessi's a good choice here.
Yeah.
They're right out there. They're right out there.
Well, that's
You are
she
unmuted.
didn't say that she believed that. She said that Yannetti had said she did nothing wrong.
Right?
We've been back for a long time. I think Marissa is a little drunk today. She's been fighting a goose.
A goose? Geese are
Yeah.
mean.
She has
All
a
right,
goose
so I
in her
apologize
house.
if that wasn't quite 5 minutes. I just wanted to see what it was that you had there.
Are you comfortable with what's in the notebook?
Yes, if I haven't read everything, but I know what each of them are.
Table of contents.
Yes.
Good, okay.
Somebody, I think Runkle was saying that he's a boxer, Alessi. Or Runkle's chat, I think.
Oh,
May I proceed, Your Honor?
Sure.
Thank you. May it please the court. I understand the moment. The moment has categories and components. And in my presentation today, Your Honor, I am going to go through those categories in this order. I am going to start with the notebook that I handed to Your Honor and to Mr. Brennan this morning. The notebook is purposefully in chronological order. The notebook is in chronological order because I believe the best explication of the facts and what those facts mean come from a proper chronological presentation of
Oh, he's
facts.
mad.
I also believe that the chronology is going to address many, if not all of the concerns as I understand from Your Honor. Your Honor, of course, will be the ultimate arbiter if they successfully address
He's so
those
mad.
concerns.
I'll just say, normally when they stand at the podium, we can hear him. I have my booster at 10 times normal boost.
It looks like the
But
mic's
my
way off to the
intention,
side.
Your Honor, is not to obfuscate, not to conflate issues. To the contrary, my intention is going to be to elucidate and to illuminate so that Your Honor can make the proper determination. That is my genuine goal for my presentation. As I go through, and I know I don't have to say this to Your Honor,
Oh, yeah.
you can feel free to interrupt, pressure test me on anything I'm going to say.
Oh, he's prepared.
I would welcome it, but I believe if I can get through the chronology, my hope is that the facts will speak for themselves. But that brings me to my second component of understanding the moment, which is going to be to also add to the fact is what happened at the last hearing, on February 18th.
Oh, he's going
And
to
I have
dog
the
Hank.
transcript for that, and I have that in the notebook, because I believe that is also critical to the proper elucidation of the facts.
So that's the only thing I have not previously seen.
The February 18th transcript.
Yes.
There are 9 pages that I'm going to go through, Your Honor, and because of the stakes here, I am going to go through it hopefully efficaciously and efficiently, but it's going to have to be methodically.
All right, so are you were addressing this in chronological order as well, right? So if you
He
can
said
tell
that
me
right.
those pages now, I'll likely recess because I do want to see them before you talk about them, but I'll hear you going up to that point. So
You
what
just
pages are
recessed and
those?
said you
Can
didn't
refer,
know it
Your Honor,
now.
to the February 18th transcript?
Yes,
Yes,
your
I will
number,
tell you exact
8.
pages that I'm going to refer to. And Your
He's
Honor,
so hot. He's so mad.
get to this is tab 8
Right.
of the notebook. And specific pages that I'm going to reference start on page 53.
Okay.
And those are 9 pages that proceed all the way to really the substance ends on page 62.
Okay.
And I appreciate that Your Honor wants to take a look at them because I think it's incredibly important for putting in context what happened at that last hearing. And I think it helps also do a compare and contrast to what the actual facts are and to what the statements were that were made on the 18th. So am I understanding, Your Honor, that you would like me to
You
suspend my
can,
brief or keep going?
no, you can keep
Okay.
going and we'll stop so I can read whatever I think I need to read
Sure.
at certain points, but we should be good to at least start.
Thank
Yeah, I think Brennan really kicked the bee's nest, whatever
Yeah.
beehive. They want to punish him in front of the cameras, even though Bev won't punish him.
you.
I have a feeling he's about to.
And can I just ask, when was this put together?
Started about a day and a half ago and was completed this morning.
Okay. All right.
He's
Go
so
right
mad.
ahead, Mr. Blessing.
Thank you, Your Honor. So I start with tab 1,
I love
which is the March 22nd, or excuse me, go to the bottom, please, the March 20, 2024 email. And this is an email between Mr. Jackson and Mr. Wolf. It was sent from Mr. Jackson to Mr. Wolf. It was entitled Engagement. And so what I'm going to do is, that's where the notebook starts.
This has to do with, did the defense lie to the court?
But I want to go backwards to start in terms of something that is well known. And that is the federal investigation and the products of that federal investigation produced the ARCA report. And that was in February of 2024. So what preceded this communication
Because then she would say, why didn't you send it so I could prepare?
was a production of materials from the federal government, about 3,000 pages. Contained in that 3,000 pages was the ARCA report of February of 2024. There was no index of the 3,000 pages, and the defense came upon that report. They got to reviewing the documents in March of 2024. And as Your Honor will recall, the trial 1 started in April of 2024. So it was pretty close to when that trial started. And I know Your Honor knows from both your judicial experience and other experience that when you're entering into a trial of this significance, there's a lot going on. And so what happens is that report's produced in amongst 3,000 pages, it is located, it is read, the significance of it is immediately discerned. The report, basically the findings of the report that the vehicle, and this is important, Your Honor, because it really informs a lot of the emails. The substance of the report speaks to the issue of whether or not the motor vehicle of Miss Reed made contact at all with the decedent, and whether the decedent's injuries at all reflect a contact with that report. Those findings in that report was set in cement in February of 2024. What do I mean set in cement? It means they were never changed, nor could they be changed. So that report was provided to the Commonwealth and to the defense. Next step, important also. Any party, the Commonwealth or defense, had access to ARCA. They had the opportunity to contact ARCA. There were restrictions that I'm going to get to on that contact. But either party had the opportunity to contact them. Now, only the Commonwealth knows why they didn't take that opportunity. It may be because of the findings. It may be for other reasons. I don't know. But I understand the facts to be that the Commonwealth didn't make contact with the ARCA experts. The defense surely did. So that is the background. That is the information that we have. And so what happens? The defense sees the report, sees that the information in it is completely exculpatory to Ms. Reed. Of course, any attorney, lest they want to risk malpractice, is going to make a communication with that expert, which was perfectly legal and perfectly contemplated by the rules of the road, if you will. Now, as Your Honor also knows, the rules of the road with regard to the ARCA expert were not set by this court. They were set by the U.S. Attorney's Office. And I'm importantly going to articulate with objective evidence what those rules of the road were. But the one key point is those rules were not set by this court. So the contact was made. This is one of the most unusual situations I've ever seen in my practice of law, meaning you have these experts, you have great exculpatory information, but there are significant constraints on how it is you can interact and utilize those experts in a complete unorthodox situation. Why do I emphasize that? I emphasize that because lawyers in trial practice are used to doing things a certain way. And when there are certain constraints that are imposed upon them, it becomes more sui generis, more ad hoc. And then there has to be sort of new ways of addressing the situation. That now brings me with that important background to tab 1. And to repeat, the communications start with a report from the ARCA experts and their findings and their conclusions that never changed. They never changed from the report they generated until the first communication in tab 1. It may seem self-evident, but given the moment, I'm not going to take anything as self-evident. The defense had zero input into the report and therefore had zero input into the findings. And in fairness to the Commonwealth, nor did the Commonwealth. So with that, we come to the emails on tab 1. March 20, Mr. Jackson to Mr. Wolf. Please note that there is no CC to Mr. Yannetti. Why is that important? When we get to Massachusetts Professional Rule of Conduct 3.3A1, that fact is going to become extraordinarily important. So we have a communication, and it needs to be read in its entirety. Fortunately, it's short. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. I will get that countersigned and returned to you forthwith, along with your retainer, as required. I have the good fortune of dealing with experts probably every week. And this is classic form parlance. If it's going to be required, you always hope for your client that they're not going to require a retainer. But the language is as required, as. Also, if you could attach a copy of your, Dr. Rentschler's, and Mr. Klein's CV, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. At that particular point in time, there was no conclusion, no agreement, no knowledge that these folks would actually be testifying. There was certainly the hope, there was certainly the desire, but there was no agreement that they were going to be testifying. That was the
Was the federal protective order that was referenced by Ms. Giannetti that said it was specifically outlined and ruled that they could not prep with us for trial. Was that in effect at the time these emails were sent?
The answer is, Your Honor, and I'm going to get to it, but I want to answer your question directly.
I'd like you to answer my question.
Yeah, no, I wanted to say, I'm going to answer it directly. What Mr. Yannetti articulated as the rule of the road, not prep, was not a rule of the road. That wasn't the rule of the road, and I have objective proof of that. The rule of the road was there would be no substantive conversations with the ARCA experts, okay? That was it. But the answer to your question is I do not know whether the ground rules were in effect, but I can get you that answer, and I will get you that answer hopefully in moments during my presentation, but I do not know the answer.
All right, go ahead.
And it's an important question, and it's an important answer, I understand.
It's an important
But
question,
I'm going to
I don't
give you
have it.
information that's going to indirectly answer that question, but I'm going to get you a direct answer as well. So you see that there's an attempt to iron out the logistics for your preparation in the trial. Then we get to the email up above, and that is merely 2 days later. Again, Mr. Yannetti is not copied on the email, and my understanding is Mr. Yannetti is not knowledgeable about these communications. So,
Are they preparing to throw Alan Jackson under the bus if there's any sanctions that can only hit him? Since they're mentioning that constantly, that Yannetti doesn't know about it.
I mean, I guess if he's going to fall on
Yeah,
his
the email-
sword, that would make
Yeah.
sense. But I can't imagine they would have to after the end of all this.
Yeah, I don't know how.
reads, hi, Alan. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when we have it. Your Honor, this is not a direct answer to your question, but this is, to me, going to corroborate my point that if there was an agreement and if they were going to be testifying, subject to whatever constraint, this email would not have been sent. There would not be a pause until we receive additional regarding our involvement moving forward. The involvement is clearly inchoate at that point. Why would Mr. Wolf be saying, until we receive additional information from their
Dr.
office, the
Wolf.
U.S. Attorney, regarding our involvement? This is just talking about mere involvement. So what happens is I call this the pause email, and it's regarding engagement. So Mr. Jackson on the 20th tried to get matters started. He's communicating to see if ARCA's willing, if they're ready, if they're able, etc. And then we have the pause. The next tab is tab 2, which is the very important June 10, 2024 excerpt of the transcript. But the time in between, Your Honor, the March 22nd pause email and the 6/10/24 transcript is also exceedingly important. What happened between that? Well, to state the obvious, the trial had started. The trial started in April. Mr. Yannetti gave the opening argument for the trial. Do you recall, Your Honor, that Mr. Yannetti never mentioned the ARCA experts in his opening?
I did not review the openings. I reviewed only, for the non-evidentiary transcripts I reviewed, was only Mr. Jackson's closing argument.
Certainly fair enough, Your Honor. Why do I underscore this point? Mr. Yannetti did not even mention the ARCA experts because the defense didn't even know if they would be testifying. The two most powerful witnesses in support of the
I'm sorry, what was the date of the openings?
I do not know. I do not have it. It was in April. We can hopefully get that.
I can find it. I didn't know if you had it.
So, but clearly, Your Honor, it was between March 22nd and June 10th.
Right.
And so the most powerful exculpatory information from what we consider some of the most powerful witnesses were not mentioned because the defense didn't even know if they would be testifying. If there was an agreement that they would testify, that would have been in the opening. But the uncertainty about it is the reason why it wasn't in the opening. We didn't know what would be happening. So that pause continued through the opening. That to me is so key because I think it's antithetical to an agreement. Now we come to the June 10 transcript. And as I said, I am going to hit head on these areas.
Head on.
I start with, Your Honor, something that's not in the excerpts, but Your Honor may recall that there were a lot of Rule 14 discussions. And Your Honor, and Mr. Brennan read this on February 18th at the hearing we just had, that Your Honor was making the point, which I appreciated, that with this very unorthodox situation, the defense was exclaiming, you were saying, I think you're in violation of Rule 14. They said, we've given everything we've got. We don't have anything more. Well, I know you can't, but you're still in violation. So Your Honor fashioned a remedy.
Thank you, JBH.
Your Honor fashioned the remedy, the Rule 14 remedy, that there was going to be a voir dire. And that the ARCA witnesses were going to have to come up from Pennsylvania and they were going to need to sit for a voir dire. I will get to the significance of that, but that's what started, is the predicate for the discussion I'm now going to focus on. It starts on, this is tab 2, page 2812. Line 5, the court. Now, regarding the 3 experts from ARCA, so I've read that report. I can't tell who does what or what the basis of their opinion is. So what have you provided? You're referring to the defense, of course. Mr. Yannetti, Your Honor, we've provided everything that we know. We mentioned to this court at sidebar, these experts did not arise from us finding them. The court, I understand that. Mr. Yannetti, these experts were hired by the federal government and they provided a report to us pursuant to the TUI request. And it was specifically outlined and ruled that they could not prep with us for trial. Court, and it's important not to stop there with what Mr. Yannetti said. There's more to that statement. There's an elaboration of it that is important. The court, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. And I want to key into your words, Your Honor, because I want to be fair and precise. Your question
That's exactly what I said.
Pardon me?
That's exactly what I said.
Yes, and I want to key in on you've never spoken, right, to and putting them on the stand. Now, no one ever said from the defense they never spoke to them, but that was what Your Honor was concluding from what was stated. So what did Mr. Yannetti do in elaborating on his answer? I didn't go back to the video to see if there was sometimes two people speak at the same time. I don't know. I'm going to assume it wasn't, and this was just a natural flow. So Mr. Yannetti says, that's essentially it. But what follows is really probative. We've spoken to them only for the purposes of coordination of their testimony and their background.
Boom.
And I've got definitions of coordination and background that I won't provide, but those in Merriam-Webster's dictionary have specific meanings. But I don't have to parse that at this point. So I want to continue.
Be right back.
We
Someone's
have not been able to interview them regarding their findings, which are outlined in detail in the reports that both sides have. And I know the immediate response might be there, it might be at this point, wait a minute. You haven't had time to interview, et cetera, et cetera. But what has been the communication up to that point? It's been the first communication from Mr. Jackson, mentioned in the March 20 email, and then the pause email. That statement of Mr. Yannetti, as best as I can gather, is 100% accurate. It is not merely a response that stops with line 14 to 18. He goes on and explains exactly what the interaction had been up to that point. The statement of Mr. Yannetti is 100% accurate. Now we get to the court. See, I don't see that as being the report. I don't see that as being detailed. It leaves a lot of questions as the gatekeeper as to what they can testify, and you have not complied with your Rule 14 obligations. We can't, Your Honor, and this was what I was pointing to before. So you can't, but you haven't. So I'm left with you haven't complied. So we need to get everybody here for a voir dire that can testify yes. Well, we need to do that in advance of their testimony. Okay, that's fine, Your Honor. So the defense is now fighting with bringing them in for a voir dire. That's, Mr. Yannetti says, that is fine. So I said I'm not going to conflate issues, but there's overlap of issues. So here you have a Rule 14 issue. Your Honor has concluded there's a violation. Your Honor has fashioned a remedy. The remedy is they're going to be subject to voir dire. The defense doesn't fight it. That is the Rule 14 remedy. But I'm going to get to how that interacts with the Model Code 3.3A1 in a moment. So we have then the voir dire. And what I'd like to, if I could, Your Honor, have you turn to tab 3, which is excerpts of the voir dire.
Page?
It's tab 3, and it's the June 18,
Okay.
2024 voir dire examination of Dr. Wolf.
This is going to be the video you posted.
And before I get to this,
Can we just acknowledge that Internet Snoops had this 15 minutes after she ended her hearing? Brandy had it up 15 minutes after. While I was preparing my video, I could just see clip after clip going on TwitTwat.
Here's why you're wrong, Bev.
Yeah.
specific parts of it, I know this is well known by Your Honor, but it's important to set the predicate for the elucidation of the points I am making. We all know voir dire is the opportunity for anybody to ask virtually
got like $1
any
million
question
vocabulary.
they want of the
Love it.
witness to be voir dire. Your Honor set no limitations on the topics of voir dire at all. In recalling Your Honor's concerns, right, I don't know who even is opining on what. I went back and looked at that, Your Honor, pretty fair comment, if I could, from the bench. It was hard to see. But please recall that wasn't the defense is making. We got what was...
This guy is slower than and just sign me up for some sacral nerve stimulating. He needs to be slow because Bev doesn't understand fast talking New Yorkers. I don't want to know what that is.
Said in
think
cement,
he's trying
the
to be
reports.
controlled
That's the way they came.
because
We
he's
didn't
very
create a report that blended experts as to what they were going to say. That's what got dropped in our lab. So the voir dire was the opportunity for the Commonwealth to ask whatever questions they wanted to ask. There were no limitations. So up to this point, Your Honor, I'm going to use some words of others because I'm going to come back to them after we talk about the February 18th hearing. There was no compensation as of June 18th. There was no promise. There was no reward. There was no inducement unless one tries to define inducement as being the hope that you'll get to have these experts testify on behalf of the defense. There was no favoritism because the Commonwealth had the opportunity to interact with the ARCA experts. They had the opportunity to call them as witnesses. And we sure know that the Commonwealth knows how to conduct a rigorous voir dire. Please simply recall Attorney Brennan's voir dire of Dr. Russell. That was the opportunity. They had a Dr. Russell opportunity with Dr. Wolf. What they chose to do with that opportunity, of course, is fully the discretion of the Commonwealth. The Commonwealth did not ask numerous questions that someone with the benefit of my hindsight in Monday morning quarterbacking would have asked them. But I would have asked them a lot of questions, especially given the unorthodox situation and given that the defense quickly jumped on the opportunity, right, to interact and call these witnesses. But they didn't take advantage of that opportunity in the voir dire. They didn't ask those questions. Had they asked those questions, they would have gotten answers. Now, Your Honor, I don't say that that in and of itself addresses the Rule 14 issues. I'm going to get to those. But I want to get to the prejudice and I want to get to some of the other important issues. I'm going to highlight, because I'm going to come back to it, Your Honor, page 1-67. We heard at the February 18 hearing, and again, I'm going to come back to it when we go line by line for those 9 pages. Not line by line, but many lines. If I could draw your attention, please, to line 12. It starts with line 10 to put it in context. What about human factors? This is the voir dire, direct voir dire. So Mr. Jackson is asking Mr. Wolf the questions. What about human factors? What does that discipline entail? What is human factors? Answer. Well, to give you an example of that, so I do a lot of nighttime visibility work. And then it goes on where, for instance, let's say a pedestrian is coming down to the roadway at night. There's also going to be, that I'm going to get to in chronological order, Dr. Wolf on direct talking about nighttime visibility work, etc. But if Your Honor could just please note the absolute raising of the issue of nighttime visibility in pedestrians affirmatively in voir dire.
by the defense.
So that was voir dire, no restrictions, opportunity to ask whatever they wanted to ask, and as a highlight, the voir dire brings out nighttime visibility work. If Your Honor could please turn to tab 4. Tab 4 is the June 22nd, 2024 email but it's important who it's from and who it's to and who's not on it. From Daniel Wolf to Alan Jackson, subject Wolf qualifications. No David Yannetti on this email. And Your Honor, because I've said it so many times, Mr. Yannetti not being on the email, I can tell you from my own experience in this second trial, but this was, I understand, the first, there was a division of labor. There was a lot going on. This is now June. This is in the middle of trial. Everybody's got responsibility for their witnesses. So there's not collaboration going on. It's not the luxury I usually have at my law firm, where you're sitting in a nice big conference room and all the attorneys are sitting around the table all the time, let's say in March, etc. But clearly in June, the trial's going on. But they're dealing with their own witnesses at that particular time. So let's read it because it's short, but it's important. I'll repeat again. This was an email from Daniel Wolf to Alan Jackson. Alan, I spent this time this morning putting together a brief outline of my qualifications. I've also attached my D&T deposition in trial, in the trial parlance. I know it's nothing compared to Andy. I obviously won't say what the response is verbatim, but I gave you a general sense of what my response would be. Again, I thought your questioning during the voir dire was fantastic, so please feel free to make whatever changes you feel necessary. I will try to work on some direct examination questions tonight. So I want to start with, without getting tech geeky about it, some basics, because these basics were not brought up and I believe led to confusion on February 18th. If you look at the attachments, every email, as we know, has a lot of information on its face, and one of it is you can always tell what goes along with the email. So this is attachment Wolf Qual's document. But what's the most important points, I think, to be gleaned from this objectively, Your Honor?
Brennan's a liar.
Mr. Wolf prepared the document, not Mr. Jackson.
No, I'm well aware of that.
Okay, so he prepares it, he sends it along to Mr. Jackson, and it's on qualifications. The next is, if you would just please turn to the attachment, which are the qualifications, etc. There's a comment, and these pages aren't numbered, but the questions are. If you look at 19, nighttime visibility work. And there was a comment, and this was referenced on the 18, but I'm going to come back to this. If you don't want me to say that, that's fine. That very testimony in that very point was elicited by Mr. Jackson on the direct that we're going to get to. There was no hiding of it.
I read that as well.
Good. Thank you, Your Honor.
So why are we here?
The next tab, and of course, it has the D&T of Dr. Wolf, his experience in testifying in court, et cetera, et cetera. I will indicate, Your Honor, that the information in terms of quals, et cetera, all of that, to me, would be basic questioning in a voir dire. But those questions, to the best of my knowledge, were not an issue of concern for the Commonwealth with regard to voir dire. I mean, but again, that's what voir dire provides the opportunity for. So next we have tab 5.
Hopefully.
June 23rd is Sunday at 2:59 p.m. from Daniel Wolf to Alan Jackson. Subject Wolf Direct, attachments Wolf Direct. So it's clear And then if you turn the page, that is the attachment, is something that has no labeling on it, but I don't think anybody is going to misunderstand that this is what's being referred to in the attachment Wolf Direct. So all the topics that are in this direct were all in the report of ARCA, the frozen in concrete report of ARCA. And we will get to this, but what I did was I went and compared this outline.
I did too.
Your Honor, there's one thing I've learned in the short time I've had in this courtroom is that Your Honor is on everything. And the reason I am underscoring this is because it's going to come to an application of all the legal principles. So I very much and genuinely very much appreciate that Your Honor has, seems like with an exacting eye gone through and looked at all of this. So all of this is what's in the report that everybody already has. Why do I make that point? Because the rule 3.3A1, it has relevance, but it's got more relevance to the Rule 14, and we heard on the 18 a very long buildup in an emphasis on the Commonwealth not having access to information, being surprised, et cetera, et cetera. So the point here is, additionally, if you compare the direct examination that actually occurred with this outline, there's not a very close resemblance. The topics are covered. I make that point because of two things.
Just call it a script.
First, Mr. Jackson did not prepare this document. One of your questions at the February 18 hearing was, what's the day, et cetera, and I'm going to get to it, and I'm going to use words, not characterizations. That's why I don't want to go into it too much here. But there was a certain impression made about who had prepared this document. But I want to underscore it was Dr. Wolf who prepared it and sent it to Mr. Jackson. Now I want to get to the timing because I think this is very important for the Rule 14 issue. This is Sunday, June 23rd at 2:59 p.m. The trial resumed the next day, which is going to segue me eventually to tab 6. And if Your Honor would look at the first page on tab 6, it's June 24, 2024. The very next day, probably less than 24 hours after this outline goes to Mr. Jackson, Dr. Wolf is on the stand. If anybody thinks that Mr. Jackson was waiting for an outline from Dr. Wolf to be able to prepare one of the most important direct examinations of the trial until he got it, I think that person would have to have quite a fanciful imagination.
I don't think there's anybody here who thinks that.
Thank you. So the other important point to underscore is that this was something provided by Dr. Wolf, not drafted one word by Mr. Jackson. So if someone is to say that, and I'm not inferring Your Honor, but someone else might want to infer to say that this is a blatant Rule 14 violation, this should have been turned over, et cetera, et cetera. What happened the next day, one day later, that would have required Mr. Jackson in the middle of trial with an unorthodox situation, trying to figure out what to ask Dr. Wolf, under what parameters, under what constraints, et cetera, that he should have also had the thought, oh boy, I got this in at 2:59 p.m. on a Sunday. I better hurry up and communicate with the Commonwealth and go provide that to him so I comply with Rule 14. I'd like to believe that I'm very diligent about my Rule 14 obligations, Your Honor. I'd like to believe I would have done it. I don't believe I would have even thought of it, came to my mind. we know what the standard is, but I want to underscore the connection in time between Mr. Jackson gets this and when Dr. Wolf is on the stand, because that's the really the prejudice time period or potential, if you will, that occurred. Not even to bring in the voir dire that this could have been brought up, all these topics in the voir dire. Not that voir dire satisfies all Rule 14 obligations, but the reason I brought up Your Honor's Rule 14 remedy was it was the remedy, I think perfectly tailored to the situation, to basically say, I don't, as the court, understand, these folks haven't gotten what the court found was their proper discovery. We're saying we don't have, the information to turn over in terms of it. We got the report, and all we had is emails in March, right, that are, in my view, non-substantive. They're communications. They're Rule 14 material, no doubt, Your Honor. But the question is, what's the prejudice from not getting those emails in light of the voir dire that Your Honor ordered? We'll get to those under 3.3A1, but under Rule 14, they clearly are of no prejudice to the Commonwealth. So now we have the trial testimony of Dr. Wolf. I mentioned, Your Honor, about the nighttime visibility issue, because much was made of that in the hearing 1 week ago. If Your Honor could please turn to page 3665, starting at line 22 at the bottom. Question. Mr. Jackson, this is direct. Mr. Jackson is eliciting this testimony. Remember the comment, I don't know if you want to bring this up? Mr. Jackson now is eliciting this topic. And how many of those 1,000, I know you don't have a number specifically, but how many of those 1,000 would you say involve pedestrians as well? Answer, several hundred. As I mentioned earlier, a great deal of my work is in the field of lighting and visibility, so there is a direct correlation between time of day and pedestrian incidents. Here's the key sentence. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. Elicited, discussed. Now to some very important communications on direct. If I could ask Your Honor to turn to 3669, please. Line 9. This is, again, by Mr. Jackson. At the time you did your expert review, Dr. Wolf, and your consultation, you and I had never met. Answer, that's correct. 100% true. You did not know who I was. I did not. 100% correct. You had never met Ms. Little? No. That's correct. Mr. Yannetti? No. Fact. As a matter of fact, you had never heard of this case. That's correct. Page 3670. Line 10. Question. When did your analysis and conclusions, well, let me ask it this way. You finalized your report, you and your team, correct? Answer, correct. Question. And that report is contained in a multi-page document that was submitted following your analysis and your opinions and conclusions, right? Answer, correct. The defense didn't have anything to do with that. That's correct. True statement. You had never met us, didn't know who we were when we did this. Correct. Now, if you could continue on, Your Honor, to, I believe, if I could be so officious and say this may be some of the most key aspects of the testimony for Your Honor's inquiry. 6, question. All right, it goes without saying, I'm going to ask it anyway. You haven't been paid by the defense. Answer, you have not paid us anything. No. 100% correct. And you don't work for us. That's correct. There was no engagement. There was no engagement letter signed. There was no retainer. Those discussions that were started on March 20th were paused with a March 22nd email, and they never were re-engaged. They were never re-engaged. They got to eventually get them on the stand, but there was no retainer. There was no terms of the engagement. To the best of my knowledge and my review of all these facts and discussions with counsel. So then the next, that's correct, question. As a matter of fact, I've never asked you specific questions about your testing before today. That's correct. Mr. Wolf sent in questions that he proposed Mr. Jackson asked, but that's why I underscored so many times the fact it came from Dr. Wolf to Mr. Jackson. It's not Mr. Jackson asking questions in that document. It's Dr. Wolf sending them in. And Your Honor, I'm going to speculate if I could, and I'm not going to do this often in my presentation, but I do know a fact, and I do know, and a fact I know secondhand. If we put ourselves in Dr. Wolf's position, we think it's odd for attorneys. Imagine him. He's about to sit on the stand in one of the most visible cases in the country. He is an experienced expert. He's used to interacting with attorneys. He is not having the level of interaction and preparation anywhere near what he's used to having. But he's got to go on the stand with his professional reputation, and he's nervous. He's nervous. So my speculation, he sends in the direct to try to get some degree of comfort.
So with all due respect, please don't speculate. Let's move on to the merits, okay?
I will not.
You can use this maybe at argument at some point, but let's just focus on what we have.
I will do that, Your Honor.
If you know for certain that's the case, that's fine.
I will tell you, and first of all, I appreciate what you said, and I won't speculate anymore. I said I was going to make an exception for this, but here's the fact that I do.
No more, because you said you might do it more than once. So no more speculating. But if you know for a fact that that's true, I'll hear it.
Your Honor, first of all, completely understood, no more speculation. There will be no more speculation until we get to February 18th, what I think is really important.
Okay.
Because the Commonwealth on the 18th speculated a lot. And I think the only way to fairly...
So let's go back to this, okay? You'll get to February 18th. Do you know for certain that that's what Dr. Wolf was thinking?
Here, I will tell you the basis of it, in fact. I've spoken with Mr. Jackson, and Mr. Jackson said that Dr. Wolf was anxious about the fact that he had to get on the stand without having the typical level of preparation and knowing. That is Mr. Jackson's sense of Dr. Wolf's situation at the time the direct was sent. So can I say for certain? No. Can even Mr. Jackson say for certain? No. That's the sense, though, that was extant at that particular time.
Okay.
So we then go down to the next question. But I want to come back to that question on 12. As a matter of fact, I've never asked you specific questions you're testing before. That is correct. That's an accurate statement, Your Honor. That's an accurate statement. 15, your work product, the report that you provided was provided both to the defense as well as the Commonwealth. Is that right? That's my understanding, yes. And you were equally available to both sides in terms of them reaching out, correct? Yes, and I called you ultimately after receiving your report and asked if you join us and testify, correct? That's correct. Why do I point that out? Because it's not only my sense when I said earlier that and I don't think this is disputed, the Commonwealth had equal opportunity to contact ARCA. That was Dr. Wolf's sense as well. So that is the direct testimony of Dr. Wolf, and I want to just speak to the findings because on page 30 3676 to 3677.
The Commonwealth isn't getting leeway. This is the defense talking. So Commonwealth haven't said a word today. The point of all this is to make Bev not throw Alan Jackson out and rescind his pro hoc vice.
Which I don't see how she possibly
Because
could.
the findings
If he lied to court.
never changed
Well,
one
Brennan lied.
iota from the report ARCA issued in February to Dr. Wolf's testimony. There's been a lot of talk about potential cause and effect of the interaction Mr. Jackson had with Dr. Wolf before he testified. And the key emphasis, and I think should be the key concern of everyone, certainly was the concern of the U.S. Attorney's Office in the federal investigation. They didn't want those findings altered in any way. And the U.S. Attorney's Office basically said, we don't want any more additional testing. We don't want anything. You're going to get these findings and you're going to deal with the findings that they have. So what were those findings? Bottom of 3676, line 25, did you perform an accident reconstruction? Specifically focused on determining whether or not damage to the Lexus was consistent with hitting Mr. O'Keefe. Answer, yes, I think that's a fair characterization. And reversing that, was your accident reconstruction also focused on whether or not the injuries to Mr. O'Keefe were the result of being hit by a vehicle? So it's important to know, in terms of, whatever the interactions were and whatever the effect of the interactions were, is that the findings always stayed the same. And what was elucidated at trial, what was presented to your court, was not anything whatsoever different from what was established in cement in that report in February of 2024. So now we go to, and of course, the findings of ARCA being that the vehicle did not come into Ms. Reed's SUV did not come in contact with Mr. O'Keefe, and the injuries that Mr. O'Keefe incurred were not the.
No, the argument is Brennan misled court by not keeping a timeline. The only thing that could have been a problem is that Dr. Wolf reached out to Alan Jackson at 2:30 on a Sunday, and he was testifying on a Monday that Jackson didn't send that email, but it had no impact on his testimony.
Result of an interaction with a motor vehicle. So now we go, Your Honor, to the tab 7, which is the invoice. I am going to be very precise and point out some items, hopefully for an efficacious purpose. It says at the top, ARCA invoice date, July 12, 2024. Of course, by then the trial is over. Your Honor correctly noted in your preparatory statements about these line items that are in it. We don't run from one word or line in this invoice. But it's important to understand the facts behind this. The last discussion that any member of the defense team recalls having about any compensation at all was back in March, and it wasn't even any discussion about particulars, etc. It was just the defense feeling that they were going to be calling these witnesses. And there was the question of, is there going to be, and I had that as required in there for a reason, because they didn't know. It was just trying to understand this very unorthodox relationship because of the U.S. Attorney's Office, their constraints. The defense position is that there was absolutely no meeting of the minds that ARCA was going to be compensated by the defense. It wouldn't have been a surprise if that would have been demanded of the defense, but those were paused. Those discussions were paused. And again, that's the recollection of the defense. And to be clear, Your Honor, as Your Honor knows, I was not a participant in the first trial. I'm not speaking with firsthand knowledge on any of this, but I have conducted as thorough an investigation of these facts and marshaling of them as I think I can possibly do. So here's the punchline, Your Honor, with the invoice. Came out of the blue.
No, he didn't. He didn't lie. He didn't adhere to his Rule 14 obligation, and as Alessi said, in the heat of the battle. But again, if that is one lie that should lose him his pro hoc vice, then the case should be thrown out with prejudice because the Commonwealth has not followed their Rule 14 motions. So
They
again,
haven't
if it's good
followed
for
a
the goose, it's
single-
good for the gander.
Yeah, they've been delaying turning over evidence the whole time since the
Yeah.
beginning of this thing.
It came out of the blue. It gets sent to Mr. Jackson's office in July. I can't reveal attorney-client communications, but I can tell you there's one person that was more shocked than most about the invoice coming in and the amount. So what happened? And this is, Your Honor, objective. These are recollections, information.
I don't know what you're fiddling with, but that clinking sound is really annoying.
It's a wind chime. I'll get it.
The defense team called Mr. Adam Deitch at the U.S. Attorney's Office. What is this? Can we pay it? We supposed to pay it?
Sorry, y'all.
I encourage Your Honor to communicate with the U.S. Attorney's Office about, did this conversation really occur? What was the substance of the conversation? Because, as I understand it, one of the questions of Mr. Deitch was, can we pay this? Are we going to be in violation of some expectation of yours? We want to do this the right thing. Mr. Deitch said, yes, you can pay it.
Who's Mr. Deitch?
Why
U.S.
would
Attorney's
the
General's
call
office.
go into Mr. Deitch if there was a prior agreement that they would be paid for anything? There would be no reason for the call.
Did they pay it?
Yes, that was just the point I was going to get to.
And when was that?
The best of my understanding was very close in time to when it occurred. So I understand the date of this invoice, the date of the invoice is July 12th. And I think I can get you the exact dates here.
So they got an invoice, they didn't know why, and paid it.
Mr. Jackson's firm, not Mr. Jackson, but a staff member, and I want to be careful of attorney-client communication, so I'm not going to talk about the subject, but communicated to Ms. Reed that this invoice had come in. And I believe that communication was toward the end of July, I'm going to roughly estimate the 24th. And then there was a communication, of course, with Mr. Deitch. And after Mr. Deitch said, yes, it's permissible to pay that, I believe the payment was made very shortly thereafter, maybe within a week.
When was that? Within a week, within that July 24th date?
Get you an exact answer?
I would like that.
Sure. I'm going to attempt to get an exact. If I can't, I think I can get a good approximation. Your Honor, I understand a check was sent to ARCA on July 25th.
Thank you.
You're welcome. So there's no
July 2nd is when they declared the mistrial.
doubt the invoice was paid. But the story is not solely about was the invoice paid. The important part of the story, but the facts, is it came out of the blue. And I don't expect anybody to take my characterization 100%, but that's my full understanding. But the call to repeat to Mr. Deitch is, to me, the corroboration of that very point. And it's an important one. It's an important question, and it's important, very important question. But it's an important fact point as well that that call was made. So in terms of the next tab, which I've been
Attorney
alluding
General's
to
office.
during
Okay,
my-
so this is the one I said I needed to take a
I
recess
was
to
just
read
going to
that.
say the same thing.
All right,
This
so-
is now that point.
All right, why don't we take a 15-minute recess?
All rise.
So the payment is for service rendered that they didn't order. And so far, the only communication that has anything to do that didn't follow the Rule 14 motion is an outline
email.
discussed Sunday afternoon at 2:30 in the middle of the trial. Is what I gathered from these an hour
what
and
it
20
sounds
minutes.
like. That's what it sounds like.
Yeah. So, what Brennan presented to the court is,
At the very least, a misrepresentation of the truth.
yes, because he didn't put in the timeline that all of this happened after the trial with the payments and the retainer wasn't. They were never billed for anything with that retainer. This bill had nothing to do with the retainer that they talked about, and they had no communications between him reaching out to them and then they were about to have them at trial.
Essentially, what he's trying to do is give somebody a ticket for not stopping at a stop sign that they ran before the stop sign was installed. Like, they installed a new stop sign, so they went back and watched the camera from yesterday where somebody just drove through the intersection. Now he's trying to write him a ticket for it.
ARCA sent a bill. They asked if they could pay it. They did, but it was after they said they weren't getting paid. They
Right.
were sent a bill
In July.
almost 3 weeks after the trial ended, and they called Mr. Dyke at the U.S. Attorney General's office and said, "Should we pay this?" And he said, "Yeah." And then they paid the bill the day after. But they were talking to the U.S. Attorney General's office. So again, it wasn't even a communication with ARCA that said, "Yes, you need to pay this." It was the U.S. Attorney General's office. And again, we don't have an itemized bill, so we can't speculate. I know everyone was up in arms and said they got 23,000. Yes, for two experts doing trial works with 2 days in court. That's $5,750 per expert per day in court. Travel, prep work, that's not a lot of money.
Not a little money.
It's nothing. Go back and look what the Johnny Depp's experts got paid per hour.
Oh, I'm sure.
Put it at $500 an hour. That's 4,000 for an 8-hour workday.
Man, I'm in
ARCA
the
don't
wrong
come cheap.
business. If only I would have stuck with that PhD in mechanical engineering.
Yeah, but you got your gender studies.
My basket weaving degree. Oh, God.
Tomorrow,
Yeah, because you have to be drunk to drive to court in Canton.
he'll be in custody.
So that's hazard pay.
15A, doctor's going to talk to him.
Apparently, somebody was drunk when they testified, huh?
No, he wasn't.
Yeah, that's the rumor. Yeah, and it didn't go to the expert; it went to ARCA. And the AG's office. Well, Bev couldn't she just summon them and say, "Hey, did you make them pay this bill?" So it's crazy. It's and again, we've been doing this for an hour because Brennan, and he even went back and corrected it because he lied to the court when he said he didn't get this. And most of it is, as proven today, information that was said in open court.
Mm-hmm.
That's I don't know.
Well, that's why he didn't get it, right? Because it was all done in open court, and there was really nothing to send him at that point.
The only thing so far I can hear is that Brennan got an email at 2:30 on a Sunday that he never replied to Jackson. Yeah, that he never replied to. That he then had the next day he was talking to that guy in court, where he
Right.
asked the question. He said, "If you want to leave it out, you can leave it out." So that Rule 14 again. The Commonwealth dropped evidence during trial, so it's probably not. But it's Bev. Bev is an a-hole, so we never know what she's gonna rule. But
It's almost certainly going to be on behalf of the Commonwealth,
yeah, of course.
because that's just how Bev gets down.
Good yourself? Good.
This kind of hearing should have been done regarding the video. Well, at least you should have tried to figure out why she allowed an inverted video in, and why they lied and said it was a true depiction of what happened. Will we learn
she
how much
also doesn't-
Brennan's tab has already exceeded the amount agreed upon? Has nothing to do with the courtroom. That is a deal between the Commonwealth and the lawyer. So it's the taxpayers of Massachusetts' problem. It has nothing to do with the trial. Because it has nothing to do with the trial. The Commonwealth can pay him $1 billion if they want to. It has nothing to do with the trial. They hired an outside guy because apparently no one wanted to run it, who is already hired. So
Lally decided he didn't have enough hair to lose this time.
yeah, and he couldn't smoke as many cigarettes. So that's for you, Massachusetts taxpayers, to decide at the next election if you want a DA who wastes, I think it's close to $200,000 now, to hire a guy because his already hired personnel can't run a trial. Has nothing to do with the trial.
Ridiculous.
Well, he said both. He said he read the first trial transcript, and then he said he didn't read it. So Brennan is he's the only person who can be a little bit pregnant.
And I almost want to say like there's a new
Oh,
Well, you just had an election. You're going to vote him out there, but apparently didn't even have competition. And I love that he gets a lot of political contributions from the people working at his office. How is that not a bribe? That someone who's working for you pays to your election campaign. That's highly unethical, in my opinion. But that's okay, apparently. Hey, Unbronzed. You can figure out his salary. It's already been openly declared that the 75,000 he was agreed upon having is, I think, his company has already received 146,000. So
He's already
don't
doubled
think,
it.
yeah,
Wow.
doesn't matter.
Wow. I still can't believe how he got up there and just made all these crazy, wild accusations. And he's still not going to have anything happen. Like, he's not going to get sanctioned for it. He's not going to get even yelled at.
No, and she made all this noise out of nothing.
Nothing.
A potential minor Rule 14 motion. When we think about Lally, who constantly lied about discovery in the first trial, Hank Brennan, who had lied about Rule 14 evidence in this trial. And again, it's a big nothing burger. It was, they didn't change the testimony. They knew what the testimony, because the report was already delivered to the court before they had the first contact with them. So I don't understand it.
Seems
You can
fairly
find out
biased.
how much he was paid. It has to be public record. Yeah, you can go and see it. So funny thing, we were talking about it today in court. Now you can pay everyone, whoever you want, and judges can just take money. Our judges can't even have, like, if there's something from a lawyer's office, like a box of chocolate, or participate in the yearly lawyer Christmas party. They will have to pay for it themselves, because there can't be seen any inflection of payment to the judges. They have to stay clear away. Back in the day, they could get, like, well, here's a Christmas basket or something like that, or come to this arrangement, so you have that relationship where you can talk without it have to be on the record all the time, because sometimes you just need a little good relationship with each other, and can't have any of that. They can't
I
do
know
anything.
I've heard congressmen talk about, like, they can't receive gifts over like $20 in value or something crazy. I'm not really sure why it would be different at a lower level of politics.
No, I have a hard time thinking that they don't. But it's the same with doctors that gets all these golf trips and stuff by medical companies. I can't understand why they are allowed to do that if a judge can't even get a box of chocolate.
That doesn't make any sense to me personally. That's
Yeah.
just gross. Get the money out of politics, yo.
We're only allowed to receive one gift per year and cannot exceed $3. Well, so you can get,
There you
like,
go.
a bottle opener.
Get you a koozie.
No, but it's just it's weird to think that because the DA can pick favorites, who can get the nice cases. If you get a good case, you can get a good career. If you win some high-profile cases, if Lally had won this one, yeah, there's a potential DA job when Morrissey steps down. And
He would have been a shoo-in.
yeah, and he, I can't even remember. I think I've seen how much he contributed to the re-election. And why does a guy who have no opposition run up a war chest in the tens of thousands?
Well, that's called
What
a
does-
slush fund, Baker.
Yeah, and that's another thing that is so highly inappropriate that they can use that.
Yeah.
An elementary school teacher in Korea can't have anything over $50.
It's crazy.
Campaign contributions are public record, but that's a different thing. But it's still, why is a guy who doesn't run a campaign soliciting campaign funds? Didn't he run up like 90,000 to his campaign this year, or his last campaign? I think so. And again, he had no opposition, which is and again, keep politics out of the courtroom and keep money out of the courtroom. That's just my opinion.
Good opinion. I'm on board.
Aren't cops state employees? Some of them, well, state cops are. Well, then you have something to eat while you are recovering from surgery. And the drama llama has also arrived to the U.S., so that's great.
I can't wait till June, man.
I still every time I try and pay for the tickets, it get oh, it's wrong. I think that those search engines, they give you such a lowball price to get you to buy through them, and then the airline says, "Get out of here." So I still haven't bought my ticket.
You should probably get on that.
I just got angry yesterday because I tried 5 times and every time it said payment not processed. So that's a little annoying. And again, it's about to get economy premium. It's some of the flights I can almost buy business for the same amount. So that's a little.
You may want to reach out to your financial institution to see if they've got a block on like a maximum that you can spend.
You have like 25K and the tickets were 8K. So
Okay.
that's not the problem. But I have to. If I put in I want to buy this, I'll have to swipe on my bank app and say yes, I approve that. But it never even pinged there. So I think it's because they're just putting up those low prices to try and get you to buy through them.
They're catfishing you.
Yeah. Someone tried to buy me a bag of chips once. Nope, not worth getting fired over. That's crazy.
Right.
I don't even think I know where there is a travel agent in Denmark. I think I'll have to go to the airport to find someone who sells everything is done online these days. Travel
I'm sure
agent.
you've got a government department for that, don't you?
No, but I have a friend of mine whose sister worked in a government department buying plane tickets. And she really liked that job because she had to go out and approve the hotels. So whenever the minister and the delegations went out there, make sure that if it says it's X, then it has to be X. Because sometimes you buy a 4-star hotel in Spain and they haven't really built the hotel and stuff like that. And you'll end up sleeping in a shack somewhere. So her job was to go around and check the hotels.
Rough job.
Yeah, her frequent flyer miles were insane.
I'm sure. That'd be quite the gig, wouldn't it? Just fly around
pretty
and
good
check
one.
out hotels.
You don't have travel agents. Why do I need a travel agent? I'll just go into the website and I can call the company and say it doesn't work. But I haven't bought a ticket through a travel agent since 1998 when I went to Crete.
Where's Crete at?
Crete? That's in an island in Greece. Or Greek island is probably the right term. No, they can't get me cheaper tickets than online. It's a big scam. You pay. They don't do a service for. They get paid for the service they do. I don't need an assistant. I need an assistant to get me booked with other people and book other people on my show. But that assistant had a dog that got ill, so I didn't want to pressure her and say, "Hey, could you reach out to some people?" It's a great little island. I was there while we had the beginning of the '98. I must have been the World Cup. Yeah, we had the World Cup. So we spent some time there, and then I had to go home. And with the band I played in, we were going to France where they had the World Cup. So I was in just outside of Paris when they had the France-Brazil in '98, where France beat Brazil. That was a crazy night. Buddy of mine was, we were high-fiving people while we were taking the cab home to the hotel, and one guy just grabbed his hand and the cab just moved forward. That hurt a little bit. We had to stop by the hospital, and he had some ligament that got stretched a little bit.
There's a saying about that, about the celebration. Like, if you can't handle the celebration, don't score the goal or something.
Yeah.
Something like that.
I don't yell at you. I said I didn't want to do it because you had a sick dog. I am compassionate. I'm not Jamie.
I thought he was being pretty nice, Marissa.
There are a ton of brick and mortar travel agencies in Denmark. I can't tell you where. We had them when I was younger, but I haven't seen one in 1,000 years. I don't. And I live in a decent sized city. I don't. We don't even have a ticket office for the railway. That's a 7-Eleven you go into and buy your ticket.
Are they called 7-Eleven?
I think they're still called 7-Eleven, yeah.
Nice.
I remember when I lived in Copenhagen, and I had a 7-Eleven just across the street, and that was amazing because where I came from, everything was closed after 6 o'clock. Well, gas stations was open till like 9.
You are unmuted.
But other than that, we couldn't do anything after 9. So going down at 11 o'clock or 12 o'clock, buying beer,
Back in session.
amazing.
May I proceed back
Living
to
in
the
the
podium,
bush.
Your Honor?
Please.
Would you like to remain seated?
You can
Thank
go
you.
back.
May I continue, Your Honor?
Please.
Thank you. So, Your Honor, to blend and quickly summarize what we've gone through I'm using the table of contents of the notebook. We've spoken about the March 20 and March 22nd email from Mr. Wolf to Mr. Jackson. We've talked about June 10th and statements of counsel. We've talked about comments of Your Honor. June 18th, we've talked about briefly the voir dire of Dr. Wolf and the opportunities the parties had there. We talked about the June 22nd and June 23rd's emails from Dr. Wolf to Mr. Jackson and the proximity of those emails to the restart of the trial on the 24th. The 24th is the trial transcript of Dr. Wolf. July 12th, the date of the invoice. As Your Honor well knows, we got you when that invoice was paid. And now, with all of that, what I am going to do, Your Honor, hopefully productively, with no speculation.
Okay, so you don't have to tell me what you're going to do. Just go ahead and do it.
So I will just go ahead and do
Yeah,
it, Your
you're
Honor.
losing her. She's
Now
getting
to
angry.
the transcript. And as I go through, I start on page 53.
Okay?
Line 19. And this is Attorney Brennan. Your Honor, my purpose is not to deprive the defense of an expert. I'm going to stop there. That statement is I will carry forward about the Commonwealth's statement that they're not seeking to deprive the defendant of ARCA as a witness was made 5 times. I counted them, and we'll go through each one and number them. Or deprive the defense of an ARCA expert in this case. Very important, because from my perspective, what was put in the firing line on February 18th was the ARCA experts, albeit indirectly. So now we go to page 54. And this is going to be, in some points, a line by line, because the words matter. line 5, and this is again is Attorney Brennan. Well, what the government worries about is that there is other things that are relevant, like compensation, promise, reward, inducement, whether there's collaboration between one side or the other, and that expert witness that they don't know about and can't ask about. I'm going to stop there. That they don't know about? Really? Don't know about the ARCA experts?
Get 'em,
February
Lucy.
12th report?
Told you this clown was blathering about nothing. Well, let's see how Bev takes it. But yeah, he needs to tighten her up.
A voir dire?
Gigi.
Knowing the purpose of the voir dire was we wanted to have these witnesses testify. And then the next statement, and can't ask about? Really? Can't ask about? Voir dire, the opportunity. Next statement, that there's some bias or favoritism that the expert might have towards one side for whatever reason. I don't know what's meant by favoritism, but having worked with experts almost every week, you call an expert to testify. I don't know if I would call it bias, but I don't think it's a stretch to say that if an expert's going to come in and give opinions helpful to your client, that that expert is biased. But this expert was not engendered by the defense. It was engendered by the U.S. Attorney's Office in their federal investigation. Next, on line 12. So that if that information is not disclosed, really? It was on February 12th of 2025. Now, I'm going to get to this because, and this is not speculation, this is fact, the entire buildup of February 18th was on the false foundation
Finally.
that the Commonwealth had gotten all the information that they were going to talk about until Your Honor's break from the federal government and not the defense, which was completely false.
Finally.
So this is a buildup, is all in.
And what was the date again that the defense provided it? The Friday night before our hearing, was it?
It was, I will tell you this, I'm going to have to think out loud here. I'm going to answer it. I think it was February 12th that it was provided of 2025, but it's important to state why that date. Please recall, Your Honor, that the Commonwealth had not yet issued its certificate of compliance with discovery. And I know I don't need to tell Your Honor the rest, you know it better than I do, about counsel's obligation to turn over discovery, et cetera, et cetera. So I don't know if the Commonwealth on the 18th genuinely didn't know that it came from the defense as opposed to the Commonwealth. But what's very, very clear are the statements that I'm going to go through that were all built upon the foundation that they learned about this all from the federal government and that the defense had not turned over anything, which is completely false.
Okay.
So let's go through each word because it gets really important. When there are claims made that the defense has not turned over something and there are words used like ambush and duping, it's important to understand and get behind those verbs as to what the facts are. So the next. So if the information is not disclosed, then it's not only an impediment, it creates a position where there's an unfair examination. Really? Voir dire occurred? It's not the ARCA witnesses that I have the issue with. That's number 2 of 5. The Commonwealth is not saying we have an issue with ARCA. And why do I keep repeating this? Because my conclusion is going to be ARCA should be unscathed. ARCA should be available to the defense. And I'm going to get to more of that in a moment. So it says it's not the ARCA witnesses that I have the issue with. It's the issue, the fact that I don't have adequate discovery. Those words, I don't have. The Commonwealth had for 5 days the very discovery that was being discussed that the Commonwealth didn't have. If the defense is going to be a proponent of those witnesses, they have obligations, Rule 14 obligations for basic discovery. I agree with that. I agree completely with that. And we complied on the 12th. And it's for this trial that matters, Your Honor. Your Honor has commented before that this is a new trial. This is a second trial. I've tried unsuccessfully sometimes to talk about the baseline with the Daubert issues, and Your Honor has rightly commented, well, Mr. Alessi, this is a new trial. Point taken. Now, I wasn't at the last trial, but I've read the transcripts. That's an important point, Your Honor. Mr. Brennan has said before that he, earlier in these pretrial proceedings, that he hadn't had a chance to watch, hadn't had a chance. And believe me, I can empathize with Attorney Brennan on that. It's a lot to digest. He and I are both coming into this second trial new. So I appreciated the comments he had made before. But his comment here is I've read the transcripts, and I'm going to assume that for the very important topics he was talking about, he had read the transcripts. But again, that would be something that only Attorney Brennan would know. But it's an important point to point out. That was the representation. But I've read the transcripts. And then he goes on, and on page 55, he repeats what we went through about June 10th and what counsel for the defense had said. So I'm not going to cover that. He's just reading what I took head on before the break. And so we then turn to the continuation of the buildup, which is at the bottom of page 55, Attorney Brennan. Now, I have some familiarity with the federal government. Seemed to me, based on my limited experience, there was much more to the story. And the story is about interactions with defense counsel. That's what was talked about above. So I called the federal government. There's no statement here. There's much more to the story. And I've got the discovery that the defense provided that told the complete story. So there was, and I'll tell you, my impression from what is stated here is that counsel made these representations, but the Commonwealth couldn't evaluate them because they didn't have information, so they went to the federal government. So I called the federal government and I tried to encourage them to provide full discovery so that the experts could testify. It's another statement so ARCA could testify. I was resigned to a TUI letter. I've been down that road many times. It's a dark road that never sees the light of day. So I filed a TUI letter, comprehensive TUI letter. And it was delayed. And over a long period of time with requests and deadlines, I finally received a response that was unresponsive. This is talking about discovery and information about ARCA that was already in the possession of the Commonwealth. And it was striking that it was noted it was unresponsive just when I read the materials. I don't know which materials Attorney Brennan is talking about. I'm going to give Attorney Brennan on this one the benefit of the doubt that he's not talking about the discovery materials that we had provided, because I think fairly read in context, that's not what he was referring to, but I don't know what's being referred. It's not the point I want to make. And Attorney McLaughlin actually identified them. They didn't respond to our request, so Attorney McLaughlin wrote back, and then we got new materials, just some. Got them from the federal government. It's not a statement that he got them from the defense, which is a fact. And then we got new materials, but a qualifier, just some. But these materials were the very reason why the defense should not be able to call witnesses without giving full discovery. We had given full discovery. We had given it. Having not been at the last trial and reading the transcripts, I only have a flavor for the last trial. So there is email correspondence between the defense, not only the federal government, but some ARCA, the witnesses themselves, and recent requests for. So he's saying, this is what I got from the feds. And what do I discover when I got this information from the feds, when he really got it from the defense? There's email correspondence between the defense. but not only the defense and the federal government, but the ARCA witnesses. And then he goes on. But if we look back earlier in the relationship, what we see back in March 22nd, 2024 is that there are conversations between the defense, Attorney Jackson and Daniel Wolf, who's one of these ARCA witnesses. And then he goes on and he reads the email. But the clear import of the point here is that the Commonwealth is saying right here that this is when I discovered these emails. This is how I got them, not from the defense, but the federal government. And we know now that that's incorrect. Then we proceed down to page 57. The Commonwealth, as I understand it, was not aware of any promise, rewards, or inducements or payment. They relied on a reciprocal discovery order of this court for that information. That's a misdirection. That's a misdirection.
Tell them.
There was no promise, rewards, or inducements or payments before all of those documents that the Commonwealth is referring to here.
And he knows
That
that.
didn't come until the invoice came in July. And it wasn't even a promise. It was pursuant to the conversation of Assistant U.S. Attorney Deutsch that, yeah, you guys got to pay it, and it's okay to pay it. So next, on page 57, line 11, he reads, response, "Hi, Alan. Subsequent to our conversation on Wednesday," this is, I think he's reading from the March 22nd, but one of the disquieting aspects of this February 18th discussion is it's not chronological, doesn't have dates. So it's kind of hard to follow, but it certainly gave the impression, clearly, not the impression, it was stated that these came from the government, and I'm going to get to it when Your Honor was asking very apt questions about dates. But this is a very interesting paragraph. "Hi, Alan. Subsequent to our conversation on Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward?" Your Honor, I'm going to please ask you to turn back to tab 1 of my notebook, because this was a purported quote of the March 22nd email. That's really not close to what the email says.
Oh, yeah. Come on.
We call that a lie.
It's not totally incorrect, but here's what I'm going to do, Your Honor. I'm going to assume that the court reporter's transcription was not accurate, and that Mr. Brennan accurately, because I'm going to give Attorney Brennan the benefit of the doubt, because I
Throw
can
the
tell
court
you that
reporter
I
under the
had
bus?
my statements in court not completely correctly transcribed by a court reporter, and unfortunately, sometimes it's been on some key things. I don't think this is key at all, but I just note it. But it says, Mr. Brennan goes on, "Now it's the opinion that troubles me. It's relationship, and the Commonwealth should have an even playing field." That's number 4 of the time he's not having any trouble with the ARCA experts. Saturday, June 22nd, Daniel Wolf wrote, "Alan, I spent some time this morning putting together a brief outline of my qualifications," blah, blah, and this is just a repeat of what we have already heard. Here now comes the important points. Page 58, line 2. "Now, this isn't information provided by the defense in reciprocal discovery." Oh my. This isn't information. She's talking about all these emails. This isn't information provided by defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TURI requests.
He's a liar.
and an insistence, the best I can, to get as much information as I can. It's incorrect statement number 2, and it's an important one.
The thing he did where he said, I, of course, give my colleague the benefit of the doubt is he's a lying asshat, and I think he lied to you, Your Honor, in lawyer speak.
That's exactly what it was.
Hey, MG.
Down below, unfortunately,
Agreed,
it gets
MG.
even more incorrect. Defendant provided an outline of questions and answers for the direct examination. Please put this in context, Your Honor. The Commonwealth appears to be believing that they got the information from the federal government, not the defendant. So they've got the outline, and they're now accusing the defense of having essentially drafted the outline. Defendant provided an outline of the question and answers for direct examination. That's not a fact, but if that were true, that would be very bad.
So what I'm going to do, I had no idea it's this late. So it's 1 o'clock. We're going to break for lunch. We'll stop back up at 2.
Okay, Your Honor.
Why?
Do you think, I have no idea how much longer you're going to be, Mr. Alessi. Do you have an idea? And I'm not rushing you. Do you have an idea? Because we do have the other motions. If we can't get to them today, we'll spend those 2 days next week with them.
I'm going to answer your question. I think I can conclude in 45 minutes because I have to get to the law, the 3.3A. I have to.
I'm not rushing you. I just wanted a
That's
time
my
frame.
best answer, and I will say this, Your Honor. I share your interest. I'm presenting some of these motions, and I have a strong desire not to be back here for that. So I share the goal, believe me.
Okay, so we'll see everybody at 2 o'clock.
I have a strong desire.
You are
to not be
muted.
back here.
Interesting. I'm going to put the Todd Mullis trial back on while we are waiting for this one to come back in an hour. Because I don't want to put this down, put one up, put one down, put one up. In my age, putting one up is enough. I need help with the second and third ones.
At 27? Yikes, man.
Yeah, you peak at 27. After that, you're going down. But he just said in open court, Brennan lied to you, Your Honor.
And he did. He absolutely
Yes.
did. She's mad at the defense for lying in the open court.
You described earlier in your testimony.
In fact,
Yeah,
the
and
exact
she-
opposite was true.
And that was the big problem I had was, could they get to that without it being too obvious and too, you're just saying he's a liar, but in reality, he's a good guy. I think they got to it as well as they could.
I don't think he's done.
No, and he has 45 minutes.
I think he's
45 minutes to go yet. I'll have to agree with Brandon. It's some of it is he gets a little talkative at some points, but he has to hit some of them, and he has to get to the law. The law is the most important part because Bev will do whatever she can to try and get at least Jackson out of here, and I think she realized that they might have effed up with her
well, she knows.
emotional outburst. But if you didn't hate court TV enough, and I know I for one love court TV, what did they get from this hearing? The defense paid ARCA, and they claimed they didn't. Oh, that's quite not what was said in. But it's funny how
Drama, Baker.
court TV and I can't remember that name of that horrible person, but she's very anti Karen Reed. But that's funny because she constantly does. She constantly do the what's good for the Commonwealth. Her and Kathy Daffy sounds the same.
Oh, that woman.
Well, he did
They should.
he did the nice thing and said, well, it must have been a mistake by the court reporter to try and. But he also said,
I think the Brennan should get sanctioned for that, but
yeah. But he won't.
No,
It's the same with everyone who said, why didn't all of the witnesses get held up for perjury? Because it's the Commonwealth who should charge them with perjury. That's not going to happen because they are perjuring themselves, saying things that the Commonwealth wants them to say. So the wine moms are going to get their pitchfork after they say that headline. Oh, you know how it is. True crime, box wine, in bed by 9. If you're Jamie, bed by 6. Yeah, he lied twice where they came from and who put the list together. Yes.
100%.
So
100%.
You should always be a little bit intoxicated watching me. It makes my streams better. I can play you the YouTube coverage. Yeah, but again, it's a professional courtesy to because he knows Bev will most likely don't do anything. So, but I'm gonna put on the Todd Mullis hearing, and I'm gonna go find me some food.
I like that idea.
So, and Valhalla is gonna kiss a goat.
Maybe.
Well, you should kiss a goat. They need love too.
My goats get plenty of love, Baker. They
Goat lovers.
Gross.
Well,
it's a good song.
Yeah. I'm going to put this on. I'm going to be back at some point, and we will return to the Can Read when they're back from break. Remember, this is the forensic examiner who testified on behalf of the defense in the first trial. And I can tell you, it's been like yesterday. They are talking for a long time to the same witness. So it's going to get a little boring.
Is this paused from where you had it, your last stream? Is it picking up wherever you left off? Cool.
Was a homicide. Yes. Did you testify in cases where you drew other conclusions? Yes. What did you do after your time in New York?
So I was looking for a job or evaluating jobs as a chief medical examiner, and ultimately was offered a position in a private practice in Pittsburgh with Dr. Cyril Wecht. So I accepted that position and moved to Pittsburgh.
I know it was loud. It's because I had the Can Read case boosted till 10 because couldn't hear anything. Hope it's better now. It's at 5.
Work with him in his private practice to help him perform autopsies.
Is Dr. Wecht still alive?
No, unfortunately, he passed.
You heard that part.
So for the autopsies that you've performed for those rural counties, what kinds of injuries are you seeing at autopsy?
The whole variety. We see the typical cases that medical examiners see, like motor vehicle crashes and gunshot wounds. But we see a lot of deaths in more rural areas, like people on dirt bikes or ATVs, farms, people at work who are passing away, those types of cases.
In your current practice, do you testify in court?
I do.
And have you testified on cases in your current practice where your opinion has been that the manner of death was a homicide?
Yes.
right, you said that I think you said 60 to 70% of your current practice is with those counties, is that right?
Yes.
What else are you doing with the rest of your professional time currently?
So I participate in medical legal consultations, like I've done on this case, and a large amount of that other time is spent teaching and as the pathology division chief at the Duquesne University College of Osteopathic Medicine.
I want to come back to your teaching in a minute, but you mentioned that you do consulting work. Can you explain what a consulting forensic pathologist does?
Sure. So primarily, we're asked to review records. Typically, it's cases where either a living or decedent person has had evaluations, and I'm given either medical records, autopsy reports, photographs, investigative information, and I'm asked to review that, analyze that, and offer independent opinions based off of my review.
Who are the clients that retain you for those consultations?
Attorneys do.
In what kinds of cases?
All kinds of cases. I've consulted in civil cases. I've consulted in criminal cases, both for the prosecution and the defense, Title IX cases, on college campuses, arbitrations, living victims of things like strangulation, so a whole variety.
And are you retained more often for one side or the other in those consults?
I would say for the consultations, it's probably about 50-50.
And have you been called to consult on criminal cases as well as civil cases?
Yes, I have.
In some of those consults, are you performing an autopsy?
I'm sorry, what did you ask me?
Sure. For some of the cases that you're consulting on, have you been asked to perform an autopsy?
Occasionally. It's uncommon, but yes.
And for those cases where you're not performing an autopsy, but you're consulting, do you follow a different procedure in terms of the way that you evaluate the case?
No, I follow the same procedure.
Well, if you're not performing an autopsy, how are you able to get information to aid in your evaluation?
Well, I'm using the autopsy and the information that's documented in the report, in the photos, in their investigative reports, and reviewing that and drawing my own conclusions from that, and then placing that autopsy into the context of all of the other information that's available, just like I would do if I performed the autopsy.
As a consulting pathologist, do you have clients who retain you to provide opinions in a case who elect ultimately not to use those opinions?
Yes. So my opinions are my opinions. If they choose to use them, they may. If not, then they may not.
Is it a concern for you if a client elects not to use your opinions?
No, it's not.
All right. You mentioned that you teach, and in addition to your work with Duquesne University, are you teaching anywhere else currently?
I teach at Duquesne University in 2 other programs other than the medical school, in the Masters of Forensic Science and Law program, and at the law school at Duquesne. And then I teach a course at Boston University in their Masters of Anthropology program.
Have you presented and published on topics in forensic pathology?
Yes.
Are you a licensed physician?
I am.
In what states?
Pennsylvania, New York, Massachusetts, and California.
Are you board certified in any subjects?
Yes.
What subjects?
Anatomic and clinical pathology and forensic pathology.
Are you a member of any forensic pathology professional societies?
I am.
What societies?
I'm a member of our 2 national societies, the National Association of Medical Examiners and the American Academy of Forensic Sciences.
Do you hold any leadership or committee positions in forensic pathology?
I do.
And can you tell me about any of those?
Sure. So I am part of the American Board of Pathology's Test Development Review Committee for our continuing certification, which are questions that we have to answer quarterly in order to maintain our license. So on that committee, we review questions, we edit them, we update them, make sure they're current, look at feedback from the test takers, and consider that. I also am part of the ACGME, which is the Graduate Medical Education Council, which certifies our training programs in pathology, so both in primary pathology, anatomic and clinical, and all of the subspecialties. So we review those programs annually and issue citations if programs are non-compliant with the requirements.
In total, Dr. Hammers, at this point in your career, how many autopsies have you performed?
Probably just under about 6,000.
Have you been qualified as an expert in forensic pathology in the past?
Yes, I have.
Has a court ever determined that you were not qualified as a forensic pathologist?
No, it is not.
In your career with teaching, have you been involved in running any teachings or trainings for law enforcement?
I have.
And can you tell me what that has been?
Sure. So for the last probably 5 or so years, I've taught for the Pennsylvania State Police, who put on a basic homicide, advanced homicide, and cold case lecture series or educational series. There's probably about a total of 5 of those trainings a year between the 3 of them, and I lecture in all 3 of them.
At this point, Your Honor, we're seeking to qualify Dr. Hammers as an expert in the field of forensic pathology.
Does the state desire any additional record?
No, Your Honor, I don't think this is necessary under Iowa law. She's qualified by her testimony, her opinions. There's no requirement that the court make that finding.
I agree. Certainly, I agree that this witness qualifies as an expert.
I'll proceed, Your Honor. Thank you. Are the opinions that you're going to offer in your testimony today, Dr. Hammers, opinions that you hold to a reasonable degree of medical certainty?
Yes, they are.
And the opinions that you're going to testify about today, are those opinions you reached using techniques that are generally accepted in the field of forensic pathology?
Yes.
I'm going to show you what's been marked as Exhibit 276. And just so the court's aware while that's being pulled up, Your Honor, I don't think for this exhibit, but for other exhibits that have been admitted today, we do intend to publish those to the gallery today.
Just let me know, I guess, counsel, if there's one that you would like
Thank you,
up on the big screen.
Thank you. Do you see Exhibit 276 in front of you, Dr. Hammers?
I do.
And if you need to look through it to answer this question, please let us know. But is this a true and accurate copy of your CV and the report that you issued about your opinions in this case?
I only see the cover sheet of my CV.
If you'll look, we'll move through that for you.
Can you go just a little bit slower because it's all gray? That's okay. Thank you. Go ahead.
Have you had a chance to look at Exhibit 276?
Yes, sorry, it came back to the CV again. So
All right.
yes, I see.
Is that a true and accurate copy of your report in this case and your CV?
It does appear to be, yes.
All right, and Your Honor, at this point, we're seeking to admit into evidence Exhibit 276.
Sorry.
Yep, any other?
276 in the CV, we have no objection to that portion of it. The report that Dr. Hammers authored, which I think is dated March 10th of 2023, correct?
I believe so.
Is hearsay, since it was prepared in preparation for litigation, is not admissible. I believe there's also some affidavits that are attached to it that are likewise hearsay as well. So that's our objection.
The court will take those objections under advisement, and we'll move forward since this is a bench trial. You may continue.
Thank you, Your Honor. And I have a binder for the witness of Exhibit 276 and two other reports that I think we've conferred about and may seek to offer into evidence, but not at this time. I just want the witness to have them available for her testimony. So we'll provide that notebook to her.
Okay, Mr. Brown, did you want to review whatever this is that the witness is going to have available to
So
her?
I was provided a copy of that before we came in, and I know we've already discussed this issue back in chambers. We are going to have an objection to the two other reports that are contained in that binder for the reasons we stated in chambers. And just for the record, this is in the two cases that we gave the court, or three, was In re Stencil, 827 Northwest 2nd, 690, 2013 Iowa Supreme Court case, which also references two other cases, State versus Barrett, 445 Northwest 2nd, 749, an Iowa Supreme Court case from 1989, and Bruner versus Brown, 480 Northwest 2nd, 33, Iowa Supreme Court case from 1992. Our objection would be to those reports and the consideration of those by the witness, in as much as they're going to use them in this way, just to alert the court to this. The expert here is, as State versus Barrett says, does not empower one expert witness to state other experts also subscribe to the same conclusion. Essentially, what we believe this is going to be is vouching. It also is the same 5.703, which is the rule of evidence. I believe that they're going to be relying on is not intended to be a mechanism for experts to self-bolster their own opinions with the opinions of other experts. That's Bruner versus Brown, the case I just cited. So I realize the court may take all of this information subject to that objection, but in as much as she relies on that, where it crosses this line that clearly Iowa's case law indicates that she cannot cross, we would ask the court to certainly consider our objection under those circumstances.
Ms. Thompson, did you wish to make any additional record on this point at this time?
I was going to say I'd like to reserve argument on this issue, Your Honor.
Okay, and that's fine. Obviously, I don't know how the testimony is going to come in yet. I understand that this may be an issue as it does, and certainly I'll allow both parties an opportunity to make any additional arguments that they wish. You may proceed at this point, Ms. Thompson.
Thank you, Your Honor. Dr. Hammers, you mentioned earlier that you were retained by Mr. Mullis's counsel to review materials related to this case and offer your opinions. What specifically were you asked to do?
I was asked to review multiple pieces of information, review them, analyze them, and offer opinions concerning my review based off of my education, training, and experience.
All right, now, you did not conduct an autopsy of Ms. Mullis in this case, is that right?
That's correct, I did not.
All right, did the fact that you are not a person who conducted an autopsy in this case limit your ability to reach opinions about her death or about the pattern of her injuries?
It does not.
Why not?
I'm able to review Dr. Cruz's autopsy report, the photographs that she had taken, the toxicology report, the medical records, EMS records, and the photographs that Dr. Thompson had taken at the hospital, and analyze all of those just like I would if I was doing the autopsy and preparing to sign a death certificate, and be able to issue opinions based off of that.
Did your process in evaluating Ms. Mullis's death differ from the process you'd follow in cases where you did perform the autopsy?
My process did not, no.
In general terms, what sources of information did you rely on to evaluate Ms. Mullis's death?
So I had the autopsy report, photographs, toxicology report. I had medical records from Ms. Mullis's hospital visit on the 6th of November, as well as when she came to the hospital the day that she passed away. I had the investigative reports from the police documenting the events the day that she passed away. I had Dr. Thompson's information from the hospital, as well as his photographs. I additionally received a report that Dr. Wecht had issued and a report that Dr. Boley had issued regarding their review of the case as well.
Now, you mentioned that Ms. Mullis had gone to the hospital on November 6th. How close in time was that to her going to the hospital related to her injuries in this case?
So it was about 4 days.
What was your understanding of why she went to the hospital that day?
She had a medical procedure that was like a same-day procedure that she underwent on that day.
What was that procedure?
It was what's called a DNC, or dilatation and curettage. It's a procedure on the uterus that can assist if someone is having continued uterine bleeding.
Was Ms. Mullis having that problem?
Yes, that's why she presented.
Why did you want to review records related to that procedure in this case?
Well, especially with it being so close in time to her passing away, I noticed that there had been some reports that the day that she passed away, that she had some complaints of feeling tired, maybe being kind of dizzy, and she had just kind of started back to working on the farm that day after the procedure because she hadn't been feeling well. And so it's best practice to have a person's medical information in general, but certainly if they have a procedure or some kind of change in their medical history around the time that they die, it's good to know what procedure they had, any medications they were on, and anything that was documented at the hospital during that time.
As part of your the records that you reviewed in this case, did you review any records from the emergency medical services staff who provided assistance to Ms. Mullis on her way to the hospital?
Yes, I did.
Did you review the Greeley Fire Department pre-hospital care report?
Yes.
Why did you look at the EMS records?
So my standard practice and everywhere that I've worked is that when I know that there are pre-hospital records from EMS or fire or first responders, is to get information from those records, either to have an investigator gather that information and have it in our report prior to autopsy, or to gather just the records themselves and be able to review them to understand what medical procedures were done and what their observations were, because findings and observations can change over the course of time prior to autopsy. So it's nice to have those different steps to be able to analyze each person's view of what they saw and what they did along the way.
And you said that you also reviewed medical records from Ms. Mullis being brought to the hospital where she passed away?
Yes, I did.
And why did you review those records?
So to understand, was her condition the same when EMS saw her as when she came to the hospital? Did anything change? Did they do any kind of additional testing that would help understand why she's passing away? Did they make any observations that either weren't present at autopsy or were different than autopsy and different than what Dr. Thompson, his photographs and his report showed.
Reviewing these categories of records, prior medical care, EMS records, medical care from the day that she passed, is review of those kinds of records part of the general practices of forensic pathologists reaching cause and manner of death determinations?
Yes, so in my training, in every place I've worked, and in all of my understanding of forensic pathology practice, that is part of the process and is the beginning part of the process even prior to autopsy.
And it is the general practice of forensic pathologists to review those records before reaching opinions about cause and manner of death?
Yes.
Did you review any records or photographs from the Delaware County Sheriff's Office in this case?
Yes, I did.
What did you review?
There were some, I think, two specific accounts of deputies, I think they're deputies, I'm sorry if I'm misstating that, but who had been the responders at the scene and had gone back to the farm and looked in the shed and taken some photographs.
Did you rely only on those materials to gain an understanding of the shed or issues related to the Mullis farm?
No, not just those.
What else did you do?
So I went and visited the farm and the shed to see the space for myself.
Is that a common practice for forensic pathologists?
I would say that it's not common for a forensic pathologist to go to every scene, but certainly we can choose to go to any scene that we would like to. And in cases where there's a question of in my experience, it tends to be a question of determining the manner of death that I've gone to scenes, but it could be the cause of death as well. And if you just don't have sort of what you need from the photos or the investigative report, or you need to kind of see, could this happen in the way that it's being posed to me or the way that I think it may have happened from the autopsy, it can be helpful to go to the scene.
Is gaining an understanding of the scene, whether through records review or a forensic pathologist's own investigation, is that a generally accepted practice in the field of forensic pathology?
It is. Typically, the only time that there isn't a scene investigation is if somebody dies at the hospital, but that would tend to be like if they're dying under natural causes. If there are unnatural causes, then certainly going back to the scene, depending on the circumstances, would be something that would be quite common for the investigators at the office, at least, to go and do.
Now, you referenced as part of your evaluation in this case, reaching determinations about the cause and manner of Ms. Mullis's death.
Yes.
Is that a determination you've made in this case?
Yes.
Before we get to what your determinations are, what process did you follow to reach your opinions in this case?
So I would say that in this case and every case, I follow sort of a standard like scientific method to the process that I undergo in order to evaluate a death.
What is that process generally?
So basically, it is gathering the beginning information that we've talked about, like the circumstances of death, the first responders, some medical information prior to the autopsy, at the autopsy, performing the external exam or looking at the outside of the body, and collecting any evidence or pictures, things like that that we need. And from there, formulating some ideas or hypothesis about what the cause and manner of death likely is, and then taking those into the autopsy, performing the autopsy, collecting additional samples like for toxicology or to look under the microscope at different tissues and kind of testing those hypotheses of what we believe may be the likely cause and manner of death, and then waiting for the additional testing to come back like the toxicology report, and then reevaluating those hypotheses of the cause and manner of death, and then ultimately, if we need more information at that point, going back and asking for it in order to make sure that we have everything we need to issue the cause and manner of death, and that there isn't anything outstanding that could be an important factor to that. And so when we get to that point, that's when we're going to issue the cause and manner of death and issue the death certificate.
All right, and Dr. Hammers, you described at the point where you conducted the external exam and an autopsy, that being the point where you develop your hypotheses. In your practice of developing cause and manner of death determinations, are there cases where after the external examination of the body at autopsy, you make a determination of your opinions about cause and manner of death?
So after my external exam, I often have a depending on the case, I can have a pretty good idea of what is happening depending on what injuries I see on the body or what I don't see. But I always need the internal examination to be able to definitively examine those tissues inside and understand. So a good example would be, I might see a gunshot wound that's in the chest. I can tell that it went in and it went out, but I won't know how much bleeding is inside the chest. I won't know what organs necessarily that it struck without doing the internal exam. So knowing basic anatomy, I could come up with some presumptions of what likely happened, but I wouldn't know until I actually did the autopsy. And the autopsy is typically what allows you to better understand the mechanism of somebody's death or the physiologic changes that are happening to them.
All right. So as part of your review of this case, did you have materials in front of you that would let you conduct an external review of Ms. Mullis's injuries?
Yes.
And just before we start to talk about this, do people in your field sometimes use the word defect in talking about injuries?
Yes.
What does defect mean in that context?
Defect tends to be used as like an injury or a hole that you can see in either the skin or an organ, and typically it's used when you're not really sure what it's from. So you may say this is a defect, and then ultimately you come to a more specific conclusion that it's a gunshot wound defect or a stab wound defect, and you may call it then an injury. So defect tends to be a general term when we're not sure or we're not yet sure more specifically what caused it.
All right. In your review of Ms. Mullis's body in this case, did you determine that areas of her body had injuries?
Yes.
Where were her injuries?
So she had puncture types of injuries on her back and extending over to her back right side, and then she had blunt type of injuries on different parts of her body.
And we're going to talk about both of those injuries, or both of those types of injuries, but just in general, thinking about, in your evaluation of both the injuries to her back and the injuries to other areas of her body, did you consider both of those categories of injuries in reaching your opinion?
I did.
Was there one category that was more significant than another?
Yes.
And which was more significant?
So the puncture defects that were on her back and extending to her right side were ultimately the significant injuries that she had.
Your Honor, at this point, I want to show the witness and publish to the gallery Exhibit 573, which has been admitted into evidence. And this is a version of that exhibit which has been cropped somewhat for privacy reasons, which I think the state saw yesterday.
Kelly, do you see the remotes for the big TVs anywhere?
The big TVs.
You'll wake up.
Do you have the exhibit in front of you, Dr. Hammers?
I do.
What are we looking at here in Exhibit 573?
So this is a photograph of Miss Mullis's back, particularly looking at it from the right side. In the upper right, you can see the back of her, where her arm meets her shoulder, so like the back of the armpit area.
For those of you who weren't here yesterday, all the pictures we can find Jemima and Marissa have put on the Discord. And again, Discord, free to play. You just have to sign up and you can go watch all the pictures. I won't show them on screen.
And there are 6 puncture defects that are on her right backside, extending across her back. And amongst some of those, there's one abrasion or scraping type of injury to the skin.
Are you familiar with a term, wound pattern analysis?
Yes.
What is that?
That's essentially when you look at each individual wound and look at any specific features like the size, the shape, the orientation, and the features around the wound. And then when you take all of the wounds that you have and look at them for any kind of patterns that they might have, or similarities or differences that they might have, to try to group some or all of the injuries together to understand how someone may have sustained those injuries.
Did you do that type of analysis on the injuries that on Ms. Mullis's body?
Yes, I did.
And first of all, in general terms, how would you describe the injuries that we're seeing in Exhibit 573?
So all of the injuries but that small scrape to the skin are all puncture types of defects or penetrating defects, meaning that the injury is going deeper into the body than it is large on the surface of the skin.
Can you give me an example of something that would be a penetrating defect?
Yeah, so common things that we see that are penetrating defects would be things like gunshot wounds and stab wounds.
All right. Those aren't the only types of penetrating defects, I take it?
No, there's multiple other types of objects that can cause penetrating defects, but those are the most common that we see.
All right, in this case, you've reviewed Dr. Cruz's reports, and you reviewed prior testimony from Dr. Cruz as well, is that right?
Yes, that's correct.
In Dr. Cruz's analysis, or Dr. Cruz's testimony about this case, did she assign letters to various of these wounds?
Yes, she did.
All right, and have you adopted those letters in your analysis?
Yes.
Which letters have been assigned to which of these wounds in this case?
So she labeled them letters A through F. So 6 wounds, letter A through F, and she started on the right side, which is the right side of this picture, with A, and then moving across the body, B and C, and then D she labeled as the lowest wound, and then E and F traveling upward.
To make sure that I understand, wound A is on the right side of the picture under her armpit, is that right?
Yes, that's correct.
And do you see a wound that is up from the ruler, but sort of at the end of the ruler?
Yes.
Is that B?
That is B, correct.
All right, then in the middle of the photograph, I get, well, more on the left side of the photograph, but in line with B, do you see 3 injuries and a line?
Yes.
Okay, so the injury that has the line, that's what you described as an abrasion, is that right?
That's correct.
The injury that is below that abrasion, which number, or which letter is that?
That was wound D.
All right, and then above wound D, there are 2 injuries right there?
Yes.
And which is on the right?
C is on the right, and E is on the left.
All right, and then there's another injury that's more to the top left-hand corner of the photo?
Yes.
What's that?
That Dr. Cruz labeled as F.
Right. Are any of these wounds, A through F, different from other wounds in the pattern?
They all are penetrating injuries, but some of them are just looking at them without adjusting them or moving the skin or examining them further. Some of them are larger than other ones, and some of them are a little bit smaller.
Which are larger?
Wounds A and B are the largest, with wound A being the larger of the 2, and then wounds E and F are slightly larger than C and D.
And when you're talking about being larger or smaller in this context, are you talking about depth or circumference, or what are you referencing?
So just looking at the skin here, the differences that you can see are going to be in the somewhat the size and shape of the actual defect in the skin, or the hole in the skin, and then the skin around that defect that has some changes where you can see discoloration, which is abrasion and contusion or scraping and bleeding.
Looking at in general with these wounds, did any of them have exit wounds on Miss Mullis's body that were associated with them?
So wound A had an injury on the front right breast that was in line with all of the injury path that was ultimately described on the internal examination, and was the end point of that injury path.
You mentioned earlier in your testimony that it's important to that part of your analysis is to look at medical records or records of treatment from different periods of time to gain an understanding of treatment over time. In that context, can the appearance of injuries on someone's body change over time?
Yes, they can.
And can you explain why that's the case?
Sure. So anytime the skin is broken or damaged, it makes the skin go from dry to having moisture. And anytime there's moisture on the skin or on an injury, that area is subject to drying, and that can change the color, the extent, and some of the features of the wounds.
I think we've identified which of these wounds have which letter. And I think it's your testimony that these wounds had different depths, is that right?
I did not testify to that, but they did have different depths, yes.
And sorry, I want to go through and talk about the depths of these wounds, so let's start there. So for wound A, the wound on the right, how deep was that wound?
Off the top of my head, my recollection was that was about 6.5 inches deep.
And what about wound B, the next wound over?
That one was not quite as deep. I believe it was about 6 inches. And I don't know if you want me to look at the autopsy report or not, just to make sure that I'm giving you the accurate measurements.
Let me ask you this. Did you review records from Dr. Cruz where she noted measurements of the depths of these wounds at the autopsy?
Yes, in her notes and at the autopsy, she had these documented, the size, the features surrounding the wounds, the depths of the wounds, and the measurements between the wounds and the orientation of them.
And before we talk a little more about depth, let me ask you this. Just looking at the external appearance of these wounds, the way that you see them in Exhibit 573, for you as a forensic pathologist, can you draw any conclusions about a situation where you have a pattern of wounds where some of them have different appearance than the others?
Yes, I mean, I can come up with possibilities.
And what are some possibilities for why that might be the case?
So it could be that there is movement of an object while it's in the body, which can extend the size and change some of the features around of the surrounding skin. And it can be that there are more shallow or deeper depths of penetration with an object, which can change the appearance slightly. So if you presume that it's the same object causing all of the injuries, you could explain differences in them based off of movement and the depth of the penetration.
All right, and you mentioned that you think that the concept of movement is relevant to considering the pattern of injuries. Is that right?
Yes.
How does it impact your analysis of injuries to think about the body as something that moves?
So it can change two things. So if an object, thinking about an object penetrating the body and being in the body while there's movement, that can change the size and features of the wound itself. But then looking at the body as a whole and knowing that particularly this part of the body, the torso or the chest, back, and abdomen is highly movable, it allows me to know that there can be a movement of the location of the body either closer together or further apart based off of the position that the person's body is in at the time that they're sustaining the injuries.
You mentioned earlier that having access to the measurements of the depths would aid in your testimony. And let me ask you first, in addition to looking at measurements from Dr. Cruz of the depths of these wounds, did you have access to measurements that Dr. Cruz took of the distance between the wounds?
Yes, she had those in her notes, and she had, I think, all but one of them from her notes were in her autopsy report as well.
And was that information you took into account in your analysis?
Yes, it was.
Why?
Because understanding that information aids in understanding and coming to conclusions about how this set of injuries might have been sustained.
Would looking at a demonstrative of the photographs of Ms. Mullis's wounds with some of those distances noted on it, would that aid in your testimony?
Yes.
All right, at this point, Your Honor, I'm going to show the witness a demonstrative, which we provided to the state to aid in the witness's testimony.
And as I understand it, that's been reviewed and there's no objection, is that correct?
Yeah, correct, Judge. Yeah.
All right, thank you.
Are you able to see the demonstrative in front of you, Dr. Hammers?
Yes, I am.
And what is the demonstrative that you're looking at show?
So this shows the injuries that we just saw in the previous picture, similar orientation and view, but has added colored lines and measurements between the wounds, kind of in a order from A to B, B to C, C to D, etc. And it shows the measurements that Dr. Cruz made and documented of the distances between those wounds that are the actual numbers in inches.
Just one moment, Your Honor.
Cause we're living in a world of fools, bringing us down, when we all should let them be.
Hey, Your Honor, I'm going to show the witness a slightly different demonstrative, which I believe the state has also seen. Dr. Hammers, what does the demonstrative in front of you show?
So this is an image that shows wounds.
Congratulations, you should have had at least 21. But I was sleeping, sadly, or else I would have been there talking about how bad you are at the game. If any of you like not sleeping and you just want to hang out a place where the chat is as nice as this, go check out Lefty. He plays a video game. He doesn't say anything. He's just annoying. You can see him on screen. I'm sorry. But the chat is always quite fun to hang out in. And sometimes he'll say something, but you can turn off the volume.
B through F, as well as that small abrasion. You're not able to see wound A on this picture because it's a little more toward the right side, but this is a more straight-on picture of Miss Mollis's back showing 5.
I am 4-time Miss Universe winner, so no one can do that. Marissa, can you find a link to Lefty's channel? I appreciate that.
Of the 6 injuries, showing those lines again between the injuries with the measurements that Dr. Cruz took. But this time it also, next to the large black letter that is the wound that Dr. Cruz designated and that we've kept for this discussion, it shows the size of the wound as she measured it in parenthesis, and then the depth of the wound, meaning how far or long into the body that she measured the path of the injury going.
And so does looking at this diagram help you tell us, help you review for us what the depths of these various wounds were?
Yes.
Can you, I understand we can't see wound A on here, and we'll get to that in a minute, but can you tell us what the relative depths of wounds B through F were on Ms. Mollis's back?
Sure. So wound B went 6.5 inches deep. Wound C went 3 3/4 of an inch deep. Wound D went 2 inches deep. And wound E was 6 1/2 inches deep, and wound F was 3 3/4 of an inch deep.
So B and E are the deepest wounds?
Of these 5, yes, those are the 2 deepest wounds.
All right, and which is the shallowest wound?
Wound D at 2 inches was the most shallow.
As an aside, I mean, looking at the measurements here between the wounds, for instance, did Dr. Cruz mention that the distance between wound B and wound C was 3 inches?
Yes, she did.
Does that mean that if wounds B and C were sustained at the same time, that they were 3 inches apart at the time an injury was sustained?
They may have been, but not necessarily based off of the position of Miss Mollis's body.
Can you believe how Auntie Bev takes breaks just as a critical info from defense is being presented? She's so biased. She looked great in orange. She won't ever be in orange. She's a judge. She has a very high level of judicial immunity. But yes, she has some funny places to take her breaks. But again, Alessi had 45 minutes left. I don't know if it's the right way to cut him. Maybe should have done it before he started up on the next part of it. But hopefully she'll let him finish today, and then Brennan will stand up and say, well, clearly I didn't say all of that, and it was a mistake by the court reporter. Got the response to my doubt rule 33A1 rule of professional conduct. Yeah, it's if you lie to the court.
Body. And can you explain why the position would impact that?
Sure. So with the torso and specifically the back, a person is able to either hyperflex or hyperextend. So in hyperflexion, they would be kind of like pulled forward with their shoulders forward, maybe bent forward, and hyperextended, they would be back, like with their shoulders back, their back arched, maybe their neck back, or even twisted, bent to the side or rotated to the side. And so those positions are going to change the distance, the actual distance at the time of the injury between those 2 injuries. So it could be that the injuries were sustained with the body at 3 inches apart, or it could have been closer or further away.
Does the fact that someone's back, as you've described, can move and twist, does that mean that it's not possible to draw conclusions about the pattern of the wounds, given that those distances might change?
No, you can still make some hypothesis or draw similarities from the wounds, both from all of the measurements that we've talked about so far.
All right, I'm going to show you an additional diagram. I'm going to show you an additional diagram that adds in wound A to these measurements. Would that aid in your testimony?
Yes.
All right. Is what you're looking at in this demonstrative the picture we've been looking at with measurements of wounds B through F, with some measurements between wound A and B added?
Yes.
And where wound A on the left side would be under Ms. Mollis's armpit in an area that's between her side and her armpit, correct?
Correct.
And that's what's depicted on the other photo?
Yes.
Okay. Can you tell us what the depth of wound A was?
So the depth of wound A was 6 inches.
All right. And what was the relative distance between wound A and wound B?
It was 4.5 inches.
And I want to make sure that what I said was clear. I think I may have said that wound A was on the left side. Would wound A have been to the right of wound B on this picture we're looking at on the left side of the left of the two photographs?
Yes, in the left of the two photographs, the wound A would have been toward the right, kind of between the side of the body and the arm.
As part of your, as a forensic pathologist, as part of your evaluation of injuries, are you trying to think through the position that a body might have been at the time that a certain pattern of injuries occurred?
Yes, so part of my analysis, if I have no indication of what may have caused these injuries, would be to think of them individually or as a group or groups to try to come up with an idea of what type of object or instrument could have caused this. And then if an instrument is posed to me as either known to or likely to have caused those injuries, I would then analyze the injuries with that object in mind, trying to understand if it's possible to have this injury, set of injuries caused by that object.
All right. In this case, the materials you've been provided indicate that there was an object called a corn rake that was involved in these injuries?
Yes.
Did you, as part of your analysis, have an opportunity to examine the corn rake at issue in this case?
I saw photographs of the corn rake.
In your mind, based on everything that you reviewed, is there any question that wounds A through F were caused by Miss Mullis's body coming in contact with that corn rake in some way?
From looking at the injuries and from all of the information that I reviewed, the injuries are consistent with that, and I did not see anything where that was debated that was the object that caused these injuries.
Thinking about the corn rake that we're talking about, do you know what the distance between the tines of that corn rake are?
So the distance between the tines is just shy of 3 inches, so it's almost 3 inches.
How do you have that number?
From a photograph.
Given, so in your analysis, understanding that the object at issue here is this corn rake and that you have these injuries on Miss Mullis's back, in your opinion, is there a pattern to the injuries on Miss Mullis's back that we're looking at?
There is, yes.
And what is your opinion about what that pattern is?
My opinion is that there's 3 injuries that you can cluster together that have similar features, which is A, B, and C. There's 2 injuries that have similar features E and F that you can cluster together, and then there is wound D, which is kind of on its own and a little bit separate in its orientation and features.
How are you able to determine that A, B, and C are sort of one set of connected injuries?
So looking at the spacing between them, so the wounds B and C has a 3-inch length between them, and wounds A and B is 4.5 inches. That 4.5 inches is over a curved part of the body, however. So in reality, a more narrow object could make both of those injuries at the same time if it's penetrating the body, particularly at an angle. And they also have a similar orientation of the wounds themselves if you face them on like the face of a clock. So they're all going in, all 3 of them are in the same orientation that way.
And so when you say they're in the same orientation, explain to me what you mean by that.
So when we describe injuries, we can describe them using the face of a clock. So if something is straight up and down, so in orientation with the head and the feet would be straight up and down, that's vertical. You could describe that as vertical, or you could describe it as 12 o'clock and 6 o'clock. If something is across the body from left to right, like straight across, you could describe that as transverse or horizontal, but putting it on the face of the clock, you could use 3 o'clock and 9 o'clock. And then anything else would be oblique, and you could place it on the face of a clock using, 2 o'clock and 7 o'clock, for example. And so looking at these 3 injuries, they had a similar oblique orientation on the face of a clock that Dr. Cruz documented in her autopsy report.
Is your opinion about the orientation of Ms. Mullis's wounds different from Dr. Cruz's opinion about the orientation of any of these 6 wounds, A through F?
No, it is not.
You also said that E and F are wounds that you would group together, is that right?
Yes.
And why is that your opinion?
So they're 3 3/4 of an inch apart, which is, again, pretty similar to what A and B and C are, but they have a different orientation. When you put it on the face of the clock, they're both the same, E and F, but they're different from A, B, and C, and they're different than D.
What is their orientation?
These were at, my recollection is 5 o'clock and 11 o'clock is how they were.
Yes, Karen Reed is at lunch for another 9 minutes, so I'm going to switch over there in a second. Yeah, this lady looks like she has more facts because the other one didn't really have any measurements or anything. She's just, yeah. Trust me, bro.
Described. All right, and you said that D is in a different group?
Yeah, so D had an orientation that was just one basically number off of A, B, and C. So it was just slightly differently oriented than A, B, and C.
I want to take you back to Exhibit 573. Sorry, dollars. All right, we're showing you Exhibit 573 again. Now, Exhibit 573, is that the same image that appears on the left two of the photos that you were looking at a moment ago that is marked?
The ones that we just looked.
She alluded to it, saying there are other motions, but we can do them next week because she doesn't want to go too late. Bev doesn't work till 4.
That was a straight on of the back. This is from an angle.
All right, and let me go back and show you the last photo, the second to last photo that we looked at.
Okay.
While we're doing that, let me actually ask you, well, let me show you this exhibit first. I want to ask you a different question. We'll come back to this. You mentioned that wounds A and B looked different than the other wounds on the back. Can you explain why those, or how those wounds had a different appearance?
Sure. So wound A, even more so than wound B, had a much larger.
Oh, we're on break. That's why I put the chyron on, that we'll be on break. We'll switch over in a couple of minutes.
Overall size, and around the wound, so the skin around wounds A and B had additional abrasion and contusion of the surrounding skin. So in addition to the wound being larger, there was also injury to the skin around the wounds that was different than the rest of the injuries.
All right, I'm going to show you Exhibit 561. What does Exhibit 561 depict?
So this is wound A on the right side of the body. This shows the medical therapy at the top, which is the chest tube that was inserted at the hospital.
And then, just to interrupt you, the chest tube is not wound A.
Correct, that's the medical therapy. And then below that is wound A. So there's a hole in the skin, and then there's a sort of pink to red to kind of dark, maybe purplish color around the skin around that wound A, and that is the abrasion and contusion of the skin around that wound.
So is the appearance of wound A different from the appearances of wounds C through F?
Yes.
And
here's what I found.
What specifically about the appearance of wound A in this picture was different than wounds C through F?
So rather than just having a little bit of injury around the...
He is convicted and sentenced to life in prison in 2019. Had an appeal denied in 2021 or 22. And this is a civil case to try and prove that there is sufficient evidence that he should have had an appeal, but he hasn't been granted an appeal. And I don't know why this is... This is annoying listening to, but we should be back in a couple of minutes, so I'll just keep it on in the background. They're on break. It's almost noon. It's almost 2 o'clock. Well, it's almost 8 o'clock. But no, he's already had his trial. He's found guilty. He claims that his defense used a defense he didn't agree with. That defense was that, yes, we admit she was unalived, but he didn't do it. And now the defense is, it's an accident, she fell on the rake. The problem with that is there's 5-6 holes from a 4-prong rake. That could be a big hurdle to overcome. Plus, she's found on her hands and knees. And so far they haven't really gotten into how it could happen, and I thought it would be really interesting, but it's so slow going. It's really, really, really going slow. Because yesterday they had 2 witnesses. They spent maybe an hour on one of them and then 4 hours on another one, and we got nowhere. And today of course, we've been covering the Karen Reed stuff, but the first 2.5 hours we saw, yeah, she has better measurements than the other one, but I still don't know where we're going with it. I don't know if he was given bail. I didn't watch the first trial, but he was arrested very short after her. I think they put a bond on 2.5 million on him, but I could be confusing it with another case. Yeah, it's don't get why they haven't turned the feedback on, because that's 3 minutes. Just got some messages. Sorry. I just don't, because apparently they should be giving us new evidence that should show that he is innocent, and that's why he should have the new trial. But so far, it's just been asking the Emmy if she did her job the correct way, and if she looked at all options, and a first responder, how he was reacting when she was at the scene. And I don't know what, if any, that has to do with anything. Hey, Mr. Goatman.
That's twice now my power's gone out today.
Well, pay your power bill.
After last month's power bill that I had to pay, I should be getting free power for the next 3 years, but whatever. Last month got a little pricey, power bill.
I had some ravioli. I could explain how it can happen, but I don't type fast and well. I am an injury expert, though, according to my doctors. Yeah, but I could. The problem is, when you have 4 prongs and you have 6 holes, 2 of those prongs must have left her body and gone in another way. And if you go into Discord and look at the autopsy photo, I have a hard time seeing how it would line up, especially because she's found with the rake in her back, sticking out over her head. So
I can't figure out how he only only a couple of the prongs went in. You would think.
Yeah, that's my problem as well. If you
doesn't make sense to me.
If you have 4 prongs, 6 holes, it must have been out and then in again.
But only part of it, right? And where they're at on her back, it seems very strange to me that they could have done that.
Yes.
A 2-hole puncture and not gotten all 4, especially when she's talking they went in 2.5 to 6.5 inches. How does that? How?
Yeah, and I think that's the biggest problem for me to overcome is she fell on it twice, and it came out and came back in so deeply. But if it's 6 inches in, how does it only 2 of the prongs, or however it? I don't know. I just know that I think he was effed because of his defense the first time, admitting that
for sure
they believed she was unalive, but it wasn't him. And then they're coming back and say, well, we don't believe that really anymore. It's more like she fell.
What did you do, man? What's up with all this?
It's as you can see, it's Law and Crime.
Way to go, Law and Crime.
I don't know why they put this up, because We're supposed to be back in the courtroom. Maybe they have one of their fits where they just see if maybe Boston 25 has the live feed. Nope. CBS Boston, they're showing another case. Where's Boston 25? That's annoying. Nope.
I made bean and ham soup yesterday in the crock pot. I had leftovers of that. It was yummy.
Well, leftovers is always good.
Oh, yeah.
Yeah, it's Smart TV has OnlyFans, so I'll go back and do it on Lawn and Crim. They normally have better audio, but we'll have to live with the. Imagine court being back late.
Shocking. Shocking. They don't even have the jury to blame on this one.
Bev probably needed a little claw for the law. Karen died in the courtroom. They got lunch and now going to dismiss charges. I'm pretty sure the Commonwealth would still try to try her even if she passed away.
Oh, yeah. You think a little thing like Karen passing away is going to stop Lally and Brennan? I don't think so. What do you mean you don't have a defendant?
No, there's been a lot of lies in this case. They lied about material evidence. So, yeah, Court TV is just on ceiling fan. So nothing's happening in court. We're not missing out on anything important. But it's really annoying that it blinks.
Good thing I don't have epilepsy.
But 45 minutes roughly left for Leslie. Now he's going to go in talking about the law. Someone shared the rule of professional conduct or whatever it's called, 33A1. And it was about being truthful to the court. And we can say a lot, but Brennan was misquoted by the court reporter because he left out material parts of the email. And I like that that Alessi said, well, it was probably a mistake. Hey, Nick.
Hey, Nick.
Well, Paul O'Keefe's wife haven't been to many hearings. So
she doesn't come to a whole lot more of them either.
So she's probably out getting a glazed donut or something.
Oh, dirty.
It is just past 2.
2:05.
He said they were undated. He could have had a wrong copy. He claimed he got it from the Commonwealth, which from the state he didn't. He got it from the defense, and he didn't read the email verbatim. So at least 3 misrepresentations in his testimony last Tuesday.
She better be as mad at Brennan as she was at the defense last week. I want to see shaking. I want to see fury, rage, anger.
Yeah, you
potential dire consequences for the Commonwealth. All that. I want all of it, Bev. Bias.
Yeah, I want exactly the same amount of anger that you had for this defense last Tuesday.
Have it?
Yeah, I have a copy.
You are unmuted.
We're back in session. You may be seated.
All right, Mr. Lessie, why don't you go ahead and continue?
Thank you, Your Honor. May it please the court, I first want to thank Your Honor for the generous amount of time you're according to me.
Need to thank me. Just go right ahead, sir. And take your time, Mr. Leslie. I shouldn't have cut you off. I appreciate that, but take your time. This is
He
important.
really needs to stop trying
So, Your
to
Honor,
be nice to
I
her.
left off with
She hates it.
page 58 of tab 8, which is last week's hearing. And what I want to do is to go to, because I'm going to go backwards ever so slightly because it's an important segue to returning to page 58. So I referenced the court to page 57, line 11, where the Commonwealth said, response in quotes, "Hi, Alan, substance to our conversation on Wednesday, the U.S. attorneys," and he's quoting according to quote, the, and it's good to have, if Your Honor can be, having tab 1, which is the March 22nd email, because I'm going to compare and contrast tab 1 to where I am on page 57. And Your Honor, I'm sure will recall that I dubbed tab 1 the pause email.
Yes, so I have them, and rather than me going from tab to tab, I'm going to use my copies. So go right ahead.
Perfect. So I'll just refer to them, Your Honor, as the date. Is that what's best for the court?
Yes.
Okay. So the March 22nd email, I've dubbed the pause email.
Yes.
And because of obvious reasons, and it's got the word pause in there. And the pause is a very, very important concept because the pause is the stopping of communications before really things even got underway. It was before there was even an agreement, an engagement, et cetera, et cetera. So compare that, please, to the quote, purported quote on page 57. 11, "Hi, Alan, subsequent to our conversations," and he's quoting purportedly this email. "On Wednesday, the U.S. Attorney's Office asked me, are there any further conversations? Did we receive additional information from their office regarding how our involvement will move forward?" Your Honor, there's not one mention of the word pause in that quote. The word pause was left out of that quote. That is the foundation of that email. And it's not merely semantical, it's the cutting off of communications. And it's unfortunate that that pause was not quoted on page 57. Now back to page 60, or excuse me, back to page 58.
Yep.
And this is where I left off. Line 2, now this is an information provided by the defense in reciprocal discovery. This is information provided by the federal government after numerous requests, TURI requests, and in assistance, the best I can to get as much information as I can. Defendant provided an outline of the questions and answers for direct examination. So this is where I left off. That's not correct. It was Dr. Wolf that provided the outline. It's really important when we're talking about a collaboration, et cetera, communications. That's not accurate. And Your Honor, what is important to note, Your Honor asked about when did the defense provide the discovery.
And you told me the 12th, right?
And I want to correct that. I was off by a day. It was February 13th.
Okay.
Because it's important to try, I clearly understand, to be as accurate as we can. I'm the one creating the standard that every word counts, every date counts, so I want to try as my best. I may get some things wrong, but I want to try my best to be accurate. So what I did during the break is I went and asked for the email that sent that request. So it's the email from the defense to the Commonwealth providing the discovery.
Okay.
And the email is dated February 13, 2015 from, and I've got extra copies if the court wants it, if the Commonwealth wants it, from Evelyn Arellano, and she is an employee of the Worksman Jackson firm. And it's important to who it's addressed to. 2, the first name on it is Hank. That's the first name on it. To Hank, Mary Ellen, Adam, and 9 more. Good afternoon. The Dropbox link below contains ARCA reciprocal discovery. Please let me know if you experience any issues accessing the files.
Okay. What time of day? Because if it's California time, it might be different than what we have here. But
It probably will be, but I don't know what time of the day. I'm going to ask the team if they can access what time of the day, because I don't know the answer to that as I stand here.
okay. Go right ahead.
And so, but suffice it to say that the hearing was on the 18th. So it wasn't like it was a Friday and then we're back in court on a Monday. My best recollection, the calendar will be the best evidence, is that this was toward the middle of the week, right? But in any event, let's say worst case scenario, it was dispatched at 9 o'clock at night, California time, which would be midnight Eastern time. And let's just...
If we can, because I'm looking at a
Absolutely.
calendar.
What?
If you don't, I thought you may have had it. We can move on.
What happened to the audio?
Approximately 6:30 in the evening, it was received by the Commonwealth.
Thank you.
And is that, may I ask Your Honor, if that's Eastern time, 6:30?
Eastern Standard Time.
Thank you, Mr. McLaughlin.
And Your Honor, it was a Thursday.
I'm sorry.
It was a Thursday.
Okay, thank you.
Hey, Chrissy.
So also,
Hey, Chrissy.
in big bold letters, at least on the printout, the subject is Karen Reed ARCA reciprocal discovery. It's not like it was buried what was being sent. I mean, this was a lot of things, but it's right there, ARCA reciprocal discovery.
Was it just these pages that we've been talking about, or was it a lot more discovery?
May I confirm with counsel? I think I know the answer.
It was just the pages, Your Honor.
Okay, thank you.
So it's not like ARCA is amidst a sea of other topics, right? This is the driving force of the email. And so, Your Honor, the question, and I'm going to keep moving on, but the question becomes...
Yes, he just gave the date, and Miss Little confirmed that was the date it was sent.
And I'm going to ask it more than once, but hopefully not too much. How is it that the Commonwealth on the 18th understood incorrectly? I think it's undisputed it's incorrect.
Is your audio messed up as well?
Yeah. Yeah.
It had
they
that blink,
switched
and it
mics or
sounds
something.
like it keeps going through two channels at a different time.
They did something.
Oh, it must be. Yeah, I can see there's like a discoloration over here, so it's the feed.
That they got these materials from the federal government. We don't know the answer to that question, but I respectfully submit it's an important question. Was it an honest mistake? Was it just as...
No, as I said before, 2025. It was sent a week before the last hearing.
It happens sometimes in lawyers working together. There's a lack of communication. There's a miscommunication. Is that the explanation? But I think truth and justice on these topics, since we're being so exacting and appropriately so, we should have an answer to that question. So we move on. We move on to page. So there we have on page 58, we have another incorrect statement. We have two of them right up off the top. And then we continue on.
Oh, I misheard it because I heard it as 2025. It's 2025. They sent a Dropbox link at the 13th at 6 in the evening Eastern Standard Time saying this is the Arca discovery. So they had 5 days to prepare for the last hearing.
Page
And
59.
they sent the
Your Honor,
discovery within like 24 hours, right? Almost.
No,
27
that
hours?
was the discovery. That was the link. It was all of this we have been talking about now that he claims he got from the Commonwealth, from the state. They gave him a Dropbox link with all of that in it. The 13th of February 2025 at 6 p.m. Eastern Standard Time, which is a Thursday, and to prepare for the Tuesday meeting where Hank says, I got this by way of a jury hearing. I didn't get it from the defense. The defense never disclosed it to me. Bev blew up, ended the meeting, and we are here today. So all of this was provided, and that was the email that was provided saying, here are the links.
understandably, says the court. What is the date of that? Mr. Brennan, it's not dated.
When I said it, what was I talking about?
I believe, Your Honor, you were talking about the outline.
Just give me a second. Let me make sure.
And Your Honor, if I may, I want to give you the second, but the basis for that answer is page 58.
636.
Line 7, where the statement is, and what follows is all about the outline.
Okay.
So, Your Honor, appropriately and understandably says, what's the date of that? Here's the answer Your Honor got. It's not dated. It's not dated. Now, let's please just go back to tab. We're talking about the outline. Let's go back to the outline. And we can pick either one. I'll pick perhaps the most probative one. I'm not going to refer to the tab because Your Honor says you have these. This is the June 23rd email from Daniel Wolf. I'm just...
If you, as far as I remember, I worked all of those days. No days off. No days off.
Pausing from Daniel Wolf. I'm just pausing to make sure you're... Thank you.
It's what I refer to as a script, right? That's what you're referring to?
That's what Your Honor has referred to it as.
So that itself is not, I understand it's with the email, but it's not dated.
Well, Your Honor, I was going to get to that, but there's context for that.
Okay, go ahead.
The context, you're correct. The outline itself is not dated. However, the attachment, keep in mind, we produced these materials.
Okay.
So we deal in e-discovery all the time. And when you look at the attachments, everybody relies upon the attachment line, especially if it's a Word document. So it's wolf_direct.docx. So you know this email has an attachment. We fortunately have a file named direct. Your Honor has referred to it as a script. There is no other document that was produced that comes anywhere near close to this being the direct. So I don't believe there's any reasonable basis other than the other email on the quals that came the day before, 2 days before, the June 22nd, which has the same attachment wolfquals.dcx.
Can I ask you a question just
Yes.
because I don't understand? So what I have separately is the script and then something saying qualifying the expert. Is this all one document?
No, Your Honor.
All right,
And
so
I appreciate the question.
What
So-
is the date of the, so you're saying what I refer to as the script was sent on the 23rd?
That is correct, Your Honor.
What was the other one?
The other one was sent the day before on June 22nd.
Okay.
I'm just going to give the name that the email has. I think it's wolf_quals document. Okay? So there's two emails. One's just the quals. The other, respectfully, Your Honor, I know what you're calling it. I'm just going to call it what it says.
Sure.
The title is direct. So it doesn't matter which one you're talking about. To me, it doesn't matter whether there's a date on the actual Qualls document or the direct document. We produced them in this fashion, and I believe the only reasonable conclusion is that the outline is what is sent under the June 23rd email. And Your Honor, the reason why I persist in this is because if Your Honor goes and looks at the, and this is important for the context, if you go back to the June 22nd email,
Okay.
the last sentence is, I will try to work on some direct examination questions tonight. So
Yes.
you know,
This is Alessi. He was the guy who first joined. Now we're waiting to see if Betterwell will be allowed to join as well. He is from New York. He is kind of the technical guy, and he is really good. He just have a tendency to try and be too nice to Bev, and it's kind of getting on her nerves now.
that when the direct comes in the next day, I think the only reasonable conclusion to make is that that direct outline was created after the 22nd, or on the 22nd or after, and certainly by the 23rd. So that's what the Commonwealth had in terms of the information. So in conclusion on this point, but I think an important one, it's not dated, but here we go back to, Your Honor, the TURI request is a recent February response, but they, and I'm assuming the Commonwealth meant the federal government, send random documents. There's no real accounting. But there is an accounting on the face of the emails that I
I'm gonna
just
actually
went through.
hold that thought. I just have one other thought about
Yes,
it.
please.
So we're talking about Saturday, June 22nd, what was sent as an attachment with the email, and Sunday, June 23rd. So this was before the witnesses testified, right?
That's
and you
correct.
are saying that this was disclosed prior to the February 18th hearing. But was this disclosed prior to the witnesses' testimony?
The answer is no, Your Honor.
All right.
The
I
answer
just
is
wanted
no.
to be clear. That's how I see it. I just wanted to give you the opportunity to tell me if that's not accurate.
No, that's 100% accurate.
Okay.
And I'm going to get to that. To me, that's a Rule 14 issue, not a candor to the court issue.
Okay.
So now, if we could please go back to page 59.
I'm there.
Thank you. There's no real accounting. Now, I'm not saying that undermines the conclusions of ARCA. There's another okay, so to speak, with ARCA. Or I'm not saying they're not qualified witnesses, but it certainly shows some bias. I went over a lot less of it, blah, 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 blah. Now, here's the next one. Another comment. He's quoting, would it be fair to say, because you had a lot of nighttime visibility work, your cases frequently involve pedestrians? Now, and then yes, unfortunately, there is a direct correlation between the time of day and pedestrian facilities. Statistically speaking, most pedestrian facilities occur during the evening.
Fatalities.
I'm sorry, thank you. Fatalities occur during the evening and night hours. End of quote. And then the Commonwealth adds a commentary. That would have been nice to have. They had it. They had that. What's the objective evidence that they had it? I go back to the voir dire. They had it 4 months ago. 4 months before last Tuesday. They had it before we turned over the discovery. And what's the objective evidence that they had it? Is the voir dire of June 18, 2024 of Dr. Wolf that I referred to earlier, page 167, line 12. This is Dr. Wolf. Well, to give you an example of that, so I do a lot of nighttime visibility work where, for instance, let's say a pedestrian is coming down to the roadway, etc., etc. But that's not the end of it. They had it twice. So if we go to the direct testimony of Dr. Wolf that I referenced earlier, this is my tab 6, but I'm going to stick with, it's the date of June 24, 2024 of Dr. Wolf. Page 36-65.
Okay.
Line 22. This is Dr. Wolf's answer. Several hundred, period. As I mentioned earlier, you know a great deal of my work is in the field of lighting and visibility. Here comes the key points. So there is a direct correlation between time of day and pedestrian incidents. We see a rise in the evening and night hours just due to drivers having a difficult ability to try to perceive and recognize individuals. So I certainly see a lot of pedestrian collisions in my casework. There it is.
I did see that.
So let's go back. That's misstatement number 5. It would have been nice to have, I agree, it would have been, and you did. Twice. Next. Reading on the same page 16, he's quoted. So, my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. That's the end of the quote, and then the Commonwealth takes on with a commentary. Pretty important stuff in this case. I agree, and you had it twice. And then he comments, if you don't want me to say this, that's fine, that's fine. Then the commentary from the Commonwealth. Shh. And I went back and watched the video. Shh. Don't tell them. I'm sorry? What do you mean don't tell them? You were told twice. In the voir dire and in the direct. In the direct it was just unvarnished. And here's the important part, Your Honor, another important part. Mr. Jackson drew that out on direct. Not only was he not shushing or hiding, it was Mr. Jackson's question that drew that out. So here you have Dr. Wolf trying to figure out, is this something that we should say? We're not. And honorably, Mr. Jackson, no, we're going to hit it head on. Mr. Jackson draws it out, puts it right on the table. 4 months before February 18th, and the whole world heard it live.
Yeah.
Next, if you could, Your Honor, please go to page 60.
I lied.
I'm sorry. There's another point at the no. Let's go if we could. I don't want to take the lesser significant ones. I want to focus because there's many of them. I want to get to the more significant ones. So then we have on page 60, line 2, and then a bill from ARCA to the defense for $23,925. That's not a trial by ambush. That's getting duped. So I, Attorney Brennan, didn't know any of this. But I've tried a few cases, I've been around the federal court a bit, I know how it works. So what is the import of that statement? I didn't know any of this until I got it from the federal government. And we're talking about the invoice. No. You know about it because the defense, after the certificate of completion of discovery, in 6 weeks before the trial is starting, the defense affirmatively turns it over and does it not buried amongst several discovery documents, but essentially a tailored discovery response that's titled Karen Reed ARCA Reciprocal Discovery. That's not a very good way to try to cover up something.
Oh, it's not buried in 2,000 pages.
There is no statement about the date of the invoice on February the 18th. So people are left to wonder, when did it occur? When was this bill stated? The date's important for that invoice. Then there's a lot of statements made, sometimes parties pick sides, agree, blah, 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 and then it allows the ability of one side to use ghosts. They create illusions and shields and say something's there and something's happening, a federal investigation, and this person, and then this happens. Your Honor, I think it's important for the defense to be allowed to speak to the very words that were used against us. Ghosts, illusions, shields. That's what we're accused of. I choose to try to comport myself and practice a certain way and give people a little bit of the benefit of the doubt. But if we're going to be talking about ghosts, illusions, and shields, I don't think it's the defense that's creating ghosts, illusions, and shields here. The illusion, and it's more than an illusion, it's a statement of fact, is that all these documents came from the federal government. It's not an illusion, it's a statement of fact. Statement about federal investigations that were these are not ghosts, we're not creating it, but I'm not going to go any further on that topic. But the ghost word was used, in my view, the way I read it was, these topics we're making up, right? And we're hiding things, shield, right? We're shield, I interpret it as, you're preventing us from getting this information, defense. And this is 5 days after we had provided it. Next line. Page 60, line 13. I don't care if the ARCA witnesses testify at trial. I'm very pleased to hear that. I don't care about their opinions. I'm pleased to hear that too. But I care that it's unfair, imbalanced, and hidden. Hidden. And that is based upon the faulty premise that we didn't turn it over and the Commonwealth got it from the government. But there's no other way to read it. And the Commonwealth, like the defense, is entitled to discovery. I agree with that. The Commonwealth is entitled to discovery, and you got it 5 days before February 18th. Now it comes to the court. All right, I'm going to take a recess. And I certainly, Your Honor, am not going to be so officious as to even delve into why Your Honor wanted to take a recess. But I will tell you what I thought and what I believe occurred. Your Honor listened to a completely counterfactual rendition of some of the most important issues of the day and, frankly, of the moment in this trial.
Yep.
And the reason I got a little bit of an inkling is because what happened when the court came back. So what I concluded, after all of this, the court saying, after all of these inaccuracies and piling on of inaccuracy after inaccuracy, there's a cause and effect in my mind between the several and serial inaccuracies, the break right in the middle, and then the court comes back. And I understand, I don't really, and I'm going to get to this, see the justice in terms of this presentation to the facts. And that's what we're going to be talking about, facts and representation. So here's what the court says. After hearing all of this, and I want to underscore something, Your Honor, and I'm not going to get too lofty with due process and notice, but it's important to hit some of these points. All of these topics that were raised were not in a motion. They were not in an affidavit. And I've had this issue before with other motions under what's required in an affidavit.
In this case?
No,
Or
I'm
you say
talking
generally, you've had this issue in other cases, or do you mean?
Other cases, Your Honor. With there not being an affidavit, right, where someone's got to be very, very careful about what they say. But in this information that Your Honor had to be subjected to was not in anything that we had notice of, these topics. We had no notice that this was coming. There was no affidavit that someone had to swear to that all of these facts were correct. And Your Honor takes the break, so we didn't get an opportunity to stand up and say, what I'm being given the very fulsome opportunity to say today. So Your Honor comes back. All right. So the Commonwealth just provided the court with information, and I don't even want to repeat these words because it almost pounds on to the prejudice to the defendant, but Your Honor well knows what Your Honor said, but it certainly had the words in there that were very, very difficult on the defense. And you say, so for that reason, right? So the Commonwealth just provided the court with information that causes me, and then it goes on. So it's clear that Your Honor was relying upon that information, which was only given verbally, right? And you say, so for that reason, I'm going to suspend today so that we meet again, and then the rest will be back in here. Unfortunately, that's not the end of the prejudice. So what happens is, all of a sudden, and Your Honor basically said, and this is all so key, so you said, I'll see you in a week from today, and then Your Honor continued on page 61, line 12. And Mr. Brennan, where the federal authorities have been kind enough in the past to allow me to have copies of everything, would you be kind enough to call over there and check with whomever you were dealing with to see if I can, in fact, get a copy of everything that you just read? It was only then, when the the reality hits, that you're looking for the backup for what's being said. Up to this point, Your Honor's understanding, all of this came from the feds and the defendant didn't turn it over.
And Hank let her go with it.
Does the Commonwealth stand up and say, whoa, wait a minute, I made a mistake. And Lord knows I've made mistakes before. They didn't stand up and say, a very significant mistake, my whole predicate for my whole presentation was, I had to even fight the feds to get this information. Lo and behold, I got it, and I've been duped, and I've been ambushed. Rather than saying that, and you know what, I don't even know if I would have had the courage to say it in open court, I might have asked for a sidebar and come up and said, Your Honor, my bad. You know, this is that. But that didn't happen. So what did happen? The Commonwealth says I can, and there's a brief chronology I think Your Honor should be aware of. So the defense is still not able to get up, but the Commonwealth is continuing on. If I could add that right now, it will take me less than a minute. The court, okay. So the Commonwealth goes on, says the chronology is December 4th. We sent another two-week request, 2024. January 6th, we filed our notice of intention to exclude ARPA experts. January 30, 2025, the United States Attorney's Office sent a response to both ours and the defense request. Without any prompting, on February 6, 2025, the defense and the prosecution received an email from the U.S. Attorney's Office saying that the contract had ended with the ARPA experts and that if either party wanted to engage, the original materials are still protected. This was a change in position about whether the party could be impeached. On February 11, we filed a motion to exclude. February 13, the defense provided us the emails that I read. Buried in a chronology is, in the middle of the sentences, the defense provided us with the emails. I think I said, I'm going to repeat that, I think I said, the federal government, it was the defense. February 13th, they sent us the emails in the direct examination outline. I think I said. That was the whole basis for the entire presentation, was that the Commonwealth had to fight even the feds to get that. And then it goes on. We reached out to the federal government, but you know what was not said in lines 9 through 14? What was not corrected? It wasn't corrected that the invoice came from the defense. Just emails.
I thought it meant everything, but...
I don't understand how that conclusion can be drawn, Your Honor. You didn't say the defense provided us with all of the entire production. The defense provided us the emails that I read. There was no email with the invoice. The invoice was discussed as a separate item, and I can go back to it. When the Commonwealth was talking about it, they never connected it to the emails. So then we reached out to the
Because I received a copy of it.
Pardon me?
I think it's because I received a copy of everything that had been referenced.
Yes, but I'm going to get to the point about the importance of correcting misstatements, because 3.3A1, everybody focuses on the first sentence, which is, thou shalt not make a false statement of fact to a court. The second part of 3.3A1 is you get the opportunity to correct, you got to correct a material. And I've got it in front of me, but I'm just paraphrasing. I want to get to precisely. But that's why I perseverate this on this, Your Honor, because I trust that the court's going to hold everybody to the same standard. And so I think there is a proper inquiry. I don't intend to be officious as to what the court should do, but if we're going to start looking at comments of defense counsel, I believe we have to look at all comments. And again, I'm going to go back to my own view is this, being a lawyer in cases like this is hard. Being a judge in cases like this is hard. Mistakes are going to be made. So we go on into page 62, line 15. We reached out to the federal government again because I was curious about the changing position on February 6th that the contract was ended, but that parties could contact ARCA. Obviously, the Commonwealth is in no position to contact ARCA because that would naturally preclude the defense from retaining them. So we refrained and we will not reach out to them. This is really an interesting statement because you read it because that would naturally preclude the defense from retaining them, yet at the same time the Commonwealth for the fourth time has moved to strike our ability to use ARPA. So then the court goes on, all right, so the information that was provided to you, not from the federal government, so Your Honor knew at that point, I don't believe Your Honor had any basis before that to believe that it had come from the defense. I'd like a copy of it before you leave the courthouse. So I hearken back, Your Honor, to what I conclude drove Your Honor to make those impactful statements about, on the top of page 61 was the presentation of the Commonwealth that I counted had 10 misstatements, 10, before Your Honor caused the pause. So, coming to what happened then. The Commonwealth having not given us notice that this was coming, these topics, not putting any of these statements in an affidavit, we didn't have the ability to stand up. But I will tell you this, Your Honor, I greatly appreciated the week that we got, because I do believe that Your Honor intended that counsel be given, defense counsel and defense, a fair opportunity to go look at this. And that's the way I'll speak for myself. That's the way I took it, and I appreciated that. Because that's allowed me to go spend the time that I spent to try to do my level best to give the court an accurate rendition of the fact, because as an officer of the court, I believe that is a sacrosanct duty. And in a matter where the very issue is, what are counsel saying to the court and is inaccurate, I wanted to make sure I could do the best I can. Now, I may have made a mistake here or there, but I just want, and today, but I want to make sure that I recognize Your Honors giving us that week, and we've tried to take the best opportunity for it. So what happens? What happens after these 10 misdirections? The court's comments go viral. And I'm not saying this for drama's sake. I'm saying this for what has impacted the defense 6 weeks before trial starts, while jury notices are out in the mail. Those words, based upon the misdirections that your court had to endure, have gone through, and I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team, and whether it's intended or collateral damage. We've got the ARCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain. And this could have been avoided had there been an accurate recitation.
Should we do a quick poll and think, will Bev be fair and balanced, or will Bev be Bev?
We all know the answer to that question.
Yeah, he is putting on a great performance, but I have a fear that she'll say, yeah, it was a mistake. I'll allow it.
He's not wrong, though. He's not wrong at all. Hank got up and lied through his teeth, and then Bev wigged out based off of false information that Hank deliberately gave her. There's no way that was not intentional. The only reason that he recouped and admitted to the fact that he was wrong is because she called him out on it. She was like, let me see the Fed paperwork. And he was like, it turns out I don't have Fed paperwork. Otherwise,
yeah, but I don't have any address or mail, or I don't know. And why is Meatball Morrissey standing in the doorway? He has never been in this courtroom before.
I think he was trying to hide it first, too. Because
he was standing and someone slipped him a piece of paper.
Came up, gave him a piece of paper, so he moved over so that he was in camera view. I think he was trying to hide, got caught. And, okay.
Of what had occurred. And Your Honor, I don't know if this can be remedied. But it surely shouldn't have been exacerbated.
He's in the black, Morrissey's in the black suit standing by the door.
I would now like to move rather, hopefully, efficiently through the next step, which is to point to the Massachusetts rule and give the court my view, and I have to reference because Your Honor brought up something.
You don't have to tell me what you're going to do, Mr. Leslie.
I'm sorry, I'll just go ahead and do it. My apologies.
He is walking the thin line, and I'm thinking he's stepping over it. She's getting annoyed. He's thinking about that White Claw in her office. Can't motion for mistrial on this basis.
Maybe. Prejudicing jury pool?
Model
Jury isn't there. Then you could have had a mistrial because of Morris's hostage video.
Well, they tried to get a
This
mistrial
applies
for
to
Morris's.
every counsel in this
Morris's
criminal
It's bad.
course.
It's still bad.
A lawyer shall not knowingly. So there's the adverb of the mens rea, knowingly.
Who's sitting next to Paul? Is it one of the Bahamas chicks, or is it one of his side pieces? Is he serving up glazed donuts?
Make a false statement
Does anybody
of
notice him
fact
touching
or
his
law
chin?
to a tribunal. Or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So we all know the mens rea of knowingly. And this court knows it better than everybody, so I don't have to get into that. But in terms of make a false statement of fact or law to a tribunal, I don't see that on behalf of the defense, and I'm going to get to the new item of February 6th, because we haven't covered that. Your Honor brought that up today. But certainly with regard to the representations that I've gone through and the statements that were made, especially on June 10th, they were 100% true and accurate at that time. They were 100% true and accurate, and that's why I went through the note. Or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. And there's no real time period that's given for the attorney. But here is something very important, Your Honor, and I'm going to parse the grammar because it's what you do in construing the statute. It says, or fail to correct a false statement of material fact or law previously made to the tribunal by the lawyer. So the is a definite article. So it's like an adjective, it's a definite article. Lawyer is the noun. The lawyer refers to the lawyer who is perhaps made a false statement of fact or law to a tribunal. So it's sort of like you make a misstatement, it happens, but you got to correct them, right? And what they talk about is what do you have to correct? You have to correct a false statement, so it has to be false. It has to be knowingly false of material fact or law. And material has been interpreted in the context of 3.3A1 to be a statement of fact or law that caused a court or adjudicator to have relied upon it for a determination. It's essentially what the case law talks about, that it's influenced the judge's decision. So let's go back and even let's assume hypothetically that on June 10th there were misstatements made. It's not any misstatement. It has to be a failure to correct a material. You have to do it knowingly, and then you have to fail to correct a false statement of material fact. And in terms of what Your Honor had, it's the same lawyer that we're talking about in both clauses. And that is why I spoke about Mr. Yannetti's statements on the 10th, about what he knew, the fact that Mr. Jackson was handling the ARCA experts. So it's important to be analyzing what lawyer is saying what and which lawyer is to be making to correct the statements. So I go to the analysis with regard to 3.3A1, and as I said, I'm keeping separate 3.3A1 from Rule 14 because they're different analyses, as the court knows. But I want to hit one of the most important ones first. So there's not a false statement of fact or law to the tribunal, and I will stand here as long as Your Honor needs, if Your Honor feels differently based upon what I've said. Or fail to correct a false statement of material fact. So what I'd like to do, Your Honor, is now go to what Your Honor brought up today, because I was prepared for the June 10th. I wasn't prepared for the February 6th.
Do you need time?
I don't. I have taken the time. I appreciate the offer. But I would like to draw your attention, Your Honor, because like I provided context on June 10th, I think context for February 6th is important. And so what I'd like to do is to go back earlier than what Your Honor quoted this morning, because I think the context is important.
All right, so I have that entire transcript, like I said.
Thank
What
you.
page are you at?
I am starting on page 40.
This is the sidebar on June 6th or whatever it was.
Okay.
I start with line 1. Mr. Brennan, correct. I had a conversation with one of the two prosecutors I spoke to, and the only means of trying to obtain information they suggested was through a TUI request. I don't think it's the Commonwealth's obligation to seek discovery, part of Rule 14, but I wanted to assist the best I could, so I made an assented to request, and they responded with a letter. I think you received a copy of it. Do you mind if I share it with, no, okay, I received it, I sent a TUI response, essentially rejecting.
Are you sure it's not Morrissey? It looked quite a lot like Morrissey, but again, all us fat guys look the same.
I thought Morrissey had whiter hair, being honest.
So to be fair to the Commonwealth, Your Honor, this is February 6th, and they haven't gotten our discovery, right? They're just still trying to get it from the government. They don't have it from us yet. The court, all right, can I get a copy of this? If not, I just need, and then Ms. Bugalton, you can retain that copy. Thank you. So I'm not going to stay here and read it right now, but all right, Mr. Brennan, of course. And so inevitably, I'm not making any motion right now, but I appreciate that as the proponent of the evidence, defense's obligation to give Rule 14 discovery. I do not think, even despite their testimony, they've complied with Rule 14, and so the reason I forecast this was because I appreciate the April 1st trial date. If the defense, through no fault of their own, is unable to comply with the discovery, I think that we're entitled under Rule 14. I will at that point move to preclude the witnesses. So I think the important in this snapshot in time is all of the discussion that occurred on February 18th, and I'm going to underscore this. That presentation was not about the substance of what was in the email. The Commonwealth never had an issue with that.
Valhalla, we did like everyone else. We just spread a rumor that's false.
God bless it. At least we're correcting it now that we know, unlike Brennan.
I will make a video that's 10 minutes long where I will discuss why Morrissey was in the room, and I will make a lot of rumors, and I'll put it behind a paywall.
It was all about they had to get it from the federal government, and we didn't turn it over. Your Honor, obviously, has read the February 18th transcript. You can draw your own conclusions. But on February 18th, they were not on the issue of anything other than they thought that they didn't get the material from us. So now we continue on the court. Move to exclude the witnesses? Mr. Brennan, yes. The court. What do you say, Mr. Jackson? Mr. Jackson, I don't want the witnesses excluded. What do you want me to say? The court. I asked you all to try and work out something. The original protective order permitted that we can do in court anything that would rule. I expect you to say something a little more than that because, and Mr. Jackson, well, I'll wait to get this motion. The court, all right. Last time, Mr. Jackson, let me put it this way. The court, hold on a second. Last time we did voir dire of these witnesses, it seemed to me that that was the logical conclusion. I'd be able to get both sides discovered. We did that. That seems like a logical alternative to the exclusion, right? Your Honor knows what you're doing here. I guess we can wait and see if I exclude it on a motion to exclude. It just makes sense to me to set that up now rather than wait. I don't know when they do that, when the Commonwealth, based on their witness list, recalls them is that when you want to exclude it, so I sort of expected the defense would have some suggestion. If you don't, you don't. Mr. Jackson, and this is the key context. I can tell you this, the Commonwealth has exactly, this is an interesting and sort of different set of witnesses. The Commonwealth is saying that pursuant to Rule 14 and, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? And there's more context to that. I understand the import of these words so far. So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give to Mr. Brennan. He's got the same information I got and he got at the same time. What Mr. Jackson is referring to here is the disclosures from the U.S. government, not the disclosures that were going to occur on February 12th and 13th when we would get the certificate. We had the certificate of completion of discovery. We had 30 days, technically, to turn it over, but it got turned over on the 12th. So then it continues on, is important, the court, if I don't exclude it with other sides seeking a voir dire, we would not seek a voir dire because they're eminently qualified and there's no other discovery to give. They've provided. The federal authorities provided all the discovery that was attended to their analysis and testimony. So what we have in terms, Your Honor, this is important, I'm going to go right back to 3.3a. We have Ms. Little handling all the discovery. Mr. Jackson is not sorting through discovery, knowing what we got, not recalling what is in the possession from March 22nd, not recalling all of those items. That was Ms. Little's responsibility. So what happens? What happens is Ms. Little handles the production, goes back and does the diligence that she always does, takes all that material, sends it over to the Commonwealth. On February 18th, the defense did...
When Bev starts sighing like this, you need to speed it up.
...did not have the opportunity to address the issues that Mr. Brennan had brought up. But I now want to go to the statute and why it is important.
He said 45 minutes and he's way above 45 minutes.
The whole issue of discovery, the whole issue of batches of information was provided. And it was provided before, well before the 18th, before any of these issues came up. And Your Honor, respectfully, whatever the court may consider to have been an inaccurate statement, there is no knowing misstatement of fact. Mr. Jackson has never, I can tell you this from personal experience, I don't see him ever touch one item of discovery in terms of here's what we're going to collect, here's what we're going to turn over. Never have I seen it happen. I've spoken with him, he can speak for himself. That's not, so there's, even if you take any reading of February 6th, Mr. Jackson is focusing on and thinking the discovery is just what everybody has from the federal government. You've heard this many times. We can't produce more than the feds have, but we certainly, and I want to hit this head on, we certainly had those March 22nd, March 22nd, we had those emails at the time that statement was made. We had those. We had the direct. We had the clause. Not running away from that. But the question is, at the time Mr. Jackson made those statements, he's focusing on the government, and he's not knowingly saying in his mind, oh, well, I know we've got these emails from way back when, and so with regard to the shall not knowingly, there's no evidence of knowingly here, and I don't believe, respectfully, there can be an inference stated. When I looked at every single case where the court can look at the circumstances, so knowingly is not merely a subjective question of what an attorney has. The court is entitled to look at the circumstances, and the case law says should make an objective determination on knowingly. But the cases, and I can give them to Your Honor, the cases are legion, that the court cannot draw an inference from no fact to conclude it was known. They got to have some basis, and I'll give you some examples. What happens is if, let's say somebody, one of the leading cases is unfortunately a woman attorney who was in a bad divorce, she had financial statements, and she made misstatements of fact about her financial statements. And then the question became, did she knowingly know it? And what the court did, she said, no, I didn't know it, I didn't remember, I was under psychological stress. And what the court did was they went and they looked at the circumstances and saw emails and conversations she had with her accountant, where she clearly knew about those statements, and she told the court she did. So there's an example of you've got to have circumstances that the court cannot just jump from a lawyer said this to it's knowingly without some basis. That's why the mens rea is there. So and that's the February 6th, respectfully, that's the only aspect, and I went through all the others, that even comes close to a false statement of fact by Mr. Yannetti or Mr. Jackson. In sum, Mr. Yannetti's statements on June 10th, all completely accurate, all completely accurate. Mr. Jackson's eliciting of the direct testimony at trial, when he asked, have I ever asked you specific, questions, etc., that's completely true because it was Dr. Wolf who sent the questions in. So we now are left with February 6th, and I've given you that construction of the statute. My last point, Your Honor, is going to go to the Rule 14, which is, and I'm going to spend a very short amount of time on this. Now that the Commonwealth knows that the discovery came from the defense, I want to go back to, please, the February 18th transcript, because I want to keep separate analytically the ARCA from defense counsel, because obviously Ms. Reed is obviously very concerned about her defense counsel and her choice of counsel, which is going to be my last legal point. But in terms of what occurred, I want to go to and quote the Commonwealth on the transcript. I am on page 62, line 18. Obviously, and by the way, this is toward the very end of the 18th. Obviously, the Commonwealth is in no position to contact, etc. And what does that relate to? If Your Honor would go back to page 60, line 13. And it's a repeat, but I didn't get to the point here. I don't care if the ARCA witnesses testify at trial. I don't care about their opinions. But I care that it's unfair, imbalanced, and hidden, and the Commonwealth, like the defense, is entitled to discovery. Key line. So, if they can produce the discovery, I welcome ARCA. I want to repeat that.
You don't need to.
I'm sorry. Okay. So, my point is,
Bev denied 5 defense motions yesterday, or the day before.
5 of 10.
we produced the discovery.
She only
Why
allowed
is there
those
still an
that was
issue with
agreed
ARCA?
on.
These aren't my words. So I want to cover, before I get to the Sixth Amendment issues, the point that ARCA should be allowed to testify. We've complied with our Rule 14 obligations. There's no prejudice. They have the discovery. They've obviously had from the government a long time everything about ARCA. So I want to touch that base to make sure that either intended or collateral damage, that ARCA still gets to testify, because it's a key part of the defense here. Now to the Sixth Amendment. The United States Supreme Court has held repeatedly that a defendant's Sixth Amendment right to defense counsel of their choice is a root basis of the Sixth Amendment. Is it an absolute right? No, Your Honor. If counsel does something so egregious, does it correct it? The Sixth Amendment gives way to the need for the court to have candor, the need for the court to have decorum in the courtroom. So I understand that. My presentation today was as an advocate, of course, foremost, but also to provide all the information. So when Your Honor balances that sacrosanct Sixth Amendment right with whether or not there has been such a level of conduct that can be diluted or trumped. And I give Your Honor United States versus Gonzalez-Lopez, 548 U.S. 140, 2006. And in that case, there was violations of the local rule. And the court, and the court struck their counsel for that. And the U.S. Supreme Court.
Pro hoc vice, or was that not?
I'm going to get to that. The answer is
no.
The counsel. I want to be sure of my answer. Yes, and I'm going to read my conclusion because it doesn't say pro hoc vice, but I'm going to read you a part of it. It says, during the hearing, however, the magistrate judge revoked Lowe's, that's the attorney, provisional acceptance. So I believe that's the parlance of pro hoc vice, but Your Honor, I'm pretty sure, but I'm not 100% sure. And then the following week, et cetera, and then the revocation occurred. And yes.
That question to me makes it clear to me she is really trying to kick Jackson out. She's looking for everything to get him out.
It was. So the Supreme Court holding. Government conceded that Gonzalez's Sixth Amendment right was violated below, where the court denied pro hoc vice admission based on perceived violations of a local court rule.
All right, so pro hoc vice was not permitted in, it wasn't a revocation of pro hoc vice, there's a difference.
There is a difference, and both occurred in this case.
Okay.
There was both. Good point, both. So, Your Honor, and there are other cases when you have the Sixth Amendment, the fact that someone is pro hoc vice status is not the determining factor. The Sixth Amendment, in terms of legal dignity, is way up here, and then the pro hoc and the local rules are down here. It's only when the violations that undergird the pro hoc vice get repetitive, get more than repetitive, but go to things that are done that aren't corrected. And the issues that I've seen in my research, Your Honor, is that they have to be so, the violations have to drive so much to the core issues in the case. So like suborning perjury, putting people on the stand when they know they're wrong, literally having objective evidence that counsel had a document in their hands, almost literally at the same time they're telling the court they don't have it. It has to be that severity to trump the Sixth Amendment. And why is that, Your Honor? Because the court has alternative remedies for if they really think that is happening. And that is going to be my last point on the Sixth Amendment. The case law is replete with the trial court having to be careful that whatever they do, even if they believe there's a basis for some sanctions, that the court look to do them post-trial so that there is not for the trial the bleeding in of those issues into pretrial matters. And the case law, there's a mention of that all the time. It encourages the trial courts to make sure that they're very, very sensitive to that issue. I don't think the courts are being all that sensitive and empathetic to the lawyers, but I think what they're doing is appropriately trying to make sure the defendant gets a fair trial, right? And the defendant is not adversely affected by whatever the counsel may or may not have done. But I want to be very careful and clear, Your Honor. I'm not saying that is sort of like mitigation. I'm saying, importantly, the time I spent that there was not these violations. If any occurred, they were corrected. And on Rule 14, there's no prejudice. And therefore, I conclude, Your Honor, and I would urge the court. What happened on February 18th? There were some misstatements, and they weren't cured. I don't want this to turn into, and I'm not making this argument, I'm not making an equivalence argument. I'm not saying, okay, now let's turn to the Commonwealth. To the contrary, Your Honor, and I hope I've provided a factual and legal basis. I don't want any of this to continue. I don't want scrutiny of the Commonwealth statements on February 18th unless there's going to be continued scrutiny of the defense counsel. And I don't say this as a camouflage or a shield. We've got a lot to do between now and April 1st. The last thing I'm sure the court wants or anybody wants is to have something happen where that date can't be met because of whatever actions come out of this. My hope is that we all understand we make mistakes. Mistakes have been made clearly by both parties, and I would urge that the parties, not talking about the court, the parties take a breath, a deep breath, and focus on the matters that are important, which is how can we prepare to make sure that the presentations to the jury are candid, truthful, and most importantly, effective so that jury can make the best decision. There's a lot at stake here. The issues are momentous, and that is the focus of the defense. And I, again, conclude, but I would ask that I have, if anything said, if Your Honor has any concerns, I would really appreciate hearing them so I can take them on. Mr. Jackson, Mr. Yernetti, any questions Your Honor has, I would greatly appreciate it, my presentation notwithstanding. If there's still concerns with the court, we will take them on as best we can, and certainly candidly. Thank you.
All right, I appreciate that. Before I give the Commonwealth an opportunity to respond, I need 10 minutes.
All rise.
Jesus.
So, with that question about her Supreme Court ruling was regarding pro hoc vitae, she was intent on throwing Jackson out when she arrived in court this morning.
I don't understand how she possibly could. Did she not this morning? Did she not realize that Hank was a lying liar who lies? Like, did she really think that wasn't going to be outed? She had to have looked that up, right? She absolutely had to have, like, at least read the transcript for the voir dire. She had to have.
We've been following this case for 2 years now.
All right. It still boggles my mind. That's all.
Yeah, it's crazy, but it'll at the end of the day it'll still be bias Bev, and she will use the same cudgel to beat AJ. That she will say, no, I can't use that against Brendan. He misspoke. AJ lied to the court, but Brendan, that was he. Come on now, it's not like he changed his statement later and made everything clear.
No, he didn't.
No,
he didn't.
But she wants to get him out, and I don't know if she if she removes his pro hoc vitae status, can that be appealed before the trial gets going, and then the trial will be delayed? I have no idea if that's how it works. Because that will be denying counsel on a basis that allegedly the Supreme Court already ruled against.
She's pretty set on having that April 1st trial start date.
Yeah, because that they have that 1 year after the first mistrial, it must restart rule. It happened in the Delphi case. Interesting.
That was another one that was a little janky.
There's a lot of janky cases. Reminds me, Thursday I will have Julio on to talk about the Coburger trial, because I don't know anything about that one. So she'll come on and try and give me the less Twitterized version of the Coburger trial, because like any other trial, when there's a little bit of susness, it takes on its life of its own. Yes, but the council doesn't have the right to mislead the court, and that's what they claimed. She will claim that they did. The court reporter was actually mentioned in the motion to dismiss filed at the federal level, also at the SJC, because they believe that that guy who handled Farah, the cop who handled the jury, could be influencing the jury. So they were actually talking about the court reporter all the time from Murdoch. That
was the court clerk, right? The clerk of
Miss
courts.
Hills, Miss Mills, whatever her name was.
Yeah, she was apparently doing some shady things back there in the jury room and whatnot. Yeah, no big deal.
They would have to ask for a stay. As a note, even if his pro hoc is revoked, that doesn't mean he can't work on the case outside of the court.
Correct.
He just can't appear in court as her attorney. No, but I think they want him to be there because he's the bulldog to attack people.
At least he's doing a pretty good job of being a bulldog.
Yeah. Well, again, as I said, why didn't they hit every state witness with perjury charges? Because they lied for the right side. It's you have. If anyone still, 2 years into this trial, after every other trial we cover, have the misguided notion that the court is fair, you really need to grow up and figure out how it really is, because perjury almost never exists unless the state will use it to force someone to testify on their behalf. State witnesses who misspeak will never be hit by perjury charges as long as the state gets their man. AJ and David Yannetti was probably too mad to do the presentation today. No, I think it was deliberately. They know she hates them, and he is the technical guy. Yannetti is more the, what would you say, the baseline. He'll talk the case. AJ is more the flash guy. This guy is the technical guy. He'll get all the. He will go home. He'll read all the. It's kind of like Dr. Russell. They'll read whatever they have and whatever. When they Google something and something pops up, they will go down that rabbit hole. And you need those kind of lawyers.
Sort of like Jess.
Yeah, Jess is she's my rabbit hole chaser.
Exactly.
And Marissa is my goose chaser. I still can't get over it. She was in a fight with a goose today.
I bet the goose won.
The goose, they are
geese are mean, man.
They can break your arm. No, that's a swan that can break your arm.
If you let a swan break your arm, you've got other issues.
You don't have that thing in America?
Swans? Yeah, we got swans.
No, but when we were kids, we were told, stay away from swan, they'll break your arm.
No.
It's a mean bird.
Well, yeah. They I do know that, like, if you go swimming in a pond with a swan, like, they have drowned people in the past because they keep attacking them and force them under the water.
We were always told that a swan can break your arm. That was the thing we were told as kids. So I was deadly. We have like duck ponds. We have, of course, we have the ruins of an old castle. I live in Denmark, and around that there's the old not dike, moat system, and they some of the parts of the moat have now been turned into like duck ponds, and in those sometimes there would be swans, or if we went down to the beach, there's swans down there, and we were just, that swan's gonna. We were sure they were attack swans.
Well, they're very territorial birds. You think a Canadian? Well, you probably don't have Canadian geese, but geese.
Oh yeah, well we have we do get geese flying over from the northern of Sweden. It's the same. They just quacking a different way with a different accent. Quacka 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 is how Swedish geese sounds.
How does it sound?
Quacka quacka quacka. And a Canadian geese is quack quack, you betcha. Quack quack, you betcha.
This is a Canadian goose.
Yeah, we have something similar to that. We have a story about a guy. Well, it's a Swedish story about a guy who flew on a geese and saw all of Sweden. Sad. That's sad way to spend your vacation. But that was a guy called Nils Holgersen. It was a great story. My dad read it to me when I was a kid.
Did he break his arm?
So that was my good night bed story. And then he got bored reading that, so he started reading Greek and Northern mythology for me instead. So
that's a better option.
Yeah, that's probably not what you need to hear when you're like 4 years old, but
potato.
Yeah. I was once walking down a path minding my own business, and then out of nowhere comes the swan making all kinds of noises. Yeah, and Mads knows a swan will attack you and break your arm.
I don't know if it'll break your arm, but it'll definitely attack you.
Break your arm. It's common knowledge in Denmark.
What if you've got Hulk Hogan 22-inch pythons, brother? Swan ain't doing nothing to those.
A swan will break your arm. It's just how it is, Valhalla. You have to learn. In Denmark, we have absolutes. We have black and white, and we don't see any other colors.
Is that like stepping on a crack on the sidewalk to break your mother's
Stepping
back?
on what?
You ever heard that one? A crack in the sidewalk.
No, we don't have OCD.
Dude, that's a thing here. Step on a crack, you'll break your mother's back. That's a thing here.
Well, we have when you cross a road and if you don't step on the white in the pedestrian crossing, it's bad luck. So.
Oh, it's just illegal here. They call that jaywalking.
No, you walk over, but it's white, and then you have the road and white and road and white and road and white, and if you don't,
Yeah.
so you have to touch the white all the time.
So it's like hopscotch. You gotta like jump across the street.
What does a rooster say in Denmark? Kykeliky. Very manly rooster.
Very manly. That's awesome.
I never seen Dude, Where's My Car?
I don't think I've seen the whole thing.
No,
I don't remember the ostrich.
I don't smoke weed enough to watch that movie.
It's that form of comedy doesn't really do it for me.
I think the last of that type of movies I saw was Road Trip.
Road Trip was okay. Wasn't great, but it was okay.
What did you do? Skin a cheetah?
They're huge, man. It is a good movie.
They are on break.
10-minute break, something like that.
Some break. All swans belong to the Queen only in Britain, and right now they belong to the King. Apparently, they don't taste good. They taste muddy. Because
Really?
they eat like small crayfish in the
Organisms.
bottom. So it's kind of like I think they have kind of the same diet as a catfish, and they can be muddy as well. So
They used to eat a lot of them back in the day, though, like in medieval times and stuff. Renaissance era.
Swans?
Swan was a dish.
It was but that's why it belongs to the kings. It was the king's bird, but apparently it doesn't taste good.
I would guess that anything tastes okay back then. It's before everything got all polluted and gross.
Maybe you should send swans out to collect money. Yeah, she that's why she started sighing. It's she needed to get back there and just tip it up.
That 3:30 fix.
I am never wrong. It is the king's bird because the queen is dead. And it's not the queen who owns it, it is the head of the state. And the head of the state is, right now, King Charles, and he has such big ears that he can take terrestrial radios without an antenna.
Them ears are out of control.
Catfish is the best fish ever. I tried it when I was in Tennessee. Didn't mind it, but it was deep fried, so...
I have never. Well, that's how I think how they mostly cook catfish. I've never had catfish. Never tried it.
Well, let's just say if we're going back to that restaurant, I would probably have that again, but I wouldn't have the cornbread. I wouldn't have the green fried tomatoes.
Ugh.
The deviled eggs weren't that devilish.
Oh, that restaurant?
Yeah.
Oh.
And I didn't. The thing I had the last night, the pimento cheese or whatever it was with the crackers, that was weird.
Yeah.
That was too much cheese.
Like that
and
one?
it was cold. And I thought it would be hot. If it was hot, it would be better, but it's just cold. It was a weird dish. But I never seen it in Denmark, so I thought I'll have it.
That's what you should do.
There's a person that had a dog as a watchdog. They said dogs can be mean too.
So actually, geese are used as livestock protection animals. Like if you've got a bunch of chickens or small goats, even you get a goose or two out there. The goose will A, sound off the alarm, and B, actually attack animals that come in there to mess with your livestock.
Have you seen that farm where I think it's a goat farm as well, where they had the 3 dogs in the barn?
So before I hear from the call, Mr. Leslie,
Yeah, I know what you're talking about.
Ask any questions, and I may have
Those are good
questions
videos. I like
both
those.
sides next week. But actually, what I want to do, and you said I could ask questions of other counsel. So while memories are fresh, I just want to ensure the accuracy of what was just said. So I'm certainly not going to order counsel to answer my questions. You don't have to, but I am curious. So we're going to start with you, Mr. Yannetti.
Yes, ma'am.
As an officer of the court, is there anything that you dispute that you just heard from Mr. Alessi? And what I'm particularly concerned about is what you knew or what you didn't know.
You know, what he said was entirely accurate.
Okay? Mr. Jackson, same questions.
No, and I would simply elucidate with regard to the February 6th sidebar comment. As I look back at I didn't remember making the comment one way or the other. I didn't remember that sidebar.
I did.
Well, I'm sure
She
you worked
wants
it out
him
with
out.
the transcript.
No,
I
no,
did as well.
no, I did.
How are you gonna?
Right. The context of that, what was in my brain when I said we don't have anything else to
Just
do,
had 15
when I
minutes.
reviewed the transcript, was very clearly the federal batch of information, what we referred to as the federal dump. I did not have in my head at all emails, communications, things of that nature, the small...
Invoices, payment.
No, nothing. Because the context of what Mr. Brennan was talking about, being frustrated about, were his TUI requests concerning the federal batch of information. And that's when I was making the additional statement. We don't have anything that they don't have concerning the federal information and the background information for the ARCA experts. That was it.
Your Honor, if I could, this is the...
Nope, hold on. Ms. Little, it was just thrown on you that you're responsible for all discovery. But the same question, you, and again, you don't have to answer, but is there anything that you dispute in the accuracy of what Mr. Alessi told me about what you knew and what you didn't know and when?
No, Your Honor, I would just add that as soon as the court issued the order, I obviously was not in court that day, but as soon as the court issued the order that ARCA reciprocal discovery be provided, I gathered those documents and I provided it. So that was the, I guess, prompt for going to look to see if we could satisfy the 10 things that were outlined by Mr. Brennan.
Okay. So I'm going to hear from the Commonwealth now. It does not look like we'll finish this today because we'll be ending around 4 o'clock. But I will hear you, Mr. Brennan.
To me, it seems she didn't listen to one word he was saying, and AJ is out if she can do anything. We don't condone sending geese to any offices.
Attorney Alessi ended his argument talking about the Sixth Amendment and discounting repeated or repetitive violations. When you consider the conduct in this case, you should consider the history of the case, including repetitive violations, 3.6 violations, protective order violations, and then discovery violations, representation violations. The defense in the first trial attempted and successfully did portray ARCA witnesses as wholly independent, presented themselves as oblivious to the nuances of ARCA, left the impression that there was no compensation, no bias, no collaboration. They postured the information that they gave in advance of the second trial, and I'm going to get to the timing of that. But it ignores entirely withholding this information before the first trial. The defendant presumed innocent has a right to a fair trial, and so do the people of the Commonwealth. It is clear from a reading of the transcripts and the records and the posturing materials that there was information that showed that ARCA was not wholly independent. It's information that was known to the
I would ask ARCA to come in and testify now, because he just impugned them and claimed they lied on the stand when they testified on the stand that the defense didn't do anything. This guy is such a POS.
defense, and for whatever reason, perhaps a strategic advantage was not provided to the Commonwealth, the court, nor the jury. Mr. Attorney Alisi talks about the Gonzalez case. In that case, there was one attorney to cross-examine a witness, which is protocol. Another attorney passed a note, a minor violation of a court procedure. That is like a raindrop in a hurricane. We have a code of ethics and rules to ensure a fair trial for everybody, both sides. Coming in at the last hour and provide information when the avalanche has started is not enough. This isn't just about Rule 14. My effort with the ARCA witnesses from the beginning, and I've been clear and consistent, is not to preclude them. It is to get fair discovery that we're entitled to. I did not know before a few weeks ago what the defense had known. I did not know that there was conversations and efforts made between them and then inevitably compensation paid. I didn't know that, but I certainly suspected it. I saw Your Honor's questions before voir dire, during voir dire, after voir dire. I remember the conversations sidewalk. And those questions were right to the point. And when we were sidebar, specifically mentioned, I don't know. A voir dire is inconsequential. I don't know what to ask. I can't send them back home to get their records or their emails or any billing. All of that was denounced. All of that was portrayed as baseless. But the court had questions. I had many of the same questions. It is not a surprise that we start to scratch off the tip of the iceberg. It is not complete. There is a murky relationship between the defense and the United States Attorney's Office relative to these ARCA witnesses. And there is a very unclear relationship, as we stand here right now, between the history of interaction between the defense and these ARCA witnesses. You can see from the emails, while there is some information provided, there are gaps. There are enormous gaps in time. The pause moment on March 24th and then reinitiating on May 5th, where ARCA is actually billing the defense for their works before the voir dire. There had to have been communication between that time that rekindled this relationship. There are two requests that are mentioned in the emails. We didn't get all of those responses. And so we do not have an affidavit from either counsel or any of the counsels. We did not hear a word.
Svedja, fornicate off, Hank.
Word from any of them. According to Mr. Alisi, what you should do, what the court should do, is go to the federal government and ask
So
questions.
just to be clear, I am not having ex-parte communications with anyone about this case. So I'm totally rejecting your request that I do that, Mr. Alisi.
It wasn't a request, Your Honor.
You suggested that I called.
No, I said if Your Honor wanted to do that. I didn't suggest that Your Honor.
I'll move on, but
so he lied again.
The point is, it is not incumbent on the court to provide the proof that the defense was given the opportunity to bring in today to clarify the record. Instead, it is the typical 101, blame everybody but themselves. There's no acknowledgement. There's no contrition. And there's no confidence that we are going to get all the materials that we're entitled to. To suggest that ARCA's position did not change, it did change. Their opinions did change by the time they reached trial. It is not that the defense brought out that there was an expert in lighting or crashes happen at night. It is the bias, the relationship that is critical, and that was hidden from the court, the Commonwealth, and the jury. It is the bias.
There's no bias. They said we pause this now and then.
Towards one side.
And it has nothing to do with bias if he testifies the same thing that they wrote in their report. Sadly, Bev will rule in favor of this idiot. And he's blatantly lying to her.
I would even say that possibly you could argue that ARCA has bias, but it's because they have found that Karen Reed could not have hit him with a car. They're going to be a little biased because they know who is telling the truth in this situation. It's like their point of view, their decision doesn't align with yours, and that's the bias that he's latching onto right now. Oh, I don't like this guy.
That was not disclosed. The first trial to disclose it last week or 10 days ago. So let me offer a quick history. It is true, when I first spoke to the court, I believed the documents provided by the federal government, and I did correct that record as soon as I learned before court ended for the day.
Why didn't you know it before you started talking in court? You have had the evidence for 5 days, you absolute idiot.
30th, 2025, the United States Attorney's Office responded to one of my two requests. They provided billing, including ARPA billing. There was billing for their reconstruction, but there was no billing provided for their preparation, voir dire preparation, travel, expenses, trial testimony. That information was provided to both sides on January 30th, 2025. It seemed at that point that the federal government was being at least a little more responsive, although not directly. No bills other than what the ARCA experts did in putting together their demonstration and their accident reconstruction. February 11th, I filed on behalf of the Commonwealth a motion to exclude the ARCA witnesses. On February 12th, the United States Attorney's Office gives us new emails. And those emails were between the defense and the United States Attorney's Office regarding their request to use ARCA witnesses at trial. It's not a surprise that on February 13th, on the heels of these more productive disclosures by the federal government, we then received the disclosures from the defense, which are the emails regarding conversations between Attorney Jackson and Dr. Wolf, and the invoice for billing. Now,
2 days
I
after
did
you asked for it?
misspeak, I corrected it, but it is not the source of that information. It is the substance of that information which is critical and relevant. It is that information that should have been known to the court, the Commonwealth, and the jury at the first trial, and it is also that information when you compare it to the representations that have been made prior to trial by the defense that has input. Before, and I'm not going to belabor this and go through the comments, most of them again, but it is important before I get to the representations. The court does consider pro hoc vice. We have one licensed attorney in Massachusetts who's carrying 3 pro hoc vice attorneys with the request for a 4th to ride on that same license. There is a responsibility, respectfully, to Attorney Yannetti, a fine attorney, an excellent attorney who I admire, but there is a responsibility so that there are not a number of pro hoc vice lawyers doing different things and then later plausible deniability. When we send emails, if I should miss one person on an email, I will receive an email telling me that make sure everybody gets every communication. I've been corrected or redirected many times when we've left
You
somebody
get
out on
an email, but yet you want to strike him
Meetings
from
are
the case.
signed by all parties. They come through the bar card.
If I do it, I'll get an email, and that's
And so to try to
almost the same
parse
thing as
or
kicking off
miss
AJ.
or put a slight on
You're a
words
fucking
to
idiot,
suggest
man.
that things are done.
No, now it's not just AJ. He wants Yannetti out too because he didn't keep his underlings in check. So her entire defense team should just go now.
Ugh. I can't stand this guy. I really can't.
He-
He's as gross as they.
How he's allowed to say this and she's not stopping him and saying it can't be the fault of the defense that you didn't read the discovery they turned over to you. I don't understand. She could stop the other one.
Independently, and there's no responsibility for the defense when a representation is made that's inaccurate isn't enough. It doesn't assure that in the future it won't continue. Now, Mr. Alisi said there were rules of the road. This was before his time and mine, but I've read the discovery. There were no rules of the road. There was a protective order. And the protective order was clear that there was no discussion outside of court about the federal material. And there was nothing in the protective order or direction from the U.S. Attorney's Office that the Commonwealth had any right or privilege to contact any witnesses. Everything is done by the book, by regulation, through 2 requests.
So I have to say, I've never seen the protective order. I received a stack of discovery that the federal authorities were kind enough to get to me in advance of trial last time because Mr. Jackson had told me he understood that I was operating from a place that I didn't have enough knowledge essentially of what was going on. So I received those 3,000 pages plus. I did not receive a protective order. I don't know that I'm entitled to it, but it would be helpful. I don't want to take it if I'm not entitled to it. I don't know what the parameters are.
Your Honor, we have a copy of the protective order. I did ask full counsel if there were any limitations to it, and I don't have a certain answer. What I'd like to do is
Call over
inquire.
there, please.
Yes.
All right, if I can have it, I'd like it. It would help guide me through this. If I can't have it, I'll just go with everything I've.
May I have a moment to speak to counsel?
Sure.
Get that cloth.
I'll need to call the United States Attorney's Office and get an answer.
All right, I appreciate that. Sorry to interrupt.
And so the portrayal that there was a rules of the road, there was no such rules of the road. Neither Attorney Lally or McLaughlin ever contacted any witnesses directly because they understood that that was precluded. And so there was not an opportunity to call or discuss or have conversations, share direct examinations, or have emails with these witnesses. In fact, it's underscored, isn't it, by the emails that we received where Dr. Wolf replies at the 24 saying U.S. Attorney's Office essentially told them to hold off on communications. It doesn't seem like that would be a very clear rule of the road to have independent conversation with these witnesses and then be cautioned that that no longer was viable. And so inevitably, it was the understanding that nobody would be speaking to the witnesses. And I did see in the transcript, when the board there was asked, were you available to the Commonwealth? And the witness said yes. I don't know any basis whatsoever for the witness to suggest that there was any invitation to speak to them. And so what we...
That's not what being available to the Commonwealth means. It means if you had reached out, they would have talked to you.
We have witnesses that were wholly portrayed as independent. When we look at the testimony, it was represented many times in court, leaving the impression that the defense had no access and no special relationship with the ARCA witnesses. On June 5th, 2024, day 26 of trial.
What date?
Day 26 of
No,
trial.
that, but what date?
June 5th, 2024. Discussing scheduling and voir dire hearings, the defense said, I provided everything we have. I can't make up discovery. I mean, I got a report. And everybody in this group knows why I can't provide additional discovery for ARCA. Everybody knows they've got what I've got. Your Honor asked, I haven't. If you can't, that's fine. So not everybody knows, and I make those decisions. Response, certainly, certainly. You're the one who needs to know, and I thought you knew. The federal authorities will not allow me to interview or ask for additional information from anybody in their world. So I have nothing. I've got a report. He's got the report. That's it. I'm going to start asking questions on the report. That's it. He can cross the report. So as many times as he says, I don't know what they're going to testify to. Yes, you do, because they're going to testify to the content of the report. And those are definitely questions I'm going to ask, so I've got clean hands.
All right, so you're reading from a transcript. As you know, there are dozens of transcripts. What's the volume number? What's the volume number and the page number?
Day 26 of trial, page 248 to 250. I will get a volume number to the court.
That's okay.
This seems to directly contradict the theory that Attorney Lisi has been promoting today of the rules of the road. This does not suggest that ARCA is open for business and private discussion and consultation and payment. It says the opposite. It says the opposite. The federal authorities will not allow me to interview or ask for additional information from anybody in their world, so I have nothing. And so this presentation today by Attorney Lisi, suggesting somehow that this was open and notorious, is not backed up by the defense attorneys themselves. The June 10th hearing, we've already been through it. I won't repeat it, but those comments are important. I think what stands out about the prior hearings, and I say that I think that there's a murky relationship that we have not done more than scratch the surface of, is Your Honor may remember that the defense noticed 3 experts in ARCA, including Mr. Klein. When we get to June 10th, Your Honor is asking, regarding the 3 experts from ARCA, and this is June 10, 2024, trial transcript 28.
Hold on one second. Let me grab that.
I believe it's page 12.
Okay.
And you were asking about the 3 experts from ARCA. And you mentioned, notably, I can't tell who does what or what the basis of the opinion is. And when you look at the ARCA report, there's no delineation on which of the 3 experts did what in that report. You can't tell what role each of them played from the report. And so if we only had the report, we wouldn't know which of those experts to call. And so when you continued questioning, you were told Well, you said, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand. And Mr. Yannetti said, that's essentially it. He gives some detail. As mentioned earlier, we've spoken to them only for purposes of coordinating their testimony and background. The important point for this particular point is that the defense inevitably calls 2 witnesses, Mr. Wolf and Mr. Rentschler. And when they only call Mr. Wolf and Mr. Rentschler, there must be a reason why. Because you can't tell from a report who did what. They noticed 3 experts. So there must be conversations with somebody explaining the...
That's not the problem here today. The problem is she will... The feeling in my urination system right now is she will retract at least AJ's pro hoc vice.
Witnesses' role, or why only 2 of those 3 witnesses are important for the defense. And so it is clear from the absence of information, there are much more communications that are expected to be in existence that have not been provided. On June 18th, 2024, the voir dire hearing. The court asks, well, I thought that you would help...
I've got the transcript. What page you want?
He doesn't know.
Do you know?
No, but I can...
If it's just your notes, that's okay.
I can pull it up.
No, because you wanted the pages from the defense. Then you need the pages from the state as well. Stop having a 2-tiered justice system.
Can I also point out real quick that the entire time Alessi was speaking, they didn't show Hank's face once. Now that Hank's talking, they keep zooming in on Karen Reed and Yannetti and everybody else other than Hank and his lion ass.
Yeah. I knew it would be bad when he got up there, but he's just BSing all over the place again. And saying the same thing. Oh, we didn't get it. We didn't get it. You did get it. And you lied when you said, I thought it was the state. No, you had it 5 days before. You just claimed that AJ and Yannetti need to know every piece of evidence. So do you.
Page 4, line 11, the court asks, so the understanding of the voir dire is that this is for the Commonwealth's motion to exclude this testimony. All right, that's what we're here for.
Not her case, but her team.
And Mr. Jackson says, is that the same with Dr. Wolf and Dr. Rentschler? And the court says, well, I thought that would help both of you. The Commonwealth has nothing on that, and you say you haven't been able to even talk to them at all about this case. And the answer is that's correct. Now, refrain from my opinion and characterizations. Unlike the
He's
defense,
withholding the next part of that explanation.
Yeah. Yeah.
When we continue in the voir dire hearing, page 71.
Okay.
Line 4, importantly, were you hired by the defense in this case? No, sir. Before this morning, when you walked into court, had you and I ever met face-to-face? No, sir. Now, this illustrates an important point. That is technically true. But what impression is that making to the court?
That they didn't meet face-to-face.
Is that a genuine impression consistent with reality? Line 20, the person to my left, the female to my left sitting here, have you ever seen her before? Nope. Do you know who she is? Yes. And so there is direct and indirect commentary, questions, presentations that reinforce that the defense and ARCA are wholly independent from each other. This is also consistent with their representations regarding payment. There are questions, voir dire, in the trial, about whether or not the witnesses were ever paid. It may be technically true, they were not paid at the time they were asked the questions, but if there is an expectation of payment, it is a promise, reward, and inducement. It can show bias. There's nothing wrong with paying an expert. There's nothing wrong with going over a direct examination with an expert.
They weren't paid as experts and they didn't have a promise of.
There is nothing wrong with talking about particular questions with an expert. But when these experts are being portrayed a certain way, that they're independent, that there is no evidence, information about them, then it is not a fair representation. It is not an honest representation.
Well, you think ARCA is like Alan Jackson's little hitmen? Like they're running around just doing Alan Jackson's bidding?
Your Honor asked today.
And the experts didn't get paid. ARCA got paid. They got a bill 3 weeks after.
Some things that stand out. There's a tax ID number, an invoice dated July 12, 2024. It's addressed to.
Hold on 1 second, please. Okay.
It's addressed to Attorney Jackson. And the position that the defense takes, Attorney Alisi takes today, is this came out of the blue that they had to pay. Apparently, everybody in the know knew the defense was paying for this expert, other than the defense. ARCA experts knew. Dr. Wolf knew. Dr. Rentschler apparently knew. The federal government knew. When you look at the bill, there are things that stand out that are so notable that you can't go back and try to twist them or change them. Look at the first entry of May 1st, 2024. That is before June 10th. That is before the representations that there was no intention of compensation. Apparently, the witnesses they were going to call expected that they were going to be paid by the defense, and they wouldn't have been keeping track of their time back on May 1st, 2024, participating in a telephone call with Alan Jackson. And so the March 20th email asking for an engagement letter and a retainer, and then the 24th saying we need to take a step back because of the U.S. Attorney's Office.
22nd.
I'm sorry, 22nd and 24th. There is obviously more communication because the relationship re-engages at least on or before May 1st, 2024, and these witnesses understand that they're going to be paid by the defense.
That's because they're ARCA. That's what they do. They testify and then send a bill. There's no ex-party communications, you lying son of a bitch.
The reason why they keep an itemized bill is probably because they were talking to a lawyer who might use them as an expert. They are experts in cases all the effing time. They have to tell, I don't know, Valhalla, have you heard about Doge and them sending out emails to government workers telling, can you tell us what you did last week?
Yeah, 5-point bulletins.
Because if you work in a private company, especially one like ARCA, they really want to know what you're doing if you're talking to clients, because they kind of bill their clients. It's the same if you call a lawyer. He doesn't say, well, I'll start the clock sometime at, I don't know, maybe next week. They kind of keep a timesheet because that's billable hours.
That's what they do. That's what they do.
Jemima, why are we watching this? You're a lawyer. I blame you. Jemima actually had Brennan as a professor at her law school.
Ew.
Yeah, ew.
That's not true.
And as I mentioned in the materials we got
It's
from
true.
the United States Attorney's Office.
Well, she didn't take his class, but he was a professor at her law school.
This guy's teaching
on February 12th,
Yeah.
there is no billing related to prep for voir dire, travel, trial, none. So the only people who were surprised that they were paying the witnesses, apparently, was the defense themselves. And then before that June 10th hearing, where the representations were made, there's a June 9, 2024 phone call. Another participated in telephone call with Alan. And then we see before the voir dire testimony, there is billing to the defense, which is now we know paid by the defense, prepared for voir dire testimony, June 17, 2024. What we don't know is, in the preparation, was there any conversation with the defense? Was there any emails? Were there any documents? Were there any outlines? Was there any discussion about the potential testimony, or is this solely the preparation of Dr. Rensler on his own? On the same date, 3 hours billed by Dr. Wolf, prepared for testimony and hearing. Now, they felt inclined and comfortable billing the defense for it. Was there any interaction or discussion between the parties? We don't know. This was the time.
No, but you are implying that there is an improper contact. Have you contacted ARCA? Have you contacted these witnesses and gotten a written statement from them saying, yes, those 3 hours we billed was in close connection with the defense, they have misstated? Or are you just implying, like you did last week, where you implied because you didn't know, so you don't know outlaws, New Age outlaws?
I wonder if that's why he never contacted ARCA, so that he couldn't be accused of paying for their expert testimony. I wonder if if this was actually a play the whole time.
They write a bill for. How long did you spend preparing for testimony? 3 hours. I had to read my report, get it back in, and all of them did it. It's fuck. There's no evidence provided, and I say it right now. Bev will go back, and then she'll probably she will kick AJ out, rescind his pro hoc vice.
That the court gave the defense an opportunity to bring in their product, their receipts, the emails, to elucidate, illustrate, demonstrate, prove what the relationship was. We don't have anything. We have nothing more than we did last week. On June 18, 2024, a round trip to Norfolk Superior Court by Dr. Rensler, and also separately for his testimony, 8 hours billed, 12 hours for Dr. Wolf billed to the defense. June 21st, Dr. Rensler prepares for his trial testimony, bills the defense, 5 hours. Again, we have no idea if that includes in any way correspondence, communication, interaction with the defense. June 21st, Dr. Wolf, the same, prepares for trial, 6 hours. June 23rd, Dr. Wolf travels to Boston for trial, significant delays, and then Dr. Rensler on the 24th, round trip, Norfolk Superior Court, 11 hours, 6.5 hours respectively, billed to the defense. Now, it's hard to believe these witnesses would put forward money and expenses and travel without some understanding that they were going to get paid. It is hard to believe this company, especially after receiving an email about engagement and retainer, especially after having
all you're doing right now is speculating. What did Bev said earlier about speculating?
Or she wasn't talking to him.
No, she wasn't talking to the Commonwealth. She was talking to the defense. They couldn't speculate, but this asshole can speculate all the time.
Collaborating on their potential testimony. It is hard to believe that they would come to Boston, spend their time and their own money to do this, to just simply send a bill later with no expectation of being paid. In fact, it's a very specific accounting of their time. And when one accounts for their time, it's because they need to have a contemporaneous record so they can get paid for that time. Also billing for wait time and travel, testimony at trial on June 24th, and then there's expenses for June 18th and June 24th.
It's not like they're fucking humanitarians. It's not like they're doing all this work for the well-being of society.
Within 1 month of the defense, they
No, and they would have built the court if they didn't build a defense.
This is disingenuous at the very least. He knows this is the case. He knows that what he's arguing here is bullshit. He knows it.
Yeah.
This dude is
but he knows she's gonna fly with it. And Sue hates this guy as much as Alan Schiff. I don't know who that is.
Maybe not quite as much as Adam Schiff, but pretty close.
I don't know who this is.
get paid that Commonwealth and the court never knows about. Talking about correcting a record.
He's a politician. I don't care.
And so this $23,925, you find out what you did. It was paid by the defense. We hear that there was a conversation with the federal government We have no affidavit, we have no witness, we have no writing, no email, no correspondence, nothing to support, put in context the conversation, nothing. No. And so when you look at the story on this bill and the timing of it and the details of it, we know that we are getting a fraction of the story. A fraction. It's not enough to blame the court, blame the Commonwealth, blame the Attorney's Office. There's some accountability.
You're blaming everyone, you idiot.
In addition, when we look at the totality, the representations made in court, we also, at some point, we're going to address the Commonwealth's position of violations of 3.6. That's the motion. It's interesting that after the last court hearing, well-known reporter, very reputable reporter, Christine Rex, asked Mr. Jackson about paying the bill. And what I suggest, more 3.6 activity. Quote, no, of course not. That was the position last week. So what we're left with is we still don't know the relationship between the defense and ARCA. We don't know about the impact it had on the first trial. There has been these multiple representations that ARCA was independent, they had their opinions, and they were exculpatory. ARCA's opinions changed. There were 4 opinions. And if you look at the report, and I'm not going to read it for the sake of the press and the public, we'll have the trial, and we'll vet it at trial. But when you read the report, clearly the representations made about that report were extended at trial. And the question is going to be, why? Why did they improve? Why did they...
Particular page you'd like to read without citing?
So they changed their testimony, is what he's saying now, but they said in court they didn't, so ARCA lied to the court.
You don't have to read any of it, you just tell me the paragraph.
That doesn't make any sense.
I think it's just the first paragraph that lays out their findings.
Thank you very much.
Yeah, and they testified they didn't change their story.
And actually, particularly note number 4, and both publicly, repetitively, but also at trial, the parameters of that were extended substantially. There is a summary again at the end of that report, substantially says the same thing. If you look at the last page, which is signed by all 3 of the experts, Mr. Wolf, Mr. Renshaw, and Mr. Klein, says essentially the same thing. So we'd be oblivious if
this is rank
stood here and said that
the whole thing is
the relationship between the defense and the experts, there's no relevance to bias or motive or desire to please, because clearly there's a change, there's an expectation of payment, there's communication. And
this is bullshit.
An outline was provided so close to the testimony, therefore it shouldn't have been shared. It isn't just what's in that outline. It's the fact that they have the relationship. Attorney Jackson may have brought out that accidents happen often at night. It's not the point. The point that the ARCA witness is willing to forego that information as a benefit to the defense. That is the heart of what is missing and what is hidden. And so there are a number of instances, 3 of them, in the outline where the ARCA clearly is trying to accommodate the defense. And by representing to the court that there is no relationship, the hands are clean, they have no information, is not only not accurate, it is misleading and unfair.
No, and that's what they testified to today. They didn't understand why they got an invoice. Then they called the USAG and asked, should we pay this? And they said yes.
So we know there is more. The question is, will we get it before trial? I have another TUI letter going out this week. I don't know how long it will take to respond to it, and the TUI letter is not going to be thorough and complete. It's just not the way TUI works. And so we are in the same spot. Well, actually, we're in a better spot. We know now about the relationship. We know about the potential bias. We know about the payments, but we don't know the full scope of it. And so we are entitled to that information. We don't know what conversations and communications the defense had with the ARCA experts that the federal government doesn't know about.
So what's
Over
the
next
remedy?
few
You
weeks,
want
we're going
like
to attempt
the
to get more
downloads of
information,
all of their devices?
but we will never have
Yeah.
an accurate
The
account
off the record
unless it's
notes, like everything else.
Hey, Money G.
Your Honor has mentioned the sidebar,
Which one?
the most recent one.
Okay.
I am not trying to be overly critical of another attorney.
Yes, you
I'm
are.
not.
Yes, he is.
You can laugh, but I'm not.
I'm glad he laughed.
It has been my effort to get Rule 14 material. It has been my effort not to exclude ARCA witnesses. It has been my effort.
You put in a motion to exclude them.
Fair play. There's been no other way to compel any information other than to file motions in this case. And it is not incumbent on the government to fight for this information. We're entitled to it. We're entitled to it. And at this point, we have no confidence whatsoever, none, that we're going to receive the information that we deserve.
You're a lying piece of shit.
Thank you. Mr. Leslie, very briefly, if you have something.
Yes, thank you, Your Honor. I'll be very brief.
Yeah. Kick his
I hope we
ass.
get an opportunity to have a more fulsome response, but I'm going to be very brief on the key points. Attorney Brennan focused a lot on the invoice. As I said, I work with experts all the time. The experts keep track of time. They had historically been paid by the government. There's another completely rational, more probable explanation that they have been retained by the government. They were being paid by the government. They maybe at a certain point didn't know who was going to pay their bills because they turned out they were going to be providing testimony. That's a whole different issue, what they expected to be paid and by whom from what the defense expected. So two things can be true. It can be at some point they thought they were going to get paid, but up to that point they were being paid by the government. And the entries, all that Mr. Brennan went through, particularly the early ones, there is zero evidence before the court on any basis that they expected on those dates of those entries that they were going to be paid by the defense. And it's very important because Attorney Brennan spent most of his time on that invoice.
It is, man.
With regard to the comment he made, and this is the problem when we don't have notice, like I provided a notebook so everybody could see it, we don't have some of the things that Mr. Brennan was referring to, but he referred to, of all things, Mr. Jackson's response to a reporter. We're here talking about communications to the court. But to be clear, the reporter asked, did you pay for testimony? Did you pay for testimony? Mr. Jackson, of course, said, no, I paid for their time.
Did he say I paid for their time?
Pardon me?
Did he say I paid for their time?
Mr. Jackson?
I said the words, of course not. Did you pay these witnesses for their testimony? And I said, of course not. If the court were to ask me that question today, I would respond exactly the same way.
All right, so you just told that I paid for their time. That
No,
was not said, right?
That was not said, but I'm saying there's always some inference.
That wasn't the
about
question
what he
asked.
said that was it, but that was his response, that was it. But it was only, the premise of Attorney Brennan was, what Mr. Jackson said to the reporter was different from what you've heard in court today, and it wasn't. It's important to be accurate. The other things that I'm going to go through quickly is it kept stating that there had to be a belief that they were going to be paid by the defense. There is no evidence whatsoever for that because it didn't exist. So now with regard quickly again to the other topics. Attorney Brennan talked about 3 witnesses, right? And he was, I believe I took it as clearly inferring 3 ARCA. Your Honor can go back to the transcript. It was Dr. Russell was the 3rd one.
Oh, I thought it was the 3 ARCA people. I
Nope.
have to go back to the transcript.
You can go back to the transcript. Earlier on, there was a discussion, way early on.
Lying again.
He was a 3rd ARCA expert that was involved for the government, right? And then he stopped, and we didn't retain him for testimony.
Okay.
And let me be clear on what I mean by retain. He didn't testify.
It's been a long day.
I understand. I'm trying to answer your question, Your Honor.
I know, and I realize that you just said something that you want to explain. Go ahead and explain.
Right, so what I'm saying is, in terms of, I'm going to take back the retain. The point is, there were originally 3 ARCA persons on the report that we got from the government, right? Rentschler, Wolf, and Klein. We only went forward with the testimony of Rentschler and Wolf. And that's what I want to come to, Your Honor. The whole emphasis was that the Commonwealth had no notice that we were going to use these experts. Your Honor, the voir dire was the notice. And my point was, I didn't say that there was no bias. What I said was, once you decide you're going to use an expert, right, you're going to be having them testify. Anybody could claim that that testimony is biased. But the point is, Your Honor, that the allegation that somehow mysteriously this third person that was being discussed, and clearly the inference was that we were misrepresenting still about which ARCA witnesses because we weren't talking about the third. The third was Dr. Russell, and you'll see that in the transcript.
Okay, but when I said you expect something, whatever I said, you expect me to believe that you are calling 3 witnesses whom you've never spoken to. When I had that discussion with Ms. Giannetti, that's what I meant.
Thank you for bringing that up, Your Honor. And that was just ARCA. That was nothing to do with Dr. Russell. But here's the important part. Attorney Brandon didn't read the rest of it.
He lied again.
You're to believe.
Okay, so where are we? Are we the June 10th?
Yes, please, Your Honor. June 10th. That's exactly right. That's exactly right. It was June 10th. It's important. He stopped on
page 12.
Yes, thank you. So on June 10th, so you're to believe, this is line 19, so I'm to believe that the defense is calling 3 witnesses that you've never spoken to and putting them on the stand here. Here's the response in its total. That's essentially it. We've spoken to them. So it's not like it wasn't disclosed there was a conversation. It was. We've spoken to them only for the purposes of coordination of their testimony and their background. We've not been able to interview them regarding their findings, which are outlined in detail in the reports. Your Honor, that's 100% true. Because I
read that earlier.
Right, but Mr. Brennan just mischaracterized it again because that is 100% true. He made it seem like that was an untruthful statement, and I know Your Honor gets it. The other last 2 points, Your Honor. Attorney Brennan talked about that the ARCA experts improved their testimony. My point, Your Honor, was their opinions never changed. Whether they improved is a characterization, but their opinions did not change. And that is very important. And the last point, Your Honor, goes to the discussion that Your Honor was having with the questioning of Ms. Little, Mr. Jackson. I want to be very clear on February 6th, and this is going to be my very last point. When Your Honor asked the questions on February 6th, and Mr. Jackson responded about the discovery, and I said to you that Ms. Little was the one handling the discovery. And I spoke with Ms. Little, and I spoke with Mr. Jackson, and they're going to be completely available for any questions that follow up on this. I asked Ms. Little during the break. She wasn't here for that February 6th. She obviously didn't hear the sidebar. But I said, when you learned of what the Judge Cannone was asking about, I said, in your head, what was going on and what came to your head? Because I said Mr. Jackson didn't make any knowing misstatement because he had no recollection of any of those March emails. So I asked Ms. Little, who would, between the two of them, would, if there was any recollection. So during the break, I asked Ms. Little. I said, Ms. Little, when you heard and got the order, because that's the first she knew of the inquiry, she gets the order. I said, when you got that and you saw that you had to turn over discovery, when you read that, did it come to your mind? Did it come to your mind that there were these March emails? And she said, no. I didn't recall them. I didn't remember their existence. And what I did was I knew we had to turn over discovery. I then went back. I rediscovered those emails, and that's how I had recalled it. That is important, Your Honor, because there has to be a knowing misstatement of fact for 3.3a. So not only did Mr. Jackson not know at the time Mr. Jackson made those statements and recalled those emails, neither did Ms. Little, who was the keeper of all the discovery. And that is my last point, and I will conclude this way, Your Honor. Attorney Brennan conflated Rule 14 issues with the 3.3a1 issues. They are completely separate. I am not here today, Your Honor, to take the position that the defense is in perfect compliance with Rule 14. We're not. But that's a whole different question, from whether the attorneys are in compliance with 3.3a. And I would urge Your Honor, as I know you will, to keep those distinctions as we go through the matter, because conflating them is not proper for the analysis. And my last is a citation of law, Your Honor. It was said that Gonzalez involved a very minor issue. Attorney Brennan is correct. There was a minor issue in Gonzalez, but the Supreme Court went through those things that could rise to it, and I'm going to give you another cite, Your Honor, which is United States versus Diazzi, that involved a lot of serious issues with regard to conduct of counsel. They were not pro hoc vice, but it's 807 Fed 2nd 12 First Circuit 1986, where Your Honor can read it as to what were happening. The attorney's conduct was deplorable, and yet the court held that you could not disqualify them because of the Sixth Amendment And my last point, Your Honor, is when you do a Sixth Amendment analysis, whether or not the attorney at issue is pro hoc vice or not, is not weighty in the determination of balancing the Sixth Amendment. It is not. In the abstract, Your Honor, in civil cases, is it easier to knock out a pro hoc vice? That would be absolutely correct. But when it comes to a criminal case where defendant or choice of counsel, that is a much different analysis with the Sixth Amendment. So I will stop there, Your Honor, because you said to be brief. There would be more I would have to say, but those are the highlights for the moment.
Anything, Mr. Brown?
Very briefly.
And now he's going to BS again.
God, I hate this guy.
He's so full of a certain thing that his eyes are brown.
My arguments to the court have always been focused on Rule 14.
Yeah, but we're not here on a Rule 14 motion.
The verbal gymnastics that counsel engages in to use words like misrepresentation to distort reality is extraordinary. So let's use the defense.
He's right, though. He's right. There was a lot of verbal gymnastics. The word that should have been used was lies. You've lied
from
the
him.
entire time, Brennan.
That was filed late, right? The
February
first Saturday or something?
February 16, 2025. This sums it up, really. And this is signed by Attorney Jackson, Attorney Alisi, Attorney Manetti, certificate of service by Attorney Little.
Was it signed by Ms. Little? It's not.
Ms.
right?
Little has only done the
Maybe
certificate of
authored
service.
by- Okay.
She did not sign it. It was signed by Attorney Jackson, Alisi, and Yannetti. And this is the defendant Karen Reed's opposition to Commonwealth's motion to exclude employees of ARCA LLC. And here's the representation they made. Not my words, not a misstatement, not a distortion. This is their words. Now comes the defendant Karen Reed, Ms. Reed, and respectfully request that this honorable court deny the Commonwealth's motion to exclude the expert testimony of employees of ARCA LLC, namely Daniel Wolf, PhD, and Andrew Rentschler, PhD. Here's the important part. The Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith and is a desperate and transparent attempt to keep exculpatory testimony
They weren't.
of expert witnesses from reaching the jury in this case. I know Attorney Alisi no longer likes the word retain, but that retain word has import. There's a reason he said it. Their words, their motion. This is no different than the tone of representations made February, last June, May.
The 18th. No, 16th.
All right. So we're back here next week. I believe we're back here Tuesday, Wednesday, and perhaps Friday. Is that accurate?
Your Honor, may I speak to Wednesday, please, the 5th? As this court may know, Mr. Jackson, myself, and Attorney Weinberg are scheduled to appear before the federal court at 9:30 in the morning.
Okay.
Could we possibly go there and then
Yes.
come here immediately afterwards?
Sure.
Thank you, Your Honor.
Sure. All right, but we'll see you here, Jim. We have these all scheduled at 9.
We do.
Okay. All right, so we'll see everybody here Tuesday at 9. We've blocked off the day for Tuesday, Wednesday, and of course I'll let you go to federal court first, and also Friday.
Friday.
All right, so we'll see you next week.
One line, please.
You'll have to run that solo. Oh, maybe I can put Jamie to bed and then I can go on my laptop.
Goodbye.
You goodbye yourself.
Brennan gets my heart pressure, blood pressure.
I actually started getting chest pains because I got so angry.
It's amazing. It's amazing that he can just blatantly lie through his teeth and not get any repercussions from it. It's amazing.
And he stands up and says, "Yeah, they have been arguing the 3.3A1, but I've been arguing Rule 14 motions." So you just answered to something completely different than we spent 4 hours talking about.
Nothing got accomplished today. Not a single thing was accomplished today. This is all stuff that all of us internet sleuths knew last week when Bev freaked out. Like, this is nothing got accomplished today.
No, but what we know now is all the people who said, well, Bev clearly got angry because black helicopters was swinging in over Canton. No, she totally misunderstood whatever happened, and she want to conflate everything into, I just want AJ out. I blame Brennan. I have to blame Brennan first of all.
I really like Alessi.
I think he got too long-winded, and he has that tendency to do the, well, now I will take you down this route, and then I'll take you down this route, and you could hear when she said it the first time, you don't have to tell me. He should have been, he should have stopped talking and just gone back and kept, just kept to the script. But I think he tried to placate her, and it became too much. And I'm just scrolling back to try and see if I can find that motion to not exclude the ARCA guys, just to read what it was he claimed. I'm having to go back. Talk amongst yourself.
That's another thing that's killing me. He's like, I'm not out here trying to disqualify witnesses, but you are, sir. You actually put a motion in to do just that. I'm not out here to disparage lawyers, but you are, sir. You're claiming that they're lying and they're falsely representing relationships with expert witnesses. You're very obviously doing all these things that you know you shouldn't be doing and are claiming that you're not doing, but you're doing them and you're getting away with it because Bev, for whatever reason, is letting you. I dropped a Lego, sorry. He's a horrible human. He's a horrible, horrible human. There's no reason that dude should be in a position of authority he shouldn't be a dog handler at the pound. Like, that dude. Clearly showing he's a mob lawyer. It wouldn't surprise me.
And I love that he keeps saying, I don't mind ARCA being here, but he filed a motion to have them excluded on the February 12th.
Well, but he gets the sound bites then.
Yeah.
So that, Attic Boy can claim that he's in the right and blah, 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 blah.
But I can't. Where the hell is the defense's motion? Commonwealth's motion to impose sanction.
I think we decided, Groovy Cheryl, I think we decided that wasn't Morrissey.
Yeah.
We thought it was at first, but I don't think it was. Unless there was two people back there.
Report evidence, affidavit.
Right. Could you, Mads, that's a good point. Could you imagine ARCA gets excluded, but Trooper Paul's the crash expert?
Yeah. Oh.
Oh, it's so sad. It's so sad. This whole thing is just ridiculous, y'all.
Why can't I find that motion to impound, defense motion to exclude certain testimony, affidavit? Liza Little, is it that one? No, defense motions to impound. Why can't I find the... Nope. There's so many papers, so... that was the continued hearing. Combined PDF. No, it doesn't. That's not the one. I bet you they have found it for me, and I'm just looking the wrong place. Production of records. Nope, that's the habeas corpus. That's the federal one. And for those who will probably be asking, we won't see the federal thing.
That was the case that Yannetti was talking about, though, right? The habeas corpus motion in federal court. Yeah. So they're going to go on the, what was it, the 5th, I think she said, the 5th, go to federal court and try to get the case dismissed essentially, and then after that come back to Bev's courtroom and finish this nonsense. For those that don't know, by the way, the Sixth Amendment is the right to a speedy and fair trial. It gives you the right to call witnesses and face your accuser, among other things. So that's the Sixth Amendment argument that they were talking about. And at least he's right. There's nothing in there that has anything to do with pro hoc vice. Like, you're not going to have a lower standard of Sixth Amendment rights because your attorney's from California. That's an absolutely asinine take.
No, and especially because he has been granted and he hasn't violated. Again, what has he violated? He lied about
the worst case scenario. He postponed an email by like 24 hours or 72 hours at the most that was supposed to be turned over in discovery.
I love just sent me something and then removed it, so I can't complain that she sent me the wrong stuff. But he has been approved, and the only thing they have him on that they mentioned today is he didn't turn over an email.
It was like 24 hours or something, 27 hours that he had it, that he didn't turn it over. And it was still in plenty of time for them to see, address, and adjust their strategy.
And again, they had everything that he used to impeach their credibility sent by the defense that he then lied about was from the state, and even presented in court and then said, oh, I took a break and then I found out it wasn't sent by the state. You had it for 5 days and you still chose to not tell the truth.
Just checking to see if Val will read my super chats. I absolutely will, Sue. I absolutely will. Man, that was pretty intense. 0% Swazier the other day.
Yeah.
That was the only time I've ever used
he has
stupid
88% Swazier.
I was talking about me the other day.
Yeah,
the only time I've ever used your Nightbot, stupid Nightbot, gave me 0% Swazier.
Can they call the entire Boston, Canton, and state police? They are accusers. No, they can't call the state of Massachusetts to the courtroom either, which is her accuser. They just work for her accuser. The state of Massachusetts is actually the one accusing her. If you go and watch the Darrell Brooks case, you will see that he tried to call the state of Massachusetts many a time and was told
sure
there's no way you can call the state of
Wisconsin.
Massachusetts.
The state of
Wisconsin, sorry, yeah. You turn over onto back, you flip over now.
That's a Asian accent, I believe. You flip over now.
Well, remember, I'm racist, so I don't do Asian accents.
That's right. That's right. Oh my God. I need to start taking blood pressure pills. Wendy says, hi, Sue. Hi, Wendy. How you doing? And Eileen's been a member for 6 months. I'm here stress knitting. Go team. Indeed. Indeed. Why isn't Bev a witness for writ?
Thank you, Jamal. I was looking at for the response for this one because I love that. As I said earlier, he was he claims I don't mind that that the ARCA guys testify
as he's putting in a motion to exclude them.
Yeah, and on what basis it's let's see what the conclusion is. the Commonwealth remains unduly prejudiced by the defendant's delay in providing appropriate discovery and notice to the Commonwealth. The Commonwealth has diligently sought expert discovery from the defendant and U.S. Attorney's Office for approximately 10 months. A second voir dire is not appropriate remedy as the defendant has continued to sidestep their discovery obligation, which we know is BS because they have all the evidence, because they got it at the same time. Commonwealth is entitled to a fair trial and simply has sought what every criminal defendant in the Commonwealth of Massachusetts is obligated to produce. The Commonwealth is entitled not to repeatedly be ambushed at trial and be permitted to effectively prepare for cross-examination of any witness. Strategic decisions do not alleviate a defendant from discovery compliance after 10 months, the only appropriate remedy is exclusion. No, because they have until you filed your discovery to reply to your discovery, which is what they did. You're just gaslighting as always. You can't find a response. That's probably why we can't find it then. It's horrible that we have to sit through this BS, because this guy will do whatever he can to get Bev to do whatever she can to throw out as many of the defense witnesses and lawyers as possible. And to me, it sounded like AJ is gone. If Bev can find any little sliver, and then it'll be appealed, and then we will delay the trial, and then I'll go to Knoxville and, well, if I find a ticket, and then I'll come back, and then we'll start the trial. It's he doesn't know facts in this case. None of the facts. He stated at the last hearing, I didn't watch the trial. I had to rely on the transcripts which I read. And then when he went up and gave her some context, he said, I haven't read the transcript. So he's blatantly lying to the court.
He's lied at least a dozen times in the last 2 hearings. At least.
It's horrendous.
I can't imagine that she's going to get away with getting Alan Jackson off this case. I can't imagine she'll get away with it.
Yeah, it was a mistake on the Videotron. It wasn't because they made a boo-boo.
Yeah, that's not how that works.
It's just horrendous that we are sitting through this week after week after week, and he's clearly lying, and he's misrepresenting what happened in court, and she just lets it fly. But you can clearly tell that she don't care what the truth is, as long as she can kick out at least AJ.
There's no doubt in my mind that her and Brennan have talked about this and are on the same page. Like, this is a team effort, right? Like, when Brennan's up there talking, she knows exactly what he's talking about at all times. The only thing she needs to do is interject and ask for a page number. Whereas Elise, even the same information, she wants to know when, where, what page, what, she needs to know so much more information, and they're talking about the exact same thing. It's pretty blatant, in my humble opinion, that Brennan and Bev are on the same page with this whole situation, and that's really terrifying.
I just don't know. This is actually disheartening that 2 years into a trial, we are still going with the same BS. And yeah, but we have to follow next week and find out what happens. And I know I had. Sorry,
she still didn't resolve anything. She didn't make any orders.
No, she didn't make any rulings.
My brain's not working because I'm all fired up at this stupid situation.
She didn't make any rulings. She didn't do anything. She just does what she does all the time. I'll see you next week. And
maybe that's the plan. Maybe they're going to just delay this thing so that it gets pushed back past the date and it just goes away and they can save face. Maybe that's what the plan is.
No, because that would make them bigger fools. But if they could have dropped it back then and said, "Well, we clearly still believes, but we don't think that we can get a different result. So we will." I said it when we still had the ability to talk to Belarus. That I still believe this will be dropped at Friday at 5 p.m. And I believed it. Now it seems like
Betero told us we were wrong on that one.
Yeah,
Betero told us that
and
they were just gonna
it
keep
just
coming.
looks like this asshole just wants to get into knife fights with the defense attorneys. He's really taking it too far.
I really like that Elise he's not putting up with this shit. I like that Elise.
He got mad.
Yeah, you could tell he was fuming.
Opposition for the Commonwealth is due tomorrow in the federal court petition. That's going to be interesting to see. No motions were heard today. Nothing ruled from the bench on yet. Well, they can rule on because today was a procedural hearing about what was said. So, is Valhalla selling the heart?
I hadn't planned on it.
Well, he will have an art auction stream, and you can bet on it there.
I should.
You
My
should.
mother-in-law came down into town, and her and my aunt-in-law, I guess, her sister, they like took most of my paintings. They found them. They're like, "Oh, I want that. Can I have that? I want that." It's like, sure. So we're a little low on supply at the moment. Just means me and Diva need to do more art streams.
Yeah, get her lazy behind out of the. But it's because Wallstrom is out of town, so he's not there to kick her into gear and say, "Go paint." He's probably, if he did it, he'll be kicked out of the house.
I need goats in my life. I'm gonna go hang out with goats for a little while.
Yeah, I wish I had some goats. I know I said we were going back to that other case, but I can't do that now. It's 10:30, and I'm angry. I'll just keep yelling. I don't want to do that. So I'm going to send you all over to Recovery Addict, and you can watch the rest of the day with him. Say hey from us. Please put some donuts in his chat, and thank him for being nice enough to send people over yesterday and giving me 300 new subscribers.
Speaking of RA, I'm going to do the same. I'm going to send my chat over there too.
Yeah,
do me a
he's
favor
good
when you
people.
get over there, guys. Me and RA are talking about a Lego stream. So get in his
Oh.
ear and tell him you want to see him on Lego with Valhalla. That'd be awesome. This is the one. Redirect ad.
Do that. Give him donuts from me and give him Lego from Valhalla, and say you will spread Lego in his house if he doesn't agree to a Lego stream.
Put little Caltrips Legos all over his floor.
Yeah, and he would be cool. I had him on for the 12 Creators for Christmas, and he's such a cool guy, and he has a very interesting backstory as well. So
Well,
he would
hopefully
be
I get to
perfect.
find out about it. Yeah.
I bet you would. He's a cool guy, and
He seems up to it. We just haven't finalized anything. Get over there
Yeah.
and
I'll
get in his ear, y'all. Get in his ear.
Yeah, I wish I had cool friends, but I have all of you, and you are my friends. I'm going to go to bed because I'm angry, and I've had a long day in court today, and I had a long day in court. I love Bev saying, "It's been a long day." You started at 11, bitch, and took an hour off for lunch. She had a 3.5 hour work day.
Must be terrible.
I'm going to yell at the mods now and say, it's your fault. And then Marissa's going to yell at me, and then Jamie is going to come back, and then I'm going to cry. Everyone, I'm going to yell in the Discord chat in a bit. So if you want to yell back at me, join the Discord, hang out, yell at me. If you want to see the rest of the Todd Mullis for today. Hang out with Recovery Addict. Remember, Lego with Val, muffins with Baker. See y'all later. Enjoy the rest of your days.
What exhibit are you referring to?
I'm going to make this 100, Your Honor.
All right.
100.
100.
Because it is 100%
100%.
correct.
Objection, Your Honor.
So you literally built a cannon?
Yeah, it's pretty awesome.
All right, I'm in love.
Go back. Please do that again. Oh, that was the cutest thing I've ever seen.
While I'm waiting for this, did you, whether it's true or not, believe that Mr. Randolph had slept with your wife?
I wouldn't have cared.
You wouldn't have cared?
No.
Did you believe he had slept with your wife?
No.
Did you believe he slept with your mother-in-law?
Probably did. Everybody has.
So there-
Everybody has.